We humbly request the gathering to receive honorable dignitaries. We cordially invite our honorable dignitaries to adorn the dais. May we commence the proceedings, my lords?
May we all now rise for Tamil Thai Valthu being presented by our staff members.
நீராறும் கடலுடுத்த நிலமடந்தை கெழிலொழுகும் சீராரும் வதனமென திகழ்வரத கண்டமிதில் தெக்கணமும் அதில் சிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறம் வியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
Light is always a sign of auspicious and divinity. Light drives away darkness of ignorance, then wisdom illuminates the mind. May we request honorable dignitaries on the dais to light the lamp? Thank you, my lords.
Now we invite Honorable Thiru Justice R. Mahadevan, Judge, High Court of Madras, and also Executive Chairman of Tamil Nadu State Legal Services Authority, and also Chairman of Tamil Nadu Mediation and Conciliation Center, to welcome the august gathering. Please, my lord.
Good morning to all of you. It is my pleasure and privilege to extend a warm and cordial welcome to each one of you present in this occasion of the special training on the Mediation Act 2023 and the Conference of District Legal Service Authorities of Tamil Nadu and Puducherry. With great honor and humility, I extend a heartfelt welcome on behalf of all our members to Honorable Justice Sanjeev Khanna, Judge, Supreme Court of India. It is with deep respect and admiration we acknowledge the profound contribution of His Lordship, who with thorough and extensive knowledge in the field of taxation, arbitration, commercial, medical negligence, civil, criminal and company laws, has penned several judgments and has been part of several constitutional benches, including the recent judgment relating to the constitutionality of the electoral bond scheme. Some of the other well-known judgments penned by His Lordship include his majority opinion in Shilpa Sailesh case related to the power to direct grant divorce under Article 142 of the Constitution. In CPIO, Supreme Court versus Subhash case, holding that judicial independence does not necessarily oppose the right to information. In the revising fee scale for arbitrators case, His Lordship has held in his dissenting opinion that in the absence of an arbitral agreement, the arbitral tribunal is entitled to fix a reasonable fee. Several orders passed by Justice Sanjeev Khanna reflect his pioneering efforts as well as faith in the system of resolution of disputes by mediation. Justice Sanjeev Khanna has time and again emphasized the role and importance of the legal service institutions. In addition to his judicial duties, His Lordship, the Honorable Mrs. Justice Sanjeev Khanna, holds the esteemed position of Executive Chairman of the National Legal Services Authority, embodying the spirit of empathy and accessibility in legal aid. Through NALSA, he ensures that justice reaches every corner, especially those in need. Moreover, as the chairman of the Mediation and Conciliation Project Committee, Justice Sanjeev Khanna puts all efforts to promote peaceful resolution methods, fostering harmony and understanding in our legal processes. We are honored by His Lordship's presence here today. I extend my heartfelt welcome to the Honorable Thiru Justice Sanjay V. Gangapurwala, Chief Justice Madras High Court, Patron in Chief, TNSLSA and TNMCC, who is instrumental for this event. I also extend my heartfelt welcome to the Honorable Mr. Justice D. Krishna Kumar, Executive Chairman, Puducherry Legal Services Authority, Honorable Justice S. S. Sundar, Chairman, High Court Legal Services Committee, all the Honorable Committee members, and the Honorable Brother and Sister Judges for gracing this occasion with their presence. The day's agenda promises to be enriching and insightful with eminent speakers, sharing their expertise on various aspects of the Mediation Act 2023. I welcome Mr. Sriram Panju, Senior Advocate and Master Trainer, P.H. Arvind Pandian, Senior Advocate, Mrs. Uma Ramanathan, A.J. Jawad, Ms. Geeta Ramaseshan, and Mr. S. Arunachalam, Senior Trainers, and other mediators and trainers. I also welcome the Principal District Judges and the Chief Judicial Magistrates of Tamil Nadu, who are present here for making this symposium in a grand success. This training program is designed for mediators to equip with the necessary knowledge and skills. Your commitment to the principles of mediation will successfully implement the Mediation Act 2023. Once again, I extend warm welcome to all. Thank you.
Thank you, Lordship.
Now it's time for honoring the dignitaries on the dais.
We cordially invite Honorable Thiru Justice Sanjay V. Gangapurwala, Chief Justice, Madras High Court, to honor Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India, with a memento.
We cordially invite Honorable Thiru Justice R. Mahadevan, Judge, Madras High Court, to honor our Honorable Chief Justice with a memento.
We cordially invite respected Registrar General Thiru M. Jyotiraman to honor our Honorable Thiru Justice R. Mahadevan, Judge, High Court of Madras, with a memento.
We cordially invite respected Member Secretary of Tamil Nadu State Legal Services Authority, Thiru A. Nasir Ahmed, to honor Honorable Justice Thiru D. Krishnakumar, Judge, Madras High Court, with a memento.
We cordially invite respected Registrar Judicial Mr. J. Selvanathan to honor our Honorable Thiru Justice S. S. Sundar, Judge, High Court of Madras, with a memento. Distinguished members of legal fraternity, it is with profound reverence and admiration we extend a heartfelt invitation to our eminent Chief Justice. May we request Honorable Thiru Justice Sanjay V. Gangapurwala, Chief Justice, High Court of Madras, Patron in Chief of Tamil Nadu State Legal Services Authority and Tamil Nadu Mediation and Conciliation Center to deliver the prestigious presidential address. Welcome, my Lord.
Honorable Justice Sanjeev Khanna, Judge Supreme Court of India, and Executive Chairman National Legal Services Authority, and the Chairman Mediation and Conciliation Project Committee, Supreme Court. Brother Justice Mahadevan, Executive Chairman, Tamil Nadu Legal Services Authority and Tamil Nadu Mediation and Conciliation Center. Brother Justice Krishna Kumar, Executive Chairman, Union Territory of Puducherry Legal Services Authority. Brother Justice S.S. Sundar, Chairman, High Court Legal Services Authority. My esteemed sister and brother judges, senior advocates, mediators, the members of my judicial fraternity, members of the bar, ladies and gentlemen, Kala Ivanakam. It is with great honor and privilege that I stand before this august gathering on the conference of the District Legal Services Authorities of Tamil Nadu and Puducherry and the special training on the Mediation Act 2023. The same is held under the aegis of the Tamil Nadu and Puducherry Legal Services Authority and the Tamil Nadu Mediation and Conciliation Center of Madras High Court. I profoundly thank Honorable Justice Sanjeev Khanna for carving out His Lordship's precious time to be with us today at the Madras High Court for this function. Today's program encapsulates the concurrent sessions of two events. One, the conference of the District Legal Services Authorities of Tamil Nadu and Puducherry, and second, the special training on the Mediation Act 2023. The state legal services authorities in the state of Tamil Nadu and the Union Territory of Puducherry, in pursuit of carrying forward the object of the legal aid and legal literacy, awareness under the aegis of NALSA, has so far implemented as many as 19 schemes, like legal aid camps, legal literacy camps, pre-litigation lok adalats, national lok adalats, legal aid to prisoners, prisoners rehabilitation programs, and so on. The state legal services authorities has so far established 846 legal services clinics, 212 legal aid training programs with 4,938 participants in the last National Lok Adalat held in 1863. 1863 benches were constituted which disposed of 3,55,762 cases, turning out a total award amount of 2,652.43 crores. During the period from January 23 to February 24, 51,824 legal aid applications were received, of which 48,352 applications were disposed of. The latest scheme of legal aid defense counsel system formulated by NALSA needs a special mention. The National Legal Services Authority has chosen the state of Tamil Nadu as one of the 17 states for implementation of LADCs as a pilot project. The LADCs has been successfully implemented in 30 districts out of 32 districts in the state of Tamil Nadu, with a panel of 29 Chief Legal Aid Defense Counsel, 42 Deputy Legal Aid Defense Counsel, and 67 Assistant Defense Counsel. In the words of Joseph Gambam, an ounce of mediation is worth pound of arbitration and tons of litigation. This phrase imbibes in itself the importance of mediation. I would like to apprise the Honorable Lordship that the first mediation center in the country was established in the High Court of Madras in the year 2004. And the room where the first arbitration center was established and the first mediation center was established and the mediation was undertaken, that room we have preserved as a souvenir. The seeds of mediation here were sowed by the senior mediators like Shri Shriram Panchu, the senior advocate, who was also the mediator appointed by the Supreme Court in Ayodhya Babri Masjid dispute. The mediation has grown by leaps and bounds here. We are successfully performing the mediations. We have inaugurated about 32 mediation centers on the last occasion, and 17 more centers are in the offing to be inaugurated. Now, this Mediation Act 2023 is a virgin subject. This program, this training program is meant for all the learned mediators to apprise themselves with the nuances of the new Mediation Act 2023. The mediation is here to stay. All the new acts which are being enacted contain compulsory mediation clause. So it is necessary that we all get ourselves apprised with the nuances of the new act, and the learned senior mediators are there to guide us all. I wish this workshop, this seminar, a grand success. Thank you everybody.
Thank you, my lord.
With great honor and privilege, we request Honorable Thiru Justice Sanjeev Khanna, Judge, Supreme Court of India, Executive Chairman, National Legal Services Authority, Chairman, Mediation and Conciliation Project Committee, to present the inaugural address. Welcome, my lord.
Mr. Justice Sanjay V. Gangapuwala, the Chief Justice, Madras High Court, Mr. Justice R. Mahadevan, Mr. Justice D. Krishna Kumar, Mr. Justice S.S. Sundar, sister and brother judges of the Madras High Court, senior and advocates from the Madras High Court, learned mediators, members of the district judiciary, members of our family. Good morning and namaste. My first introduction to mediation was after my elevation as a judge of the Delhi High Court in 2005. It was September 2005, I distinctly remember. We had gone to the law faculty, Delhi University, and there a number of lawyers raised a protest. They said, we'll burn down any attempt, we'll close the courts, we'll not permit anybody to initiate mediation. We took the first baby steps then with a lot of some reluctance from the bar, but we also realized that without acceptance by the bar, mediation will not be successful. Since then, the situation has changed completely. We have Samadhan, which is there in the High Court, which is the mediation center completely run by the advocates. It's been very successful with mediation success rate of about 48%. But one thing which I was very happy to know coming over here, that Madras was the High Court was the first, had set up the first mediation center in the country in 2004. So in a way, Madras High Court is the birthplace of mediation, modern mediation as we have, and we have established today in the country. I also, when we were inducted and told about mediation, I said, we don't require any skill sets for this. We all are trained mediators, inborn mediators. But when I went through the courses and I understood the nuances of the modern mediation, I realized the skill sets are absolutely different. The lawyers are argumentative, we are judgmental and decision-making oriented. You are far more facilitators and conciliators in a way. Just out of curiosity, today in the morning, I just went through the internet and I said, let me check out what are the skill sets required for a mediator. And when I went through them, they listed 8 of them. Another website listed 19 of them. I realized it's a tough call. I will not probably qualify in many. Patience, communication skills, listening and speaking, analytical ability, problem-solving ability, empathy, assertiveness, neutrality, and confidentiality. A mediator has to have a legal brain with ability of a psychologist, counseling skills, who can understand the root cause. He has to be a good listener, at the same time have convincing power. This makes it a very complex, very difficult subject. One does not realize how difficult it is until unless one goes into the depth and details. But then the issue arises, why should be mediation? We are all aware of it. My personal take on it is that mediation is the best form of dispute resolution, provided both sides are equal, have equal bargaining power, are situated in the equal. We have to equate them, ensure that they are not treated or discriminated because of the unequal bargaining power, which forces them to a settlement. Secondly, I'll quote the words of Mahatma Gandhi, and I think there's a lot of merit in those words. We probably, being adjudicators, lawyers, argumentative minds, we often overlook that. And that's a problem also with arbitration. Truly a person is indurate and acts cowardly when he resorts to court of law. Surely a decision of a third party is not always right. We, in our simplicity, imagine a stranger, by taking our money, gives us justice. The third aspect which is all known to us is the dockets we have in the court. And that is a problem which we all face. As per the figures which are available to us, there are about 2.37 crore cases pending in the district courts, 20.67 cases pending in the high courts, and 52,660 cases pending before the Supreme Court. We give the details with regard to per judge pendency also. It's impossible for anybody to deal with so many cases. These are the intake every year in 2023 of civil litigation. I have not included the criminal litigation for the simple reason that criminal cases normally don't go to mediation except a small part of it. We don't have data with regard to how much time each civil case takes, say in the district courts, the High Court or the Supreme Court. But there is a study by the World Bank which says enforcement of contracts in India takes about 1,445 days. and costs about 31% of the claim. These are worrisome figures. These are not good figures, especially when we compare to even South Asian countries, where it takes about 1,101 days. So we are way behind even our brothers in the South Asia. When we go down to OECD countries, the average time taken for dealing with civil contractual disputes or settling civil contracts is about 590 days. So we take almost 4 times or 3 times more than what it takes in OECD. This apart, what happens is there is a cost in between. Delay means costs. There is a cost. That's why I said it takes 31% of the costs. Why is there so much delay in the courts? Why is it happening? Is a cause which we have to study and understand, and everybody, all of us have to apply their minds. Then I went across some figures with regard to mediation settlements which take place across the board. And the figures are again very alarmingly different from, very significantly different from what we have in India. In the United States, about 66% of the commercial cases under the American Arbitration Association are concluded in settlements. Financial Industry Regulatory Authority in US has impressive 83% settlement rate, 57% by direct negotiation, and 12% by mediator-assisted resolutions. In United Kingdom, the commercial mediation has grown to about 12,000 cases annually, 20% increase since 2016. Data again from Mediation Center in Singapore has resulted in 84% participants saving costs and more than 88% experiencing respite from undue delays. I had spoken to the Chief Justice of Singapore, and he said that mediation is the way forward. Mediation is picked up in a big way, and they're promoting mediation as a way and mechanism to solve the problem. When we look at the Indian figures, we often overlook Lok Adalats. I think Lok Adalats is a way of mediation with inbuilt probably more akin to conciliation rather than mediation. But just look at these figures. 6 crores in 2023, up from 1.27 crores in 2021. This shows mediation can work. Why I referred to the Lok Adalats was this shows mediation can work in India. I have been touring around as the family head of NALSA, some states, and I have visited villages. And what I found was each and every villager knows about Lok Adalat. And his face lights up when we speak about Lok Adalat. He has confidence in Lok Adalat. It's been resolving and solving his problems, day-to-day problems. The figures in Lok Adalat are very good. So that means we have the culture, we have the mindset to go for mediation as a mechanism to resolve disputes. These are the figures with regard to the state Lok Adalats, again very impressive. The first were the figures of the National Lok Adalat. These earlier figures also deal with pre-interest or pre-litigation matters which were settled. Just imagine if a trickle of these cases which were settled in the state and the National Lok Adalat had come to the courts, what would have been the situation? It would have led to a chaos. We would have probably not been able to deal with it. My experience in Delhi showed the most difficult court to handle was the Challan court, the traffic Challan court. I couldn't understand because we were posting the junior most judges over there, the new entrants over there. When I went through the reasons, I was quite alarmed. I realized there's a gap between what we as judges understand with regard to traffic challans and the impact thereof, and what actually was happening on the ground level. Most of the persons being challaned were small-time, self-employed operators. The vehicles were impounded. They were deprived of their earnings for 2 to 3 days, which had the impact. They were not able to pay the EMIs. They were not able to pay whoever was employed with them. The person whose cargo they were carrying would be up in arms. Therefore, he'll come to the court and fight for even a day, because nobody will realize what was going behind him. And then I realized that this all can be sorted out by mediation, because mediators, we are able to directly interact with them and understand what is the cause of the problem, we were able to then sensitize the judges and deal with it. I've given the figures for permanent Lok Adalat, which I feel is most akin to mediation, and we have to promote this. But there is a drop in the figures in 2023. I don't know the cause. I'll probably now go into it, and I request all the our state legal services authorities to also examine what is the cause for the drop. But nevertheless, the figures are very good. This is the total number of cases which have been referred to mediation. About 35 lakhs or 36 lakhs cases were referred to mediation, specifically to mediation. And about 10 or 11 lakh cases have been settled, which is fairly good. I feel the figures are fairly good. But if we take it numerically, but if you take them as a percentage of matters pending in the courts, or percentage of matters which are being filed in the court, it's a little disturbing. It's not so healthy. It doesn't look very healthy. This is a very interesting figure. This is with regard to the compulsory mediation in commercial courts. This is from 2019 to 2023. Initially, about 18,000 matters were referred. Today, about 52,000 matters were referred. The cases settled is the interesting figure. Figures are not very good, but the healthy sign is from 2019-20, where 167 settlements took place, we have now jumped to 7,431. In terms of increase, is very, very substantial. This is the figure with regard to the trained mediators we have is about 12,000 mediators. This gives the figure with regard to the mediation center and area centers we have. These are the figures specific to Tamil Nadu. Can we move ahead? Yes, these are figures specific to Tamil Nadu. Again, I feel the figures can go up, keeping with the pendency we have. And I can go on and on, but now I want to talk about something which we are now developing, wanting to develop. Can we come to slide number 23? I'm skipping some because I have another meeting with the DLSAs. I want to spend some time with them, the member secretaries of the district. We are coming out with a pilot project to ensure that mediation training is available to all sitting at your home at flexible hours. So this is going to be a 40-hour mediation training course, which will be available online, which will be in form of, I'll give some details. This gives flexibility of time for the participants, simple methodology, increased diversity to ensure that mediators don't belong to all sections of the society who can help us to initiate community-based mediation. Our intent is to take mediation at the community level, in addition to commercial, family, and other matters. We have shortlisted these categories who will be entitled to enroll themselves and participate in this course. We have divided the 40-hour course into orientation, which will be for about 2.5 hours, which will be online and interactive or physical. Then technical session phase 1. Each session, which is going to be of 15 hours, pre-recorded sessions will be there. You can join the session, and whenever you leave, you can start off from the same point where you left. So you go from one capsule to the other capsule. There'll be 15 such capsules or 10 such capsules, and you'll be able to go from one capsule to the other capsule, so on and so forth. Then halfway, there'll be again a practical session of 3.5 hours, and debriefing which includes debriefing of 1 hour. Then we go to the second phase of technical sessions, again pre-recorded 10 sessions of 1.5 hours each. And then in the end, practical sessions of 2.5 hours, debriefing 1 hour, and learning outcome half an hour. During each session, there'll be certain questions and papers which you'll have to fill up. And accordingly, we'll make the assessment whether you've understood, whether the participant has understood the nuances of mediation, and move forward. And wherever there's a problem, we'll get back to that candidate and request them to please undergo the session once again. These are the topics which we have selected. And I'm very happy to say there was initially some reluctance, as it always happens when a new scheme is introduced. But I'm very happy to say I've got very, very positive response. Almost everybody whom we contacted have agreed. I will request any of you, including Mr. Panchu, if you have any suggestions to make, all the mediators who have any suggestions to make, please do write to us. We'll try and incorporate it. This is a new step we are taking, so there will be glitches, there will be some obstacles, but let's try and do it. So what the significant points are, you enroll yourself by paying a small fee, maybe 200 or 500 rupees, depending, in some categories may be free. In your time, whenever you want to, we'll be having, for the practical or the interactive sessions, 2 or 3 days fixed in a week when you can interact, join in. And then at your own convenience, at your home, you can go through the technical sessions of 15 hours, and then again 15 hours, 10 of each of them. Prepare yourself, answer the questions, get the feedback from us, where you have gone wrong, or where you have accepted or adapted and done well. And in the end, we will give you a certificate. After this is stabilized, or before that, we are also intending to introduce a similar course or similar for 10 hours each for the PLVs and others, panchayat members and others. This has to be, because then they'll be able to, they are doing mediation but in a very different way. Probably they don't even know about their biases and prejudices, and how sometimes they force upon results which may not be fair, but according to them are fair, because because they belong to that community. They can't differentiate between their, you're blind to your own faults, so you are not able to do that. Thank you so much. I wish this session a success, because enhancing and upgrading skills is something which is very important for the mediators. Mediation in times to come is going to be a profession, probably which will command a lot of respect, and the way forward. I don't see any other way we can solve. Arbitration is certainly not the way forward. Court litigation is not the way forward. Court litigation and arbitration should be the second, not the default. Thank you.
Thank you, my lord.
As a token of appreciation, we request respective Registrar of Administration, Mr. B. Hari, to present saplings to the staff members, Mrs. Lavanya, Mrs. Esther, and Ms. Rupa, who vocalized Tamil Thai Valdu.
As we draw near the conclusion of this inaugural session, we request Honorable Thiru Justice D. Krishnakumar, Judge, Madras High Court, Executive Chairman, Union Territory of Puducherry Legal Services Authority to propose vote of thanks.
I am deeply honored and privileged to extend a vote of thanks as a chairman of Union Territory of Puducherry Legal Service Authority, as well as on behalf of the Tamil Nadu District Legal Service Authority on this momentous occasion. It fills me with immense gratitude to extend my heartfelt thanks to Honorable Justice Sanjay Khanna, esteemed judge of the Supreme Court of India and Executive Chairman of the National Legal Services Authority, NALSA, as well as Chairperson of Mediation and Conciliation Project Committee. We are deeply honored by his gracious acceptance of our invitation to participate on this conference, despite his tight schedule. His Lordship has shown active involvement and invaluable contribution towards legal service authority as well as to the mediation centers. I express my heartfelt appreciation to our Executive Chairman of NALSA and Chairman of MCPC for delivering a valuable speech and offering insightful suggestions for the effective functioning of the mediation and legal service authority. We are truly privileged to have benefited by his presence and insight at this conference. I extend my sincere gratitude to our esteemed Chief Justice, Mr. Sanjay V. Gangapurwala, who serves as the Patent Chief of Tamil Nadu State Legal Service Authority and Tamil Nadu Mediation and Conciliation Center. It is a testament to his outstanding qualities of our Chief Justice, readily accepted our invitation to preside over this conference. Once again, I extend my sincere thanks to our Honorable Chief Justice for his invaluable contribution and support to the members of the committee for organizing this grand function. I would like to extend special appreciation to my brother Justice Mahadevan, Executive Chairman of the Tamil Nadu State Legal Service Authority and Chairman of the Tamil Nadu Mediation Conciliation Center, for his tireless dedication and in organizing this event and ensuring its seamless execution. His exemplary efforts have played a pivotal role in success of this conference, and we are truly grateful for his invaluable contribution. I would also thank to my brother Justice Sundar, Chairman of High Court Legal Service Authority, for his valuable contribution towards the success of this conference. I also thank my brother and sister judges of this Madras Principal Bench of this Madras Bench as well as Madurai Bench for participating in this august gathering. I thank all the committee members of Tamil Nadu State Legal Service Authority, Tamil Nadu Mediation and Conciliation Center, Union Territory of Puducherry Legal Service Authority, and High Court Legal Service Authority for their valuable assistance in executing this conference and special training programs successfully. I thank all the registrars, member secretaries of High Court, chairman and secretaries of Legal Service Authority of Tamil Nadu and Puducherry, and district legal service in the respective districts, directors and staff members of mediation centers attached to High Court and all the districts, mediators for their active participation in this conference. I also express my sincere thanks to Learned Advocate General, Additional Solicitor General of India, senior advocates, and all other officers, advocates who are gathered on this conference. Last but not the least, I thank the office bearers and members of the Bar Council of the India, as well as the members of the office bearers of the bar associations, press, print and visual and media, and have gathered here in this conference. I once again express my heartfelt thanks to all the dignitaries participated and organizers for their contribution and presence which have made this conference resounding a success. I thank you very much for one and all.
Thank you, my lord. We invite the honorable dignitaries to have high tea arranged in the first floor. Participants are requested to be seated.
We request the chairman and secretaries of district legal services authorities to kindly gather at ADR building of third floor to take part in the conference of district legal services authority of Tamil Nadu and Puducherry. Tea is arranged in the ADR building for the chairman and secretaries of DLS.
For other participants, tea has been arranged in the ground floor. We request the trained mediators to come back to this auditorium to attend special training on the Mediation Act 2023. Session will start at 10:45 a.m. sharp. This is a time-bound program. I request the mediators to stick on to the timing.
Tiskulla. Tis. Check tis.
We humbly request the participants to get settled at the earliest. It's getting late. We kindly request everyone to come to the front seats. I request participants to take their seats. Water bottle will reach to your seats. I humbly remind you all, this is a time-bound session. Please be settled.
Welcome back to have an enthralling session with erudite resource persons on the Mediation Act of 2023.
Before elevation to the higher judiciary, Honorable Thiru Justice D. Bharata Chakravarti was an accredited mediator and successfully mediated more than 400 cases before Honorable High Court. It is very true that His Lordship is the right person to commence this session on mediation. With wealth of experience and profound dedication to the cause of justice, we request Honorable Justice to present an overview of the Mediation Act 2023. Welcome, Lordship.
சமரச அறத்தினோர் அனைவருக்கும் எனது பணிவான வணக்கங்கள். Before I go to the topic, நம்ம தமிழ்நாடு முழுவதும் இருந்து அனைவரையும் ஒரே இடத்தில் பார்ப்பதை விட பெரும் மகிழ்ச்சி எதுவும் இல்லை. So happy to see you all in the same hall. Very nice to meet you all, and it is my pleasure to stand before you today. So the day's training is about the new Mediation Act, and my job is to give you the overview so that they are going to take it segment wise through the day. All right? So what is the purpose of today? We are going to showcase the Mediation Act 2023. உங்க எல்லாருக்கும் தெரியும், the new act has come into force. So hitherto we were having what was the legal framework in which the mediation system was working. As far as the civil cases are concerned, Section 89 we referred the cases, and after settlement, Order 23, Rule 3 we recorded the settlements, and therefore the settlements were executable as if the compromise decree passed by the court. This was the legal framework for the civil cases. As far as the criminal cases are concerned, all compoundable cases, principles under Section 320 of the Code of Criminal Procedure Code. Non-compoundable cases, the judgment of the Supreme Court in Gyan Singh and others, were family matters, were civil matters, are mediatable, but however, the High Court will quash in exercise of powers under 482. And as far as pre-litigation mediation is concerned, as far as commercial cases, Section 12A of the Commercial Courts Act, and the other cases are concerned under the Arbitration and Conciliation Act. That is what the legal framework, இதுதான் இன்றைய தேதியில் இருக்கிற legal framework. So 89ல ரெஃபர் பண்ணுறோம், ஆர்டர் 23 ரூல் 3ல ரெக்கார்ட் பண்ணுறோம். கிரிமினல் கேசஸ்னா following the principles under Section 320 or the non-compoundable cases based on the Supreme Court judgments, we mediate and the High Court quashes those cases. As far as pre-litigation mediation concerned, if it is a commercial under 12A of the Commercial Courts Act, other cases under the Arbitration and Conciliation Act. That is the legal framework which existed till the Mediation Act came into force. Therefore, now they want to introduce a new act. In the புதிய சட்டம் வந்து it is a complete code in itself for everything relating to mediation. Section 55 of the new act gives a overriding effect to that act. Mediation சம்பந்தமாக இந்த ஆக்ட் தான் எல்லா ப்ரொவிஷன்ஸும் எக்ஸப்ட் ஷெட்யூல் 2ல கொடுத்துருக்கக்கூடிய ப்ரொவிஷன்ஸ் தவிர மற்ற all other provisions, the act will have a overriding effect. So hereafter we will be under the four corners of the Mediation Act only. Both civil, criminal or pre-litigation or community mediation, everything should be done only as per the provisions of the act. So the act is a complete code in itself. Section 55 gives a overriding effect, and the new act contains 11 chapters and 67 sections and 10 schedules. That is what it contains. Now what is the status of this act? Act என்ன சொல்லுதுன்னா, the act will come into force from the date on which the central government may notify. The central government has given the following notification. இதில் என்ன பண்ணியிருக்காங்கன்னா, now the act is notified. Section 1, Section 3, Section 26, Section 31 to 38, 45 to 47, 50 to 54, 56 to 57 are notified. Rest of the sections we are expecting it to be notified very shortly. அது ஏன் அந்த மாதிரி பண்றாங்கன்னா, these are the procedural provisions. So Section 1 makes the act to come into force. Section 3 are the definition sections. Then Section 26, 31, 36 law to enable the central government to notify the mediation council. The governing bodies law first they want to create and then notify the other substantial provisions so that the act can be given into effect. So as on date, the act has come into force, but not all the provisions. The Section 1, 3, 26, 31, 32, 56 to 57. So until all the provisions come into force, the Act itself makes it very clear that the erstwhile rules framed by the High Court will be governing the mediation. So as on date, now we are governed by the mediation only, but very shortly we will be governed by the Act. All right. So what does this Act, in the Act, what does the Act aims at? This Act aims to promote and facilitate mediation, especially institutional mediation, for resolution of disputes, commercial or otherwise, enforce mediated settlement agreements, provide for a body of registration of mediators, to encourage community mediation, and to make online mediation as acceptable and cost-effective process, and for matters connected therewith or incidental thereto. Therefore, as I said, it completely wants to regulate all aspects of mediation. All right? So just to give you an overview, now what this Act does is, firstly the application and definitions. Section 2, therefore, now I will give you the overview and then the experts will take you in respect of each and every segment of it, so that we all have a rough idea of what this Act is about when we end this program in the evening. So what the Act does is, it gives the application and definitions. The application is given under section 2. There are 5 circumstances where the Act would apply. Madam Uma Ramanathan will take you in detail through that. And then there is section 3, which contains all the definitions, such as what is mediation, what is who is a mediator, what is international mediation, what is court annexed mediation, what is community mediation, etc. We have provided you, all of you are provided the Act in the kit. So whoever wants, you can take it and refer it to that. So application is contained in section 2 and the definitions are contained in section 3. All right? Then the most important purpose of the Act is when mediation. Eppola mediation panla. Abdin the Act clearly gives the framework. Okay? When mediation, and chapter 3 governs by it. Chapter 3 is essentially when mediation can be done. Firstly, section 4 to 7. Section 4 says mediation agreement, that is the parties have an agreement among themselves to mediate. It can be a separate agreement or it can be a clause in their respective commercial agreement. I supply a goods to you, therefore 1 lakh rupees. If there is any dispute, the parties will settle by way of mediation. So now that is called as the mediation agreement. Okay? So now the Act gives 2 different terminologies. Number இவ்வளோ நாளாக வந்து போட்டிருக்கக்கூடிய settlement or the final settlement இருக்கு இல்லையா parties-ஓட terms of compromise, that is termed as mediation settlement agreement or MSA. Hereafter we will call it as mediation settlement agreement. Whereas the initial agreement இருக்குங்க இல்லையா நம்ம mediate பண்ணலான்ற agreement இருக்கு பாருங்க, that is called as mediation agreement. Though that is very important. Therefore, when mediation can be done now, when there is a mediation agreement, then section 5 says pre-litigation mediation. It makes it optional, compulsory panla. Commercial cases under the Commercial Courts Act, it is compulsory. For other cases, it is only optional of the parties. So it is section 5 deals with the pre-litigation mediation. Then section 6 is important. What are all the cases which are suitable and not suitable? Section 6 delineates. And the details are given in the Schedule 1. எந்தெந்த வழக்குகள்லாம் மீடியேஷனுக்கு அனுப்பப்படலாம், எந்தெந்த வழக்குகள்லாம் மீடியேஷனுக்கு அனுப்பப்படக்கூடாதுன்றது செக்ஷன் 6ல இருக்கு. Then section 7 again says that pre-litigation ஏற்கனவே அவங்க பண்ணியிருந்தாலும், if it is failed and thereafter it comes to court, we can again refer it to mediation. So that is the effect of chapter 3. Chapter 3 says when mediation can be done. Then, all right, one second. Then, next chapter, mediators, who can be mediators? Act says that persons who are agreed, whom the parties agree. They can be of any nationality provided the parties agree. That's the only qualification which is now imposed. And then it says that they should not have any interest in the subject matter. And then that is sections 8 to 12 is regarding the mediators. So section 8 says who can be the mediator. Then section 9 is regarding the panel of mediators with the mediation service providers. So the Act also recognizes the private institutions who can be mediation service providers. So section 9 recognizes those who are in their panel. Section 10 says about conflict of interest. So this is akin to our rules only. So if we have some conflict of interest as to the subject matter, the mediator is supposed to disclose and he cannot act as a mediator in that. And then section 10 is termination of the mandate. Parties can terminate the mandate. Mediator also can recuse himself. And then section 12 is about replacement of the mediator. So therefore this Act also delineates who can mediate, mediators who. Then the next chapter is important. Chapter 3 is how mediation can be done. So எப்போ mediation பண்ணலாம், யார் mediation பண்ணலாம். Then the next chapter is how the mediation has to be done. That is akin to our mediation rules only. So far whatever our rules is there, it is the same procedure. Confidentiality, voluntariness, self-determination, all that is there. So section 13 to 25 of the Act deals with the procedure. Mediation எப்படி நம்ம பண்ண போறோம் அப்படின்ற procedure section that is chapter 3 delineates. Section 14 says commencement of mediation. Section 15 is how you conduct the mediation. Section 16 is role of the mediator. Then section 17 is that once a person mediates, there is a bar for him to be the arbitrator. Then section 18 is the time limit. Now the time limit they are prescribing is 120 days, another 60 days extendable. That is the maximum period of 6 months. 4 plus 2 months that section 18 time provides. Then section 19 talks about the mediation service providers. Those are the private mediation centers. Then section 20 talks about the registration of the settlement agreement, where the mediation is entered into in a pre-litigation mediation or a non-court annexed mediation center. Those mediation agreement can be presented to the mediation council. It will be registered and it will be given a number, so that it will be easier for the parties to file directly execution petitions based on the mediated agreement and proceed or realize the matter in case they don't get the, if the parties don't obey. So that is the, and then finally section 22 talks about confidentiality. 23 is mediators not to be called as witnesses. So mediators or any person connected therewith or the mediation papers cannot be called for by the court. Then section 24 is termination of mediation, and 25 deals with the cause of mediation. So entire chapter 3 deals with the procedure, how do we go about the mediation. Therefore that is akin to our earlier, the existing rules only. Most of it is similar to our rule. Then comes the most important thing, mediated settlement agreements. That is where now we are going in a different direction. Now section 27 says that the mediated settlement agreements are enforceable as if it were a decree of the principal civil court, like arbitration decree madri, like the Lok Adalat award madri. It need not come back to the court once again for passing a decree. It is deemed to be a decree of the concerned principal civil court itself, and it makes it enforceable. That is section 27. So this is what the court annex mediation center, we are going to look at a new procedure now. So that is one thing. Then section 28 is challenge to the mediated settlement agreement. Challenge is also filing an application before the concerned court on the same grounds as if it is a compromise decree. Enna grounds of challenge irko, it is by fraud, vitiated by fraud, or somebody has misrepresented yourself and other things. Those grounds are there. Additionally, the ground of corruption is also added. I don't know, all right. So therefore, the ground of corruption is also added to set aside the mediated settlement agreement. Then section 29 of the Act extends the period of limitation. For whatever purpose in a pre-litigation mediation, if the parties are there in pre-litigation mediation for a period of 6 months, their limitation is extended. That is section 29. Then next is online mediation. So, Act specifically recognizes online mediation and its effect. That is chapter 7 in section 30. Then comes chapter 8 regarding mediation council, its powers and functions. Therefore, like bar council, there is going to be a mediation council. Its powers and functions primarily are the central government will constitute the council. Then the composition of council is given under section 32. Then section 38 is very important, which lays down the duties of the mediation council. They are going to lay down the standards for the mediators, the procedure. They can even frame the procedure for conduct of pre-litigation mediation, etc. Then the ethical standards, trainings, empanelment, everything now goes to the mediation council. So that is how they are, and they can also monitor reporting, periodical maintenance of the data, everything they will do. That is chapter 8. Then chapter 9 deals with the mediation service providers. Okay? So the Act also recognizes private persons to be mediation service providers. Now we have any number of arbitration centers, private arbitration centers, we all know. Like that, the Act also contemplates that in future there can be private mediation centers also who can be a registered service provider with the mediation council. They will have a regular panel of mediators who will mediate, and settlements can be registered before the council so that it can be enforced. So this chapter 9 deals with the mediation service providers. Alright? Then next is chapter 10 is the community mediation. Wherever there is likelihood of breach of peace or neighborhood disputes, such as we call it as kitchen garden disputes. Unga veetu kuppaiya en veetla potan, or some border this thing, compound gate indha pakkam varudhu. Unga veetu dog is doing nuisance in my dog. This we call it as kitchen garden disputes normally. Small disputes between neighbors, or at the same time where there can be breach of peace. The entire concept of this peace committee meetings by the RDO, if you see that chapter 10, it takes into in its fold wherever there can be breach of peace. That is what I used to say. I hail from a village, therefore I know every location of a ration shop, every location of a bus stop, every location of a school where it should be in this street or in this street, there is a huge conflict in the villages. For every location, lot of peace committee meetings are conducted every day. That is, I think the chapter on community mediation takes into fold that those community mediators can be empaneled even by the district magistrate, those RDOs. So the Act gives a comprehensive provisions regarding that, who can be community mediators, in what kind of disputes community mediation can be done. That is for the first time recognized in the statutes. And then the next chapter 11 contains all the miscellaneous provisions. Miscellaneous provisions, funding, mediate, there will be a fund, it has to be administered, it has to be audited and account. And the powers of the central government. Central government has given 5 powers. It can give directions for the purpose of enforcement of the Act. It can frame schemes for settlement of its own disputes. And then it can frame rules under the Act. Then it can give, it can nominate the authorities who can consent for settlement in case of a government dispute. And then finally, the removal of difficulties, it can frame, it can issue directions. Similarly, state government is also given power to frame schemes for settlement, and also empower the officer to give consent to enter into an agreement. So these are the powers are given to the state government. And the mediation council is empowered to frame regulations. And then section 57 says that until regulations are framed, the High Court rules which are in force today will apply until that time. And then finally section 58 to 65 are the amendments to the various other acts. The Act also amends the various other acts, and then which is contained in schedule number 2 to 10. Schedule 1 is cases suitable and not suitable for mediation. Schedule 2 to 10 are the amendments to the various other acts. So for example, schedule uh, Schedule 2 contains the name of the acts which will not have a, to which the act will not have an overriding effect. For example, the labor law is left out of the mediation, this thing. The Industrial Disputes Act, etc., remains untouched. Therefore, those conciliation will take place as per the Industrial Disputes Act only. So, those of the enactment which are mentioned in Schedule 2 are not overridden by this act under section 55. Then section 3 to 10 are the other amendments. We have got now the new section 89. All along we have been saying that section 89 is not worded properly. Now they have beautifully worded it, or it has been drafted appropriately as per the Afghan's judgment and considering our past experiences. Then Schedule 4 amends, gives us a new section 89. Schedule 3 gives us the amend section 28 of the Contract Act, whereby even if the agreement is held to be void, the clause relating to mediation and arbitration are saved, so that they can, already the judgment of the Supreme Court is there. Now the act specifically enforces that. Similarly, Legal Services Authority, then the Arbitration and Conciliation Act, the entire chapter relating to 6381 is removed, and only new section 61 and 62 is put in place, which again says that pre-litigation mediation will be as per the Mediation Act. So that is what is done. Then the MSME Act, where they can mix up both arbitration and mediation, is now done away with. If they have to separately do the mediation and arbitration. So new section is given. Similarly, Companies Act is amended, and 12A is also amended. 12A of the Commercial Codes Act is also amended. New 12A is also given. So the 10th schedule amends the Consumer Act. So this is the outline for the act for all of you. So like I would like to, so this story we all know. I'll go in Tamil so that I can connect better with you. I have told this story several times. So என்ன மாதிரி ஒருத்தர் ஒரு ரூரல் பேக்ரவுண்ட்லேருந்து ஒரு சென்னைக்கு வராரு ஃபஸ்ட் டைம். அவர் ஒரு சூப்பர் மார்க்கெட்டுக்கு போகிறாரு. He finds this இந்த தெர்மாஸ் ஃப்ளாஸ் கலராக இப்போ அதுவும் மில்டன் அது இதுன்னு வச்சுருக்காங்க. அவருக்கு அது என்னன்னு தெரியும். ஷாப்கீப்பர், வாட் இஸ் திஸ்? அப்போது ஷாப்கீப்பர் சொல்கிறாரு, இது வந்து தெர்மாஸ் ஃப்ளாஸ்க்குங்க. இதில் நீங்கள் எதை சூடாக இதில் வச்சாலும் அது சூடாக வச்சுருக்கோம். நீங்கள் இதை எதை சில்லுன்னு வச்சுருந்தாலும் அது சில்லுன்னு வச்சுருக்கோம். அதுதாங்க இதோட யூஸ்னு. அடடான்னு ஒரு ஆசையாக ஒன்று வாங்கிடுறாரு. வாங்கிட்டு வெளியில் போகிறாரு. பார்த்தாரு ஒரு ஐஸ்கிரீம் ஷாப் வருது. அடடா நம்ம ஒய்ஃப்க்கு ஐஸ்கிரீம் ரொம்ப பிடிக்குமேன்னு சொல்லி கடையில் போயிட்டு ஒரு ஐஸ்கிரீம் ஒன்று இதில் கொடுப்பான்னு சொல்லி ஹீ கெட்ஸ் த ஐஸ்கிரீம். கொஞ்சம் தள்ளி போன உடனே சரவண பவன் வருது. ஹிஸ் ஒய்ஃப் ஆல்சோ லைக்ஸ் ஹாட் ஃபில்டர் காஃபி. இதுதான் சூடாக உள்ளதை சூடாக வச்சுக்குமேன்னு சொல்லிட்டு இதில் ஒரு காஃபி கொடுங்கன்னு சொல்லி அதில் வாங்கிடுறாரு. ஸோ லைக் தட் வாட் ஐ எம் சேயிங் இஸ், today's program will only showcase you the thermos flask. It is for all of you to properly implement. Every section liyum I have also read it. ஒரு section liyum there are difficulties that maybe it is a work in progress. இப்போதான் புது ஆக்ட் வருது. There may be problem for implementation, but you are the honorable presiding officers, you are here, you are my dear mediators, you are there. You know what is the purpose of this act. The purpose of this act is to empathetically resolve the dispute of the conflict. With that view, I request you, all of you, to go through this act, go through this session. Thank you all very much for the patient listening. And now I invite my Guru to take over.
Thank you, my Lord, for a complete overview of the new act with your special inborn quality of humor. His Lordship has explained of the overriding effect of the new act, which is completely a self-governing act. We now request respected Registrar Special Cell, Mr. K. Sitaraman, to honor and present a book and sapling to His Lordship.
You said somebody is going to honor you? Where is the sapling? All right. Good morning. No, one more.
Thank you, sir. Now we have a session from Mr. Sriram Panchu, senior advocate, who is a pioneer in mediation movement in India and was instrumental in establishing India's first court-annexed mediation centers in the Madras High Court in the year 2005. Now, with great pleasure, we request our resource person to take over the session on functioning of the court-annexed mediation centers. Welcome, sir.
Well, the High Court Mediation Center establishment in 2005 is right, but there is another thing which I have done in the recent past which may be of relevance today. I was part of the drafting committee to design this thermos flask. Maybe I shouldn't have mentioned that, because if there's some criticism about the act, it could come very easily towards me. But anyway, let me tell you what was some of our main thrusts. Firstly, the importance of having a standalone act for mediation, because please understand what that means. Instead of mediation being referred to in multiple acts, some contradictory with each other, and given a kind of, step brother or step sister status, it is important for it to be shown as having emerged in full force on the national legal landscape. It was important to have a standalone act, and just the fact that it is an act by itself, providing everything for mediation and being the governing act for mediation, is an important step. Second is the fact that now, over and above an arbitral award, mediation settlement now has by itself the force and status of a decree of court. That's a very powerful thing. The third important thrust in the act is to professionalize mediation, to realize that it must become a full-fledged professional activity like that of any other profession. Doctor, lawyer, chartered accountant, anything. Mediation must become a full-fledged professional activity. Along with that, there is also recognition that yes, we do have court-annexed mediation, and we must have community mediation. So all these must go hand in hand. We debated a lot on pre-litigation. There were demands that, we should have compulsory pre-litigation mediation, but we thought we're not ready for it yet. If we just implement mandatory pre-litigation mediation, there are floods of cases coming to the court. We don't have the capacity of, so many mediators to handle those. So we decided against across the board pre-litigation mediation. But we said we'll make a start in the commercial sector, and the government has given the power to extend it to sectors as and when we are ready. So in time, it will be extended to the matrimonial sector, extended to RERA, extended to consumer cases, as and when each sector gets ready with capacity for pre-litigation mediation. The schedule to the Act lists out exclusion. I think that is first schedule. Lists out exclusion of cases. That is a little too wide, and we had frequent discussions to narrow it down. So we did succeed to some extent to narrowing it down. I still think it's a little too wide and exclusionary, but that is something which, can be remedied in future. There is no mention of this Singapore Convention. The Singapore Convention, provides for enforcement of mediated settlements in commercial matters where parties are from two different countries. It's a useful convention. We have not provided for it here. I think India plans to have its own legislation giving effect to international conventions. And when we do that, I think we can improve on the Singapore Convention. It has its own drawbacks and limitations. For example, it only covers commercial cases. It doesn't cover personal matters. So, inheritance, custody issues, etc., don't come under it. So we might provide for a better version for enforcement of transnational mediations. There is a mediation council provided. I am not so happy because it has too little space for practicing mediators. Only 2 or 3 practicing mediators are going to be on the council. I think it should have a larger representation for mediators like we have in the Bar Council, etc. We have made provision for online mediation. There's a strong provision for that. And I think there is a lot of future in online mediation. Because it gives you tremendous flexibility. It also, makes parties, I think, behave with a little more security and safety because they're operating from their homes. They don't have to sit in the same room with somebody whom they are, maybe, ill-disposed to or have a problem with. And you can schedule it very advantageously. So I think mediation is very well suited to online. I sometimes feel that our court proceedings online is not so great, I don't like it so much because I miss the aura of the court and appearing before a judge, and I enjoy that. But I find that for mediation it works very well. So most of my mediations, in fact, are conducted online. So there is a good future in online. One thing I was very particular about is that we should not have an age barrier for entry to become a mediator. There was discussion saying, the court system, it is 10 years of practice, that should be the bar. I said, no, you cannot have an age barrier for the simple reason, if you have a youngster interested in mediation, and if you tell that youngster that after you pass out from law school, you can't do anything with mediation for 10 years, that person will lose interest. So I said to get them, and they are young, they are idealistic, they are well motivated. We have to permit them to come into the screen, into our mediation fold, right from the time they are through with law school. So fortunately that was heeded. We don't have an age bar. No, there is no entry bar. Now my colleagues will take you, I think, through other aspects of the Act in detail. I just wanted to mention some important ones. But let me focus a few thoughts on improving the court annex scheme. I have seen it from its inception. I have seen it change and evolve and grow. Let me tell you, it is much easier to operate when you have a limited number of mediators. It is not so easy to operate when you have a very large number of mediators in a large number of cases. But there are some fundamentals I want to place, and then I want to actually give the outline of a workable scheme. The fundamentals are this. See, this is the storehouse of cases. It is the courts which handle the bulk of cases in the country, and they are always going to handle the bulk of cases in the country. People trust the judiciary, they want to come to the courts. So we have to be aware of the fact that this is the first line, that the numbers are going to be large. So we have to have, a good number of mediators, provide training for them. And we have to operate the system well. It should be efficiently operated with quality. We can't think that, it's just a court annex scheme, so we can slip up here and have lesser quality there. No, it has to be operated well. Like any other, professional scheme, the quality must be high. Mediators need work. You cannot train somebody and then say we have no cases to assign to you. If you don't have cases to assign, don't train. But once you train and the person is qualified, cases must be assigned. And it is the business of the committee to find the work for the mediators. By talking to other judges, by spreading the word. There are so many jurisdictions in the court which lend themselves to mediation. Arbitration, even, for example, a judge appoints an arbitrator but says, I'm giving 1 month's time, try a mediation. Civil cases, commercial cases, property cases, matrimonial cases, public disputes, criminal matters also certain kinds. There are very few cases which are not amenable to a mediation try. And it's the business of the committee, the job of the committee, I think, to actively work with their fellow judges to see that cases are sent to mediation in large numbers. I will give you another idea for increasing the number of cases. We all know about this word called the backlog of cases. We have a backlog, I don't know how many years, 10 years, 15 years. It's always a source of worry for the court, the backlog of cases. But the same backlog is a treasure trove for mediation. I mean, you have these cases sitting there. They're not being heard. They're not going to be heard. And they are exactly these kind of cases, personal, commercial, property cases, civil cases. All you need to do is to get a team of mediators to sift through those cases, find out which are possible for mediation, have them posted before a judge who refers them to mediation. I cannot think of a situation where a court has a backlog but doesn't send enough cases to mediation. It doesn't make sense to me. So that backlog is a treasure trove. Just sift through it and you will get enough a number of cases to post through mediation. Next, mediators need to be paid well. I'm sorry, but I do not agree with this thinking that because it is court-annexed mediation, we can pay mediators a pittance. No, that's completely wrong. They need to be paid well because they're doing good, important work, and we need to respect that. I also cannot see why this court should pay 4,000 when Delhi pays 20,000. I don't see why. And I think it's high time we, became more realistic and properly paid people for the good work they do. Everybody wants to be paid well for work they do. Mediators too. And let me tell you, you don't have to go begging to government for funds. Government should be happy to pay mediators for a very simple reason. If you take the cost to the state of resolving a matter through litigation, which involves the brick and mortar costs of the courts, the salaries to judges, court staff, etc., etc. And if you compare the cost to the state of resolving a matter through mediation, the latter is a fraction. It's an absolute fraction. So it makes good sense for the state to pay the money for mediation. And there is one more avenue. When we settled the Standard Motors case in 2006, it was an overall claim of 50 crores, and the banks got 30 crores. And the day after the settlement, ceremony took place, and Justice Shah, A.P. Shah, distributed the checks to 2,196 workers and families. I still remember the number. 2,196 workers' families. And then gave the checks worth 30 crores to the banks. Next morning, the bankers came to see me. They were a consortium of 6 banks. And they said, how much do we pay? I said, look, we have no system for payment. So they looked at me as though I was mad. They said, what? You've got us 30 crores. We must pay something. I said, well, we don't have a system of payment. We need a water cooler. Buy us a water cooler. So next day they came with a water cooler and a check for 30 lakhs. And they said, you can't say no, please take this. So we took that and we invested it in the name of in the center, Tamil Nadu Mediation Center. It was the first income for that center. And there are any number of cases. All that we have to do is, where a case has significant stakes and it is settled, just have the matter posted before court and the judge to explain to parties that, look, the mediation center, needs contributions and funds, and you have this big matter which you've settled at great benefit to yourselves in saving a lot of money in litigation. How much are you prepared to give to the center? And many parties will happily give. I mean, in the center, we have settled matters worth crores, 50, 100 crores, some 2, 3, 600, I remember one matter, 600 million in dollars. They will happily pay. They will happily pay because they've got a good service, a good result, and it's a good cause. So we can make our own money but just by this simple method, of getting successful cases with stakes to pay. One thing I've always known, that if you do good work, the good Lord above will always give you the money. There is never a problem. You just have to tap it. And I think in the court system also, we should open the door out for the young. We should have law students coming in as interns. We should have fresh lawyers coming in as part of the system to be mentored, to co-mediate, and to learn how to mediate. We should provide for them. We should knock off this barrier of 10 years of practice. It makes no sense. We are not asking them to be senior advocates, so. And we should imbue ourselves with professionalism. Professionalism means doing the best that you are capable of equipping yourself well, of being up to date with modern trends, of reading, of attending programs, of reflecting on your mediations. In other words, simply being the best you are capable of being. We should all imbibe ourselves with that for us to really stand tall and proud as mediators. I would also say that, the bar should be involved a little more in programs, in the running of the court annex scheme, in the preparation of programs. We used to be very involved when we started. I think that's on a decline. I think the bar should be involved more. So, and it's easy to operate a system of professionalism, and encouragement. I think our rules provide for it, but we never do it. Our Rule 27 says, in all cases, the judge gives the parties the first right of choice of mediator. And that's all the court has to do, tell the parties, this is a fit case of mediation, we'll give you 1 week, choose your mediator and come back. Because when the parties choose their mediator, they are going to have trust in that person. And if they have trust in that person, you are on a winning wicket. Because trust in that mediator is crucial. And if mediators know that parties can choose them, then mediators will take care to equip themselves well, to do a good job, to maintain their reputation. That is the one way in which you can actually, bring about an improvement in standards. And it also respects party choice. After all, it is their dispute. You must give them the first right to choose who resolves their dispute. When they can't, for whatever reason, then you send it to the center. And let the center have, maybe a junior roster and a senior roster. And a lot of cases, make provision for co-mediators. That's very important. Co-mediators so that you can mentor youngsters. Pay well for cases. Do not have this huge distinction between, I find in many centers, successful, unsuccessful, and my blood boils. Because there is nothing like an unsuccessful case. If a mediator has made best efforts and the case hasn't resolved, it is not the problem of the mediator. Parties couldn't resolve it. Maybe the timing wasn't right. Maybe the differences were too sharp. And maybe that case will resolve in the future because of the efforts of this mediator. But to label a case as unsuccessful is, I think, completely wrong. I mean, what is this? If you do your job well, how can you say unsuccessful? I mean, if you're a single judge, if the appellate court, sets aside your judgment, is that an unsuccessful effort on your part? And your salary should be docked for that purpose? So please let us get rid of this unsuccessful terminology. Settled, not yet settled. That's enough. That's enough. If it's a good mediation, it will settle one day. They will come back to mediation. We can, of course, have a system by which we say, we won't pay you just for not settling cases. Settle 5 cases, this is what Justice Call used to do, settle 5 cases. We'll pay you also for 5 cases which you have worked on, at least 3 attempts and not settled. We'll pay you for both, and then close that chapter. It's a very good system. But of course, more cases, many, many more cases should be referred. I've already spoken about the backlog involving youngsters. And I think we should do reviews. Once in a few years, we should review mediators. Are they giving it attention? Are they doing well? Is there scope for improvement? Would somebody like to drop out and allow other people to come in? We should review. But let me tell each one of you that, I found it enormously useful in every mediation I do to sit after the mediation and reflect on it. What did I do right? What didn't I do right? What could I have done better? And I do this in the cases which I have, there's been no agreement, and in cases where there's been an agreement. In both kinds of cases. In other words, in every case. Sit down, reflect. Could I have done something better? Learn for the future. It's a very, very important part of a mediator's life. So these are simple steps. Everything I've spoken about is simple, easy to do. One last thing I want to tell you, and enjoy your work, because mediation is something to be enjoyed. You must enjoy what you're doing. I know that when I litigate, I'm subject to strain. In fact, a few months back, I had a fairly serious medical problem, and the doctor said, no stress. So I said, okay, I won't go to court for 6 months. But I told the doctor, I'm going to mediate. So he said, what is this mediation? What do you do? So I explained to him, and he said, Mr. Panchu, this doesn't look at stress at all for you. It looks as though you're going to enjoy it. Please do it. So in the hospital in Hyderabad, where I was there for 70 days, after 5 hours of therapy every day, I would mediate for an hour and a half in the evenings. So enjoy your mediations, because you're doing good work, you're helping people to make their lives better. Enjoy what you're doing. And I've often said this before, it changes the way we look at our own lives, how we respond to others, how we think of somebody whose thinking is different from ours. As a mediator, you learn that the world is not black and white. Nobody is fully right or fully wrong. And that the job really is to understand the other and then to see how we can both go forward together. There is much in life to be learned from mediation. So, let me say that it has been an absolute pleasure this morning. It's a long time since I came to a mediation program, but to see this hall filled up with so many of you who have come from distances near and far, we are a family. Please remember one thing. We mediators are a special family within the legal family. So good luck to all of you all. God bless.
Thank you very much, sir, for suggesting that mediation must be a full-fledged profession to have an increased number of cases, and expressing the need for spacious court-annexed mediation subcenters, and also for sharing your reminiscing memories for a enjoyable mediation. Thank you, sir. Now we request Honorable Thiru Justice D. Bharata Chakravarti to honor the respected senior advocate, Mr. Sriram Panchu, with a book and also with a sapling. Thank you, Lordship. Thank you, sir.
Next session is going to be handled by Mrs. Uma Ramanathan, Advocate. I request Madam to come to the dais. Mrs. Uma Ramanathan, Advocate, does not need an introduction. She has been the organizing secretary of the Tamil Nadu Mediation and Conciliation Center, High Court of Madras, since the year 2010. We invite Madam to take over the session on applicability of mediation and cases suitable for mediation.
வேண்டாம் வேண்டாம் எனக்கு நடக்காமல் பேசுகிறதே கஷ்டம். Good morning, everyone. As you all know, it's a very difficult task to follow what Justice Bharat Chakravarti and Mr. Sriram Panchu have said and motivated you and spoken so much about, and that too before lunch. And I'm trying to, and I will try to say how I'll say something about the applicability of mediation and how this act has been thinking about it. And I'm thankful to Justice Bharat Chakravarti for saying about the thermos flask. I think I'm coming here to sell the thermos flask, the first salesperson here. You know, it was very surprising that in the last week of March, when I was doing a 1-hour program for law students of Shastra University on mediation, one of the students who had attended some mediation sessions said, "Can I ask you a question?" So I said, "Yes." And he said, "Madam, why is it that mediation is so effective? We understand the potential of the mediation, but when there is a dispute, why do lawyers and parties feel that they have to litigate and not choose mediation?" I said, "Yeah, that's $1 million question. But then remember that we are conditioned to think that somebody else is going to decide for us. We need not take any responsibility for our decision. And we are not very sure about the risks that we are taking or how it will be approved by others when we make a decision." So I said, "I'm thankful to you for asking this question. And the buck stops there. You people have to start this. You people have to change your thinking pattern." And I think that's what the Mediation Act is doing to us. Yes, for a long time, this has been on the anvil, and there was a lot of discussion. And I remember when FCDR and CAMP had discussions in Bangalore, we were going back and forth about all the various provisions internationally and thinking how to put it together. And then later, of course, MCPC took over and started this discussion. And we know how it has been going on. And today, of course, with whatever idea the Mediation Council has been, there's a framework for the Mediation Council and its duties. We have an act. We must be thankful for the fact that we have something, a framework based on which we can start effective work. Because when we know that when Section 89 came in, the difficulties that we had, and when the Afghan's judgment came in, what Justice Ravindran said about cases suitable, not suitable, what can be done in mediation and all that is going to be set at rest, and we are going to have some sort of a platform to start our work from. So this is going to be the seed which is going to germinate into a big banyan tree, and we are going to be responsible for how the tree grows. And so it is necessary for us to look at how the Act frames this platform for us to practice mediation. As Mr. Sriram Panchu was saying, this is a profession. This has come to be accepted as a profession, and so we have to act as professionals. According to me, professionalism means it underlies status and responsibility. It's not just having a badge as a mediator or some identity as a mediator, but responsibility of action which does not bring about any harm, or at least brings about some kind of cohesiveness and harmony for the parties. So in that process, this act is going to be a big stepping stone to enable us to help parties to come to some sort of an understanding, or at least even agree to disagree, but come to a firmer ground where they are not reacting, but they are trying to find out how they can respond. And so the provisions that have been given to me are section 2, 6, read with the first schedule of the act. When I looked at, my senior also, Mr. T.R. Mani used to say, before drafting anything, look at the section first. You'll get a different idea every time you look at the act. And that's what I try to do, because for some time I have not been looking at the Mediation Act and the various discussions or changes that have been happening here. When I looked at the act when this topic was given, what I found was that it says, this act shall apply where mediation is conducted in India. Then I said, okay, it's conducted in India. What happens to online mediation, or what is it we are thinking of? And so then I went back and looked at the Contract Act and the Specific Relief Act. And I found that in those acts, it only says the act applies to India. But here it says ordinarily residing in India. Now, why do we have this ordinarily residing and not habitually residing or domicile, as in the Succession Act? Now, domicile is where there is an intention to reside there permanently or for a longer time. And I understand that the definition of habitually residing is as where one normally resides. So the Act goes on to define to whom it will be applicable, but first says it will be for mediation conducted in India and for all or both parties habitually residing in or are incorporated in or have their place of business in India. So later when we go on to online mediations and we are thinking of cross-border disputes also, we will have to look at this. See, we are here to sell this vacuum flask, but we are also here to see what can fit into the vacuum flask. So we have to understand applicability means, I think the definition is usefulness for a particular task. So how useful is this going to be? And when I was looking at that, I found that it talks about, section 2 talks about, I'm sure all of you have a copy of the Act. So if you open the Act and you see, you will see that the first part says, this Act shall apply where mediation is conducted in India and where they habitually reside, as I said, or are incorporated in or have their place of business in India. Of course, later on, when it talks about whether the parties should have an agreement to mediate or whether they will agree, what is the territorial jurisdiction and all that, there are going to be differences which other people are going to talk about. At the outset, when you're entering the premises, what you want is somebody to welcome you. And what you see here is somebody saying, when the mediation is conducted in India. So, any mediation that is conducted in India, this Act will apply. Great. The next is where you are habitually residing or the office is incorporated or has their place of business. So as long as somebody has although we won't call it as a cause of action, has a difference which arises within the state and has some locus here, then this Act would apply. Of course, international mediation is said. Then it talks about the central government and about commercial disputes or any public bodies or corporations. So when I was looking at it, I was wondering why it referred to only commercial disputes. But then Mr. Sriram Panchu was saying that they wanted initially only the commercial disputes to be included and then later on bring in others when everybody was qualified enough to step into it. So I think looking at it as a first step, commercial disputes are where people are prepared to negotiate. So when you're inviting the government to be part or to bring their disputes in for resolution, what they are looking at as commercial disputes is for a chance for people to make some sort of offers. That's what the Contract Act says. There must be an offer and there must be an acceptance. So would that be possible here? But then when we look at it, can't there be other areas in which government bodies or public authorities can come forward for mediation? Or do they really accept the responsibility or the authority to participate in it? So I think this is a flag bearer to that extent. It has said government should take the responsibility. That's why I said professionalism is about status and responsibility. Now, government is sort of given a hint, is a nudge to say, take some responsibility, bring some commercial matters inside, and authorize somebody to do something in this. And then the next one says, to any other kind of dispute if deemed appropriate, in which one of them is a party. Now, this is all section 2 says. So, if we are talking about applicability of this section, of course, section 6 and first schedule talk about, it's more of negation of what are the disputes that cannot be mediated at all. But before going into that, what I want to say is that there is something called legal structuralization because of which we come to courts. Now, what is this legal structuralization? What is this march of law, as the MLJ used to call it? There is a reason for the law to change or the law to adapt to the situations that the common man faces or has a problem with. And so, the primary aspect of any legal structuralization is a conscience. So, conscience means doing the right thing or wrong thing. We differentiated between right and wrong. So, there must be some sort of addressing the conscience. The second stage is culture. Culture is how the people react to it, to the situations in life, and how they want to frame norms so that there is some kind of harmony. And the third is conscientiousness. Consciousness is where we want to do the right thing. Once conscience is about right and wrong, but conscientiousness is doing the right thing. So I think section 2 attracts this. If I don't know how many of us remember that in our first training of to be a mediator, we were told about the satisfaction triangle, where it talks about the emotional, procedural, and structural satisfaction, right? I used to wonder why only, where they got this from and why only these three aspects were referred to as the satisfaction triangle. And when I was reading something, I found this Aristotle's triangle, which refers to logos, pathos, and ethos. And logos there must be logic to anything. There must be a reasoning, and we look at proof. That's what happens in any litigation or any decision making. So, any resolution needs a sort of an intellectual aspect, where you analyze the logic, where you find proof for a particular proposition, and then there is reasoning to come to some sort of a conclusion. The other one is pathos, where values, the norms of the society, the kind of relationships that define their being together or the differences, and emotions. So these also, to a certain extent, impact the emotional appeal. A person may get a decree. I remember there was a landlord who was living in the US, and there was a property in Anna Nagar. Actually, I did the execution part of it. A friend of mine had done the litigation, and he got a decree. And then he said, why is this I have to file an execution? I said, no, you have a decree, but your man has not moved out, and you have claimed damages for the property and all that. So he said, no, I have a decree, so why can't the court give me whatever I wanted? So, as we usually say, every problem, a person has a problem only when he has a decree. The problem starts when they have a decree. So there's no emotional satisfaction at all, because even though he's got a decree, there's nothing that has happened to make him happy about it or change the situation about his feelings. The third is the ethical appeal, which is more important for mediation. Now, what are we talking about? We are talking about trust. We are talking about confidentiality. We are talking about credibility. How far has this been addressed in any other resolution process? Now, we know that mediation addresses all this, addresses the needs of what one person is looking at justice. They are looking at a holistic proposition where what is it that the justice delivery system can offer, what is it that they can benefit from the system, and what is it that will satisfy them. So when we are looking at that, looking at section 2 of the Mediation Act, is there something to create this trust and the credibility? Let's start with that. Yes, this says if it happens in India, mediation is conducted in India, government organizations are brought forward, it's as an international mediation where they are habitually residing. I think while I have my own concerns about the act has been framed, I think when I started looking at it from this point, I understood this habitually residing became important because it's like a child going to LKG. The parent who leaves a child in the school, stands at the gate and the child keeps looking back because the child wants something familiar. And maybe from the second or third day, the child would have found friends, the child will not look back. But here, when you say habitually residing, what happens is it gives some sort of a comfort, a security for the persons approaching mediation to say, okay, if it is conducted in India, if these are the things that are accepted under the act or this act will apply to these sort of situations, then I can go ahead and open my mouth. I can try a conversation. Because the whole thing is about a dialogue. Mediation is about a dialogue. And when will a dialogue happen? Only when they have trust and there's credibility in the whole thing. So I think that part of it has been established by Section 2. And it is more important that when we look at the other part, the structure or the procedural part also, that is what goes on further. Now when we go into Section 6, if you look at Section 6 in the act that has been provided to you, the first part says, whatever has been listed in first schedule, you cannot mediate at all. Now when I looked at it, I said, why do you start with something negative? Why do you say that all these cases are not going to be mediated? Why not talk about something positive? But then it says, of course, provisos always sort of water down certain things. But it also again gives this kind of a security or comfort in the second proviso, which says that if there is a mediation agreement, then again it will not be final, it will have to go to the court. I have a problem with this because if it is a private mediation and if it is an international mediation, whether you will go into the territorial jurisdiction or you will wonder which court would have to decide this or go into the validity, or whether it has to go into the validity, as Geeta Ramseshan will talk about the mediation council or the others will talk about other things. But what I thought was, reading Section 2 and Section 6 together, what it provides is some sort of a framework which says that, yes, the courts are going to be there, the courts will also look into it, but these are cases which we don't want to be mediated at this stage. And there, if you go into the first schedule, you will find, of course, criminal offenses. So again, I have a problem because 138 and all that will come in. We mostly look at how amendments can be made and how we can change the situation as and when we face it. So maybe because of that, they did it. But if you see in the first schedule, other than whatever is barred under various laws, it talks about disputes relating to claims against minors, deities. Yes, that can't be done. Again, I've always had a conflict, even before this came about matrimonial proceedings being settled where the mother agrees to receive something in favor of the minor. Are we not depriving the minor of whatever is due to the minor, or what will happen? That is a gray area still. But then, here it talks about persons with intellectual disabilities, which I have not seen in any other place. Even the Contract Act speaks about the unsound mind. But here we see intellectual disabilities. I was wondering what is intellectual disability, and as I was talking to my friends also, I said I have an intellectual disability because I can't operate a laptop or a computer. I don't know various things, I can't understand certain things, so is that intellectual disability? But then when I started thinking about it, I understood that in mediation it is an informed consent. ரெண்டு பேரும் அந்த விஷயத்தில் என்ன சாத்தியம், எதை பண்ண முடியும், எது அவங்களுக்கு சரியா இருக்கும்ங்கிறத யோசிச்சு ஒரு முடிவுக்கு அவங்களா வர்றதுனால தான் அங்கே ஒரு கமிட்மெண்ட் இருக்கு. Credibility, trust எல்லாம் முதல்ல வந்தா கூட, when it comes to a mediation agreement, it must be informed consent. They must have all the data, they must have understood what are the consequences of the decision they are making, and if they enter into that, then it becomes final. So there is a doable in that. இது பண்ண முடியும், இது சாத்தியம், இது நடைமுறைக்கு சரியாக வருங்கிறது தான் அதில் மெயின். ஸோ இன்ஃபார்ம்டு கன்சென்ட் வருதுங்கிறதுனால மேபி தே ஹவ் தாட் அபவுட் intellect. See, I'm raising these because these are flags which are going to rise up as we practice and as we find how to apply this act. We are not talking about who and when to apply this act. We are talking about what are the possibilities of application of this act and what can happen. And of course, it talks about the mental health care, persons of unsound mind, I can understand. Now, CPC provides, as we all know, that when a person is not capable of taking care of himself or herself, a guardian can be appointed, right? So in what circumstances? I remember long time back, there was a case when the husband wanted to sell a property which was in the joint name of himself and his wife. அவங்களுக்கு வந்து செகண்ட் டெலிவரிக்கு அப்புறம் பேராப்ளீஜியா வந்துடுது, மூவ் பண்ண முடியாது. அவர் கையில் இருக்கிற காசெல்லாம் செலவு பண்ணியாச்சு. இந்த ஒரு ப்ராப்பர்ட்டியை விற்றா தான் அவரால் இனிமேல் செலவு பண்ண முடியுங்கிற ஸ்டேஜில் he applied. So one of the junior advocates came to me asking how you can get permission. I said, getting appointed as guardian is the only way. You go to court. But the court unfortunately dismissed it. There are cases we know where, though we talk about minors, today, of course, POXO, because of POXO, we are supposed to report, but earlier we did not have that. And so whether any information disclosed about harassment of minor, whether it had to be disclosed, whether something had to be done, again was a problem. But we know today that most of these provisions are more misused than used properly. So sometimes there are false complaints also. So how are these going to be handled? So these are areas that we will have to look at. Disputes involving prosecution for criminal offenses again is going to be a big challenge for us because 138 will come under that. There will be so many other areas. But mainly I think it is because of looking at commercial matters, all these kind of frameworks have been done. Now, complaints or proceedings initiated before any statutory authority in relation to registration, discipline, misconduct of any practitioner. I think it is because medical council has their own council, we have our bar council, they have said it will have to go through that. Again, how these are going to be handled or whether there will be areas which can be mediated, we will have to look at. And as I said, matrimonial dispute, the rights of third parties, that is of a child, can be mediated, has been said. Now, the rest of it goes about National Green Tribunal, income tax, electricity authority, petroleum and natural gas, securities and exchange and all that. So it's a sort of a blanket bar. Yes, it can be amended, other things can be brought in if some difficulties are found out, but today, environmental issues, I remember, I don't know how many of you attended the first Asian Pacific Conference in Delhi. There was a section where some of them were talking about putting up a chemical plant somewhere and people from the community being brought in to discuss about that. We know of many projects being stalled today because of communal or a political uprising where somebody has been instigated to protest because somebody is promoting it. And maybe it is good for the community, but it is not done. But I'm also conscious of the fact that given the kind of people who will be called as esteemed persons or persons qualified, we don't know who will be handling this. But I think we will have to reflect on this and find out how this has to be done. Now, overall, what I found was that it is not just about commercial disputes today. All of us, I'm sure, know, எத்தனை பேருக்கு வந்து பார்ட்டிஷன் சூட்ஸ், வேர் ஒரு பிரதர் வந்து அமெரிக்காவில் இருக்கார், ஆஸ்திரேலியாவில் இருக்கார், அவர் கொடுத்தா என்னங்க, அவர் நல்லா தான் இருக்கார், நாங்கள் எங்கள் வீட்டில் இங்கே ஒன்றுமே இல்லை கிராமத்தில்னு சொல்கிறவங்க இருக்காங்க. Or there will be a prime property in Chennai, where I remember where the daughters were living in Kerala and they had been provided for by the father. They had bought houses, they had been given a lot of jewelry, ellame veedu vaangiradhulende for a few crores, everything had been given. But then after the amendment they came to file for their share in the property. But one brother was living abroad And he refused to come for mediation. And he said, whatever is the law, let it take its course, because my father had left a will. Whether probate can be handled in mediation was also a big question at some time. But today a lot of matters are being referred. Now, that is why I referred to this Aristotle's triangle. Will it address the emotional part of it? Will it give emotional satisfaction? இப்போ நம்ம என்ன பார்க்கணும்னா, இந்த framework-குள்ள, how can relationships be handled? How can this intellectual disability னு சொல்லாம, intellectual ability to perceive the situation in a proper way? அவங்க வந்து என்ன மாதிரி சஜஷன்ஸ் கொடுக்கறதுக்கு இந்த ஆக்டை எப்படி யூஸ் பண்ண முடியும் from the discussions that we have throughout the day. இதில் என்னெல்லாம் வந்து இந்த ஃப்ரேம்ஒர்க்குள்ள பொட்டென்ஷியல் இருக்கோ அதை எப்படி யூஸ் பண்ணோங்கிறத நம்ம ப்ரோவ் பண்ணி, and where there are difficulties, if we are able to discuss that, I think we will be able to take this forward, because today the need of the hour is an act like this. இது இல்லாமல் வேற just under section 89 ஒன்றும் பண்ண முடியாது. Of course, we were looking at criminal offenses and how they are going to be handled, because a lot of anticipatory bail applications are referred. How that will come about in future, we don't know. But from whatever has happened, and my little reading of whatever I have done on mediation, I remember reading somewhere, is mediation going to be a boon or a bane? It is a boon, it can be a boon, but if we don't practice it or allow it the framework that it has to have for a proper application, then it will become a bane. So it's in our hands. So let us join together, pledge to use this and to make this better, and have a very good process which will satisfy the parties and us to enjoy the process of practice of mediation. Thank you.
Thank you, madam, for the detailed lecture on the applicability of mediation and different cases suitable for mediation, including probate. Madam has stated about grey areas which is to be addressed. She has interpreted the new term intellectual disability used for the first time in the Act. We request Honorable Thiru Justice Abdul Quddus, Judge, Madras High Court, to honor respected madam with a book and sapling. Madam, please be seated. Thank you, Lordship. Thank you very much, madam.
Mr. A.J. Jawad, advocate, who has been a part of the Tamil Nadu Mediation and Conciliation Center, High Court of Madras, as an accredited mediator since the year 2007. He has conducted many sensitization programs for all the stakeholders across the nation. We welcome you, sir, to deal with the mediation agreement, mediation settlement agreement, and its recording. Welcome, sir.
Thank you. Good morning. Well, I'm very lucky to get the morning session. And I feel very sad for Geeta, for Arvind Pandian and Arunachalam, because they have to deal with the afternoon session. And I know this morning session itself has been quite a tedious one for all of you. So, can I request all of you to stand up? Can we all just clap hands, a round of applause? Thank you, please sit down. Well, that applause was not for me. You would have thought, yeah, unik inda alpa ase appdin solli, but that was not the intention. That round of applause was for Uma. And also to wake up all those who would have gone to sleep. Of course, you can now sit down and go back to sleep, if you wish to. Okay. So, I've been asked to speak about 4 sections. Section 4, Section 19, Section 27, and Section 28. And I'll have to trouble you to open the Act because I believe copies of the Act have been given to all of you. So kindly open that. Sorry if I make you read this. It's not the preamble of the Constitution, of course, where we collectively read, but this is just for our understanding. This talks about a mediation agreement. Now, basically, what it talks about is an agreement to mediate, because there can be some confusion between a mediated settlement agreement and a mediation agreement. So, it essentially talks about an agreement to mediate. What it says is the mediation agreement shall be in writing by or between parties, and anyone claiming through them to submit to mediation all or certain disputes which have arisen or which may arise between the parties. A mediation, subsection 2 says a mediation agreement may be in the form of a mediation clause or in a contract or in the form of a separate agreement. The third clause says a mediation agreement is in writing if it is contained in or recorded as A, any document signed by the parties, B, an exchange of communications or letters including through electronic form as provided under the Information Technology Act 2000, C, any pleadings in a suit or any other proceedings in which existence of mediation agreement is alleged by one party and not denied by the other. Subsection 4 says a reference in any agreement containing a mediation clause shall constitute a mediation agreement if the agreement is in writing and the reference is such as to make the mediation clause as part of the agreement. Subsection 5, the parties may agree to submit to mediation any dispute arising between them under an agreement, whether entered prior to or arising of the dispute or subsequent thereto. Subsection 6, it talks about international mediation. I will not go into that. Okay, now, why I read out this section, because I know all of you can read the section. Why am I taking the trouble of, or troubling you rather in reading out the section is very simple. Because I just want to point out to you one of Bill Gates' contributions to, he gave us the Microsoft Office, and which makes it very easy for us now to prepare anything because we don't have to type out the whole thing, we just have to cut and paste. So if you see section 4, and if you're very familiar with section 7, you will find a whole lot of a cut and paste job that has been done. Sorry to start off on a very critical note of the Act, but that is not the intention. Now, if you see section 7, now I won't trouble you by reading the whole of section 7, but what I want to do is, I have just made a comparison of section 7 of the Arbitration Conciliation Act with section 4. Now, if you look at subsection 1 of section 4, it says, a mediation agreement shall be in writing. Of course, it goes on to say by or between parties or claiming through them, so and so. If you see subsection 3 of section 7, it says an arbitration agreement shall be in writing. Now, very shortly we'll discuss the logic behind making such a stipulation. Subsection 2 of section 4 says a mediation agreement may be in the form of a mediation clause in a contract or in the form of a separate agreement. Subsection 2 of the section 7 of Arbitration Act also uses the same words except that mediation is substituted by arbitration. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Subsection 3 again is a verbatim extract of section 7. It says any document, a mediation agreement is in writing if it is contained in or recorded as any document signed by the parties. Section 7 also says a document signed by the parties. Of course, they have made a few minor changes here and there. It says any document signed by the parties. This says a document signed by the parties. So there is a difference between the a and the any. Then there is an exchange of, that was meant to be a joke. Anyway, I think it fell flat, so don't bother. B, an exchange of communications or letters, including through electronic form as provided under the Information Technology Act. Here it says an exchange of letters, telex, telegrams, or other means of communication, including communication through electronic means, because this was before This is a 1996 Act, so before the Information Technology Act. So a change has been made. Any pleadings in a suit or any other proceedings in which existence of mediation agreement is alleged by one party and not denied by the other. The Section 7 says an exchange of statements or claims and defense in which the existence of the agreement is alleged by one party and not denied by the other. So essentially what it means is a mediation agreement or is very similar to an arbitration agreement. So it has to be in writing, it has to be admitted by both parties. And once you are able to see that there is an agreement between them to go for mediation, they have to go for mediation. Now, do they really have to go for mediation? That is a question that we will shortly answer. Now, here is a very interesting thing. Now, when you read Section 4, it appears as if it is as important as Section 7 of the Arbitration Act. Now, we all know that unless there is an agreement in writing between the parties, there cannot be a reference to arbitration, right? There has to be something from which the court can draw the conclusion that yes, the parties have agreed. Now, if you read Section 4 of the Mediation Act, it sounds somewhat similar. It means as if it implies that if there is an agreement, you have to go for mediation. Okay. Now, this is, just look at Section 5, if you may. Section 5 talks about pre-litigation mediation. It says, subject to other provisions of this Act, whether any mediation agreement exists or not. Whether mediation agreement exists or not. So even if there is no agreement in writing, you can still go for mediation. The parties, before filing any suit or proceedings of civil commercial nature, may voluntarily and with mutual consent take steps to settle the disputes by pre-litigation mediation in accordance with the provisions of this Act. So, it is not necessary that there should be an agreement in writing to go for mediation. Now, what is the significance of saying it shall be in writing? Because, we lawyers play a lot on these words, shall, may, all these things. We do a lot of mischief using these shall and may, right? So, whether it's mandatory or not mandatory, these questions arise. Now, this question, I don't know how we should answer it. Now, what is the purpose of having the Section 4 in the first place? I'm just trying to figure it out, and let's hope that we can all join together and perhaps find some answers for this. It says actually, according to me, Section 5 obviates the necessity of having an agreement in writing. Because if you have a dispute and if you decide to go for mediation, regardless of whether you have an agreement or not, you can still go for mediation. Now, here's the question. What is the point in having Clause 4 at all? Is it enforceable? Now, let's say that you and I have a contract and there's a clause in it which says that, if any dispute arises between us, we will go for mediation. Now, can that clause be enforced by me if you don't agree to go for mediation, as and when a dispute arises? Now, that's an open question. I'm not going to answer that for you. I want you to figure it out, and perhaps in the future, because we had the Arbitration Conciliation Act of 1996. With all its failings, it worked its way. Finally, in 2019, we made some amendments that made some sense of the Act. So perhaps, somewhere in the near or distant future, this Act will also be amended to make suitable changes. Now, what is the difference between this and Section 7 is that in Section 7 of the Arbitration Act, if there is an arbitration agreement, there is something called Section 8, which says that if I don't accept the arbitration agreement and I file a suit, you can go to the court and tell the court that please stay the suit because I have an arbitration agreement with this party. So you can invoke Section 8 and get this suit stayed. But can you do something very similar? If supposing there is a mediation clause, there is an agreement in writing between you and the other party does not go for mediation or does not agree for mediation. You can also go to the court if one party refuses to, under the Arbitration Act, if the party refuses to appoint an arbitrator, you can go to the court under Section 11 and ask the court to appoint an arbitrator. Can you do that under Section 4? Because there's nothing similar to Section 11 here, right? Nothing similar to Section 11. Okay, now these are some of the challenges. But, here's what, but there is a section 7, which basically is very similar to section 89 of the CPC. It simply recognizes the power of the court, that notwithstanding whatever may have happened between the parties, whether they have mediated, they have not mediated, the court can still refer the parties to mediation. So what section 7 says is, notwithstanding the non-settlement of dispute, under subsection 1 of section 5, the court or tribunal may at any stage of proceeding refer the parties to undertake mediation. So it is very similar to section 89, the power of the court to refer parties to mediation. So, of course, it would have been very ideal for, mediation enthusiasts like us if there was something very similar to section 8 or section 11 of the Arbitration Act also provided for under the Mediation Act. But unfortunately, it is not there. Now, here's the question. Should we have an agreement to mediate at all? Should we have a mediation agreement at all? Now let's for a minute remove the hats of court-annexed mediators and wear the hat of private mediators. Those who are going to be doing pre-litigation mediation, because that is why this act has come. The main reason for the enactment of this act is only to enable pre-litigation mediations. Now, it's a kind of a paradox of life that, the whole purpose of mediation is to bring dispute resolution out of the tyranny of the laws, what I call the tyranny of the laws, right? But we need a law to come out of the tyranny of the laws. That's the paradox of life. Just keep it in mind, okay? Now, when you're doing a private mediation, should you have an agreement to mediate or a mediation agreement as described in section 4? The answer would be yes. Why? Because you cannot have the luxury of what you do in court-annexed mediation in a private mediation. It's going to be a professional service. You are going to be held accountable for all your actions as a private mediator. Because you're going to be a professional mediator, you're going to be answerable to the parties who are going to come and engage your services as a mediator. So it would be very important for you to have an agreement to mediate before you enter upon a mediation, because that agreement to mediate, now if you can make some notes, it's your choice, if you wish to. Please don't think that I'm treating you like school children, okay? Clear description of the parties, names, addresses, designations. This should be very clearly mentioned. A brief description of the dispute. You don't have to go into the deeper aspects of the dispute, but broadly what the dispute is all about, okay? Is it about partition? Is it about a disagreement over a contract? Is it a breach of contract? Whatever it is. 3, the parties mention there that the parties have voluntarily agreed for the mediation. Because voluntariness is an integral part of the mediation process. There's a lot of party autonomy that we talk about. The name and address of the mediator or the mediation service provider, because the Act talks a lot about mediation service providers, because the very statement and objects of the Act talks about institutionalizing mediation. So we are going to be having institutional mediation, because we don't want mediation to go the way arbitration went in India. So there is a lot of value in institutionalizing mediation. So the mediation service provider who has been approached by one or more of the parties to undertake the mediation. In case it is a mediation service provider, the name of the mediator who has been appointed by the mediation service provider. Now there has to be a conflict check and a disclosure by the mediator that the mediator is neutral, has no interest or conflict of interest with either of the parties. That statement should come in the agreement to mediate. Now these are my views. Okay, there may be many things that you may like to add or subtract from this. Whether parties will be personally present or will be represented through authorized representatives, whether they will have the authority to settle. That becomes very important. Do they have the authority to settle? Because if you don't have the authority to settle, many times we have seen even in court-annexed mediations, some representative, someone low down in the pecking order in the corporate or the company comes, takes part in the mediation. After everything happens, they say that, sorry, I have to go back to my CEO or my MD and get their concurrence. So you have to avoid that, okay? So authority to settle, you have to verify and mention there, okay, in the agreement to mediate. Confidentiality. There should be a clear non-disclosure agreement clause in the agreement which says that confidentiality will be maintained by both sides as well as by the mediator, okay? Also that, this is very important because this again affects the element of certainty that the parties have in the process, because they need a certain level of, because see, ultimately mediation is all about self-determination, because parties are going to reach an agreement. Now they may not reach an agreement. Now what happens if they don't reach an agreement? Is the mediation process going to affect them in any way? Therefore, the without prejudice aspect of the mediation process, that nothing that happens in the mediation is going to affect the parties, that should be clearly mentioned. What is the status of the settlement agreement? We'll be coming, of course, to section 27 and 28, which talks about, the mediated settlement agreement having the force of a decree of the court. But nevertheless, it's always, parties should also have that understanding, so it's better to mention. And of course, the last but not the least, the fees of the mediator, right? You're not going to be paid 2,500 for a mediation, right? It's not an honorarium that you're going to be paid. You're going to be charging a professional fee. So the details of the venue, the logistics, who's going to share the costs, all these things should be very clearly mentioned. Why this becomes important is because normally in a mediation, both parties are supposed to bear the cost, which is very similar to arbitration. Now what happens if one of the parties is not willing to bear the cost? Will it impinge upon the neutrality of the mediator if fees is received from one party alone? So therefore, it's better to mention that. Who's going to pay the fees? What will be the proportion of, sharing of costs between the parties? So that is as far as section 4 is concerned, okay? Please feel free to ask me any questions once I finish this. I'll try to finish it with sufficient time for any questions, okay? Now we come to section 19, which is the effect of the mediated settlement agreement. Now, notwithstanding all the lacunae, all the loopholes, all the deficiencies that are there in the act, we have to salute this act for this one reason. Because this is the section 19 that confers the gravitas on the process of mediation. It emphasizes the importance of a mediated settlement agreement and gives it the status of a decree of the court. And it also gives us a huge responsibility of ensuring that parties, when they reach an agreement, when they reach a settlement, they reach it voluntarily and they reach it after understanding all the consequences, the pros and cons of the decision that they are taking. So this becomes very important. It becomes a responsibility of the mediator. Now again, I'm going to read this section a bit because I think it's important. Many of us don't go through the statute, so I'm troubling you to read this. A mediated settlement agreement includes is something which is not explained. It's an inclusive definition, right? We all know in the interpretation of statutes that when the statute says includes, it means that there are other options also possible. So what does this mean? I don't know. A mediated settlement agreement includes an agreement in writing between some or all of the parties resulting from mediation, settling some or all of the disputes between such parties, and authenticated by the mediator. Now there is a proviso here. Now this inclusive definition, I don't know what other options that the legislature had in mind. Does it include an oral agreement also? Does it contradict subsection 2? Okay, which says that where a settlement agreement is reached between the parties with regard to all or some of the disputes, the same shall be reduced into writing and signed by the parties. So all these things these questions are still open. So hopefully, when these matters come up before the court and the courts start interpreting these sections, we may be getting the answers for this. Now, there is a proviso here that says that provided that the terms of the mediated settlement agreement may extend beyond the disputes referred to mediation. Now, there is a clear distinction with the scope of arbitration and the scope of mediation, because as we all know, that an arbitrator is bound by the terms of reference. Arbitrator cannot travel beyond the terms of reference. Now, if A, B, C, D disputes are referred to the arbitrator can pass an award only on those. The arbitrator cannot go beyond that and say that I'm also taking into consideration a dispute E, which has been brought before me by the parties. That will be outside the scope of reference. So therefore, but in the mediation, there is a scope for settling many disputes. So parties may come to you perhaps with maybe a custody dispute, child custody dispute, but there may be many other things that they may have. There might be concerns about maintenance, there might be concerns about division of property, there may be concerns about some criminal cases that may have been filed. No, there is a scope for settling all these disputes in the mediation process, because there's no circumscription of whatever the disputes that can be resolved. Okay. Now there is an explanation here. It says a mediated settlement agreement which is void under the Indian Contract Act shall not be deemed to be lawful settlement agreement within the meaning of mediated settlement agreement. Now obviously, mediation works under the shadow of the law. That's what we all understand it, right? So any agreement that is reached should be something that is valid under the law. It cannot be void. It cannot be a void agreement. Where a mediated settlement, subsection 2 says where a mediated settlement agreement is reached between the parties with regard to all or some of the disputes, the same shall be reduced into writing and signed by the parties. Now we come to what is the mediator's role in this mediated settlement agreement. Once the parties have signed it, should the mediator sign the mediated settlement agreement? Now this is a big point of controversy. In fact, there is a north-south divide in this. You will be surprised to know. Because whenever I go to Delhi and talk about mediator not signing the settlement agreement, people stand up and say, sorry, we sign it. Okay, now we in our High Court, we don't follow that. We file a report. We don't sign. We file a separate report. Now, actually, and you can clap hands for the Madras High Court and our Tamil Nadu Mediation Center, because what we do has been validated by the Act. The Act says, subject to provisions of Section 26, the mediated agreement, a settlement agreement signed in case of institutional mediation shall be submitted to the mediator, who shall, after authenticating the same. So mediator only authenticates it. Mediator does not sign the settlement agreement as a party to it. Forward it with a covering letter signed by him to the mediation service provider and also provide a copy to the parties. In all other cases shall be submitted to the mediator, who shall, after authenticating the mediated settlement agreement, provide a copy to all the parties. So what you do is, parties sign the mediated settlement agreement, you authenticate it, and you give the copies to the parties. Now, there is one thing which is not answered here. What should be the stamp duty and all that on a mediated settlement agreement? Because under conciliation, we all know that parties reach an agreement in conciliation. Pursuant to the conciliation, it is stamped like an arbitral award. Though it's an agreement, it is stamped like an arbitral award because it is deemed to be an arbitral award on agreed terms. But I don't see any very similar provision here. Perhaps if the rules come out, there might be something very specific about that. Yes, Sandhya, please go ahead. Okay, authentication simply means, let me draw a parallel to what we do in the court. We submit a report saying parties appeared before me, settlement took place. Now, here something similar, because authentication, my understanding, and what we have been doing under the Arbitration Conciliation Act so far is that you attach a certificate of the mediator saying that parties came before me, conciliation proceedings were held on so-and-so date, parties reached a settlement, and that agreement is enclosed, as per the enclosed agreement. Separate. So an authentication is separately given by the mediator. Okay, so you simply say that That is my understanding. We'll have to wait for the rules. Okay, my understanding is they may sign the mediated settlement agreement, but we are not signing the mediated settlement agreement. We are not signing anywhere the mediated settlement agreement. We are signing a separate certificate saying that mediation took place and they have reached an agreement and this is the agreement. That's all. That is my understanding. Okay. No, I don't think that is any longer correct because you cannot do that. You can only authenticate. I think they should change their practice. Please inform them that that is what the Mediation Act says. Okay? Yeah. So now Section 27, which is, I think, the most important section in the Act. And this is one section which actually legitimizes the very existence of this Act, which gives it teeth, which gives it some sanctity. Because all along, a lot of statutes have been talking about mediation. We have had Section 89, which talks about mediation. We have had the Companies Act. We have had the Consumer Protection Act. So many provisions talk about mediation. But what happens in private mediation? What is the sanctity of a mediated settlement agreement that is reached? All along, what we have been doing is, we have not been calling private mediation as mediation. We have been calling it as conciliation to bring it under the Arbitration Conciliation Act. But now it changes. We can call it as mediation. Okay, we can call Jawad as Jawad. Okay, we can call Uma as Uma. We can call mediation as mediation. Okay, so that is one of the biggest things that this Act has brought about. And also, as I said earlier, it casts a huge responsibility upon us because when we are authenticating a mediated settlement agreement, we are authenticating a document that has the force of a decree that can be executed against anyone. Okay. So a mediated settlement agreement resulting from a mediation signed by the parties and authenticated by the mediator shall be final and binding on the parties and persons claiming under them respectively and enforceable as per the provisions of subsection 2. Subject to the provisions of Section 28, the mediated settlement agreement shall be enforced in accordance with the provisions of the Code of Civil Procedure 1908 in the same manner as if it were a judgment or decree passed by a court and may accordingly be relied on by any of the parties or persons claiming through them by way of defense, set off, or otherwise in any legal proceeding. Before this, there is a Section 20 which talks about registration of mediated settlement agreements. But that is optional. Okay, so when the rules come, we will know who is the authority before whom a mediated settlement agreement can be registered. I'll just come to you. Can be registered, but it is optional. The parties may choose or may not choose. But whether it is registered or not, it can be set up as a defense or a set-off in any suit filed by any other party. I mean, the parties to the mediated settlement agreement. So it has the force of a decree. So friends, when you're doing private mediation, please understand that there's a huge responsibility on your head. You cannot be instrumental in bringing about an agreement that would be, either unfair or it is something that affects somebody very drastically. You have to be very careful. You have to make sure that it is an agreement reached by the parties after understanding all the pros and cons, and they have voluntarily agreed to it, and it is their agreement. Okay? So you can no longer afford to tell them what to do. You can guide them, you can discuss with them, but make sure it is their decision because it has a lot of force in it. Okay, it has a lot of sanctity. So we have to respect that sanctity. Yes, sir. Yes. Sir, let us. No, it doesn't require. No. Sir, let us do one thing here. Okay, let us remove the hat of a court annex mediator and wear the hat of a private mediator. Okay, this is not referred by the court. This is where parties are directly coming to you and asking you to mediate the dispute. Like how, if supposing you and I have an arbitration agreement, and we go to Mr. Rahman and say that, Mr. Rahman, please be our arbitrator. Okay. So now, when he passes an award, I don't have to go back to the court and get that award, authenticated by the court or ratified by the court. It has the force of a decree. Very similar to that, in a mediation, if supposing parties are approaching you, asking you to be the mediator, and you mediate and they reach a settlement, it has the force of a decree without any requirement of going back to the court and getting the author. I hope that's clear. Thank you, sir. Yes. Yes.
If that is so, will there not be any misuse of that agreement, main agreement, wherein only the parties have signed without authentication in that agreement itself? They can have some other agreement has been authenticated by some other sheet.
See,
so I think
that's a very valid question.
That's a possibility.
That's a very valid question.
Yeah.
Now, I may not be able to give you an answer for that because we'll have to figure out a way of doing it. We'll have to wait for the rules first.
Yeah, but section doesn't provide that.
Section doesn't provide for that. We'll have to wait for the rules for that, and perhaps rules may say, maybe that's why registration is suggested. It's not prescribed, it is only suggested. So that may be an option to make sure that, it has the validity. Ma'am, we are now, let us not get confused between court annex mediation and private mediation. The Act is dealing with private mediations. Mediator cannot grant a divorce. No. What I'm saying is, see, in a court annex mediation, what happens? A matter comes to me as a mediator, I mediate, parties agree to get divorced, they go back to the court. They file a separate application for divorce by mutual consent. Yes. But that's a separate question, ma'am. We'll deal with it separately because I don't want to get, go off on a tangent because we are specifically talking about the Mediation Act. Your question is a pertinent one. I mean, it's a good question, but unfortunately not pertinent to what we are discussing here. Okay, so let's come back to that. Okay. Now, one of the very important things next is challenge to a mediated settlement agreement. Okay. Now, this is a bit, if supposing as a mediator I have ensured that parties have reached an agreement with full consent, understanding all the pros and cons, the question of challenging it doesn't arise. Or implementing it or executing it doesn't arise because parties will comply with whatever obligations they have voluntarily undertaken. But there has to be a provision for challenging a mediated settlement agreement because there is a possibility of misuse or abuse by anyone of the mediation process where, perhaps a party who is not connected or who is deeply connected with the dispute may be kept out of it. Like a brother and sister may reach an agreement for partition of the property, leaving out somebody else. Okay, or it might be induced by fraud, by so many things. So therefore, there is a provision here, section 28 talks about that. It says, notwithstanding anything contained in any other law for the time being in force, there is a non-obstante clause. In any case in which the mediated settlement is arrived at between the parties and is sought to be challenged by either of the parties, such party may file an application before the court or tribunal of competent jurisdiction. A mediated settlement agreement may be challenged only on, no other grounds are permitted, only on all or any of the following grounds, namely fraud, which is understandable. If it is fraudulent, you have to set it aside. If it's induced by fraud. Now, corruption is something that beats me really. I don't know where is the question of corruption, right? Now, unless I take money from one party, I'll just come to you, sir. Unless I take money from one party and facilitate an agreement which the other party agrees to, perhaps without knowing what he or she is agreeing to. Except that, I don't see any scope for corruption of a mediator because what do? I'm not the deciding authority. If I'm the arbitrator, I may take money and pass an award in favor of one party, right? Okay? If I am an adjudicating authority, I'm deliberately not using the word judges because many judges are here. But if I'm an adjudicating authority, there is a possibility that I can get corrupted. But as a mediator, where is the question? I mean, I can't, it's not in my hands. I'm not going to pass an award or a decree. They have to agree to that. So if they are parties who are woke, who are, alert, who know everything, there's no question. But what happens if one of the parties doesn't have equal bargaining power? What if one of the parties is under some misconception or lack of information? In which case, there is a possibility that a mediator may be in a position to influence an agreement, which may not be in the best interest of that party. So therefore, a mediator can be corrupted. Yes. Section 10. Disclosure, yes. Will it come under corruption? It may. So any corrupt practice, I think that definition will have to be given, but the courts will give it because how they define public policy. Under the Arbitration Act, public policy is a very vague term, right? It can mean anything. So similarly, corruption is a very wide term. What kind of corruption? Is it only monetary corruption, financial corruption, or is it some sort of influence that is put? It might mean anything. So therefore, I feel it's a valid ground there, though initially, at the moment I saw it, I was a little confused. That what do they mean by corruption? Because how can the mediator influence an outcome? Because basically it's self-determination. But there is a possibility, especially in a country like India. Yes, can influence. Yeah, there is a possibility. Supposing there is an unscrupulous mediator, there might be a possibility that the mediator might influence. So I think this word corruption will have to be interpreted by the courts appropriately in appropriate cases. Impersonation, because I can pretend to be somebody else and I can come and I can have an agreement with you and anyway, see, yes, that can happen. Yeah, you're right. Yes.
So may I please? So in this, Your Honor, in this 28 and 29, 28.2 and 28.3, only the limitation.
Would you mind standing up, please? I'm not able to see where you're talking from. Who's this?
Excuse me, sir.
Oh, yeah. Sorry. Yeah.
So
please.
they are mentioning 4 reasons: fraud, corruption, impersonation, and another thing. But within 90 days only we have to file.
Yeah, that is a bit of a challenge. We'll come to that. Yeah.
That is somewhat paradox is like that. We are only they can know within 90 days corruption is there as happened, the award is passed.
Yes. No, what happens if 6 months later I come to know that some money was paid to the mediator?
That is.
I don't know, right? So there should
be. That is the problem.
Yeah, I was coming to that, but thank you for that.
Okay, thank you, sir.
No, but it says that further period of 90 days. See, today I am getting a mediated settlement agreement in my hands. So I have the mediated settlement agreement in compliance with subsection 3, right? I have received the copy, as mentioned here. But maybe 6 months later, somebody comes and tells me that the mediator happens to be a first cousin of the other party, and that was not disclosed. Now, obviously, that's wrong, right? So, it means I cannot challenge, because the 180 days, the maximum 180 days would have expired by then. So, this is a bit of a problem, because challenging that, the mediated settlement agreement, I think perhaps an amendment would be required here where it says that where such fraud, impersonation or corruption comes to the knowledge of the party who's affected by the agreement. I think that may, I don't know, jurists like Arvind may be able to throw better light on that. Okay. So that's it. Thank you very much. I think these are the only 4 provisions that I was asked to speak about.
Can I say something, George?
Thank you.
George, can I say something?
Yes, Giri, where are you?
I'm here.
I can identify your voice, but...
Yeah, you can look...
Oh, yes. Always the backbencher.
So there are 2 issues. One is regarding Stamp Act. See, you asked whether the agreement should be stamped. There is no clarity in that. The Indian Stamp Act defines under section 2 what an instrument is, and my reading of that is a mediation agreement is an instrument and therefore it is liable to be stamped in accordance with the Stamp Act.
Stamp Act.
It's same like an arbitration award. Second aspect is registration. Under section 17, it may have to be registered other than the registration contemplated in the Mediation Act.
Yes.
Because if there is any title, created, transferred, etc. Now there is an exception under 17(2)(6), I think, in favor of a decree.
Yes.
But in section 27 of the Mediation Act, it does not say that it is a decree. It says it can be executed in the manner that a judgment or decree can be executed. So therefore, that exception may not be available, and therefore a registration of
may be mandatory.
Yes.
Where there is a transfer of property or any such thing, where it is required to be registered.
It falls within the net of 17(1)(a).
So these are the things that are not very clear in the Act, because the Act should have defined all these things, but it's not there. There's a bit of a vagueness here. So thank you once again, and for your patience. And I was very happy to see that almost all of you were awake. Thank you. Yes, please give him the mic. Please take the mic, sir.
The document, that is authentication document, is like a degree.
Yeah.
It can be executed, but there is no format at all, because I may draft it in some other way. In CPC there is a degree format, pleading there is a format, but for the mediation I may draft it in some other way. That may, while executing that award, that may make some difficulties. Is there any format for the award?
No, there is no format. There is no It's a simple agreement between the parties. Okay.
Because already the sir said that the Stamp Act and other things are same. This may make some difficulty in future, sir.
See, there are a lot of things that may come up in the practical application or the practical implementation of the provisions of the Act. We may be coming across a lot of challenges. And I think as it usually happens, any new law comes, it comes with its own problems. We need to find the solutions to those problems as we keep going. Yes. But the fact is, today we have a law. Today people are recognizing mediation as a serious process. And as you heard Mr. Panchu saying in the morning, we are looking at it as a profession now. So hopefully all these things will get resolved.
Otherwise,
in days to come.
The Tamil Nadu Mediation Charter may draft some format. Then that will be...
No, I don't know whether, because see, one size fits all. Again, that problem will always be there. Whether a specific agreement has to be only in that format. We can't have that. The only thing is, see, as long as... let us remember one thing. It is executable like a decree of the court. It is not a decree of the court. It is executable. It has the force of a decree of the court. Now, it is an agreement of the parties. It's not a judgment. It's not an award. So, therefore, you cannot prescribe a format for that. It has to be something which is very flexible. As long as you can make sense of what the parties have agreed upon, that's good enough. Yes. Okay. Thank you, sir. Thank you. We'll have to give the opportunity to the next speaker, ma'am. Yes, please.
One question, that's all. In addition to this decree nature of the settlement agreement, sir, in case tomorrow the party does not comply with those, then where do I go? Does he become a contender, or is it a contempt, or what is it?
You can execute it. You can file an execution petition.
Okay, so that goes up till execution.
Sorry, ma'am, I'll answer your question also, because you looked very disappointed. I'm sorry. Yeah.
What would be the forum for 28?
Take the mic. No, please take the mic.
Forum for section 28, sir.
Forum for?
Section 28.
For challenging?
Yes.
The court is described, no? And I think Uma spoke about it. The court, principal court having jurisdiction?
Yes.
That is the court. Okay. So thank you. Thank you very much.
Sir, kindly stay for a moment on the podium. Firstly, we thank you, sir, for making the session so lively, and also for taking us through the various provisions of the Act, especially sections 27 of the Act. Thank you, sir, for your interesting and interactive session. Now we request respected Additional Registrar of Vigilance, Mr. C. Vijay Kumar, to honor the resource person with a book and a sapling. Thank you, sir.
Now let's break for lunch. Lunch is arranged for the judicial officers in the first floor and for other participants in the ground floor. Afternoon, we have 3 more sessions on the new Mediation Act and valedictory function. We request everyone to reassemble at 2 p.m.
shall be undertaken. So the important word to take note here is for the purpose of 12 capital A, the word shall has been used, which means it makes the provision under the Arbitration Act a mandatory one to ensure that you go through that process before you enter court. Whereas for other civil litigation, it doesn't seem to be so, that the pre-litigation is a mandatory one. And the rules made thereunder. Now the other subsections are a bit relevant only for the purpose of completion's sake. It shall be applicable to the tribunals notified by the central government or state government as the case may be. This is what many of our speakers were also saying. This act seems to consolidate all the provisions under various acts, like the Consumer Act, the Companies Act, the Arbitration Act, CPC 89, all seem to get it from here. And certain tribunals don't even have a mediation provision in their act. Those tribunals also now would ensure that they get this. Then for the purpose of 1 and 2, I'm reading clause 3. Who is a mediator? Who is registered with a council to empaneled by a court-annexed mediation center or empaneled by an authority constituted under the Legal Services Authorities Act, empaneled by a mediation service provider recognized under this act, shall conduct pre-litigation mediation. Now, this is also a very interesting one, the concept here. For conducting a pre-litigation mediation under clause 4, clause 2 and 3 of subsection 3, a party may request any person designated for this purpose by the high courts. So there is also an element during the pre-litigation mediation that a party's request or I would rather say wish is also kind of entertained if he wants a pre-litigation mediation. It uses the word party. So either of the party can also seek this, or an authority constituted under the Legal Services Authorities Act 1987 as the case may be. So for this purpose it can be the High Court or any other authority here. And the court-annexed mediation center and an authority constituted under the Act 1987 shall maintain a list of panel of mediators for this purpose. Now for Motor Vehicles Act cases alone, there seems to be a slightly different procedure here. If we may read 6, 7 and 8, notwithstanding anything contained in subsection 1 and 2 and the Motor Vehicles Act 1988, when an application for compensation arising out of an accident is made before the claims tribunal, if the settlement as provided in section 149 of that act is not arrived at between the parties, the claim tribunal shall refer the parties for mediation to a mediator or mediation service provided under this act. So this is the process of commencing under the Motor Vehicles Act. So far as the settlement agreement, this is where I have one view, which I would like to place before this gathering, where the parties arrive at a settlement agreement under subsection 6. It shall be placed before the claims tribunal. The word used is for its consideration. I'll read the next one and you'll be able to appreciate. If the parties do not reach to settlement agreement under subsection 6, a non-settlement report prepared by the mediator shall be forwarded to the claims tribunal, which has referred the matter for mediation for adjudication. So the word specifically used in 8 is for adjudication, but the word used in 7 seems to be if a settlement agreement is arrived at, there seems to be a little bit what I call always as like an oxymoron. You have said that settlement agreement is arrived at, then where is the mind of the court going to come there to apply for consideration? Is there going to be any change in the multiple or any change in the compensation calculated? If it's a clerical mistake or so or a typographical, fine. But the word for consideration could mean wide. It requires maybe a reading down in some judgment. I'm trying to raise that only because when there is no settlement agreement, naturally it goes for adjudication. So motor vehicles alone seems to have this one particular advantage or disadvantage under 7. We'll have to wait and see. So I've just tried to sum up so far as 5 is concerned, what are all the concepts which we need to keep in mind. Irrespective of any pre-existing mediation agreement, pre-litigation mediation can be resorted to. So it's not necessary to have a written pre-litigation mediation or a mediation agreement. Parties, the moment the litigation commences, you can start the process. Commercial disputes, specific value, the provisions of 12A applies. 5.3 prescribes who are all the mediators and registered under which, I would say, authority. And the court-annexed mediation to maintain a panel. Claim for compensation. And the last one is exactly what I mentioned. for consideration and for adjudication. Just for the purpose of information, whatever presentation I'm doing, I may not complete it fully because of some slides could be a little bit detailed, may take over 45 minutes. So I've left the presentation with the institute, meaning the center. Whoever would like to take it can ask a mail to be sent. They will give the full presentation. Now, so far as the Indian story is concerned, we saw the pre-litigation mediation provision. These are the remaining ones which you will generally find under the relevant act. 89 of CPC, 12A I had mentioned, 37 of Consumer Act, 442 of Companies Act. These are predominantly the provisions under the, at the moment, statute seems to refer to some of the provisions. Slightly comparing it to the global model, naturally we always try to look at the American model first. We try to see it and water it down to our requirement. So the ADR model, I would like you to see the bullet number 2. So in 2019 in New York, all civil cases in county courts shall be referred to mediation as a first step before they enter the courts of that state. Now that is slightly different from the provision what we saw in 5. It is not shall be referred. The pre-litigation mediation is mandatory for 12 capital A, but not for all other cases. So that's different from the Western model. It's called the presumptive ADR model. That is, you have to presume yourself and get into this ADR model, go through, see it, and come back. For matrimonial matters, a system of neutral evaluation, which is also a first chance at mediation, is being followed in family matters. In these cases, mediators are called evaluators. So in matrimonial disputes. They also have what is called as ADR initiation forms, which are issued to all parties to fill up their case history in that state. So you give the case history itself and go through this process mandatorily. Canada has a slightly different one. Their Superior Court of Justice, it sets out a mandatory mediation program for certain civil cases. What we saw in US was mandatory for all, here certain, by introducing a rule, and for the states of Toronto, Ottawa, and Windsor. So they also went state-wise. Here, I'm trying to show it because US has a mediation act for each state. It doesn't have for the whole country, whereas we live on a law which always comes for the whole country. So that is how we work. This rule makes it mandatory for all the parties to attend the mediation session earlier on in the litigation process. However, if the same does not work, the parties could go ahead with the trial, and it is noted that 90% of litigated matters come to a form of settlement before the trial itself. So that's the success rate what they have seen in the pre-litigation model in Canada. Now some of the other countries, I'm just drawing 2 more for the comparison because pre-litigation is for the first time going to be tried a lot under our act. So Turkey brought an interesting one, that's why I brought Turkey and Italy alone. It amended a particular law which mandated pre-litigation mediation for labor disputes alone. So each one in their economy, in their culture, and in their environment decide also specifically where it's required. So there for labor disputes. Now we have been a little bit far-reaching for the simple reason we have not bogged ourselves down by saying it will only apply to one particular class or does not apply. The Schedule 10 no doubt is there. Apart from that, we are very clear it should apply for everybody unless excluded. Italy also passes a law in 2013 making it mandatory to try to mediate certain cases. According to this law, the parties must meet the mediator in the first meeting, which would bear a nominal cost. So there they are even trying to charge it. Though the state is going to bear it, you will see. However, skipping it would entail a penalty. So you can't skip it also. The parties can then make a decision whether to continue with the mediation, wherein the government would provide a tax credit of 500 euros of the fees. So if you pay and get out, you still get a tax credit if you have gone through the pre-litigation mediation process. So each one is trying to incentivize also to see can the pre-litigation mediation be, I would rather say, encouraged as much as possible. And some of the points I felt for pre-litigation mediation, I took it from our senior advocate, Mr. Sriram Panchu's book, in mediation, law and practice, so I need to give him the credit for having himself jotted down some of the points. Insofar as our environment is concerned, we are keeping it towards our litigation system. Sensitizing clients on the value of mediation. Now this is about the parties who come there. We already do our mediation process. When they come, we call it as introduction to mediation or trying to introduce ourselves. What is the problem about mediation, or what is the benefit you will get out of mediation if you are wanting to litigate, and the litigation costs. So try to sensitize them about it. Highlighting the possibilities of a settlement. The greatest advantage of being a mediator is you're always positive. You try to give a vibe that you are going to go through a settlement, you have come here, that is a great effort. We try to encourage them that they're sitting at a place where both parties are on the same table. We make it more encouraging. Awareness of legal costs in court proceedings. In a lighter vein, being lawyer and being a mediator is like a conflict in itself. On one side, litigation gives a different kind of fee structure, in a mediation gives a different one. That is where the conflict seems to come, both from the West up to, or rather the Indian scenario, or even another third world country. Do the litigating lawyers lose the fee, or do the mediators make the fee? In the Western economy, it's a kind of a fight between the two always. In a law firm, the mediation cell is also there, the litigation cell is also there. The mediation cell wants a solution, the litigation cell wants the same case to be taken to litigation. Who wants to do what? That was what we saw in a training which was done with regard to mediators in the West. They say that the litigation lawyer only wants the litigation, and the mediation lawyer wants only the mediation for the same case in the same firm. Emphasis on the start and end of legal proceedings and the mental makeup. How you keep your mind and your, I would rather say, philosophy occupied to see, can we end that process? Evaluating the type and genre of clients. Now that is a very important factor, because if it's a company, if it is an individual, if it's a partnership, family, so what is the concept of client which is there available, and the manner in which it could be sorted out. 90% of us talk in our environment more about family issues, not just about corporate. Corporate is just one side of it. Companies fighting, trademark dispute, or other money claims. But 90% of the fights come only based on human relationship or family relationships. And measuring the mandate of pre-litigation dialogues across cities. The last two words are very important, across cities. We try to ensure that we mold ourselves to the required environment in that city. Giving an example is, the filing system itself will change city to city, high court to high court, court to court. So if we, in our litigation practice itself, see so much of changes, though the rules are the same, the provisions are the same, still the practice rules of that high court will make it. If we take Tamil Nadu itself, the filing system will be a slightly different, I'm not saying completely, 5 to 10% different from each place. So applying that also to pre-litigation dialogues, a mediator who is trained in a particular format will have his own method of approach based on his culture where he has come from. So how he puts up. So this is where in the pre-litigation mediation, our mindset is more important, both as a litigating lawyer and a mediator on one side, and as a judge who is going to refer a matter to mediation, or who is also sitting in certain pre-litigation mediation if the situation warrants it as required. So this brings me for putting across certain points which I felt are a nutshell for section 5. Now next would be online mediation. This we heard the Honorable Supreme Court Judge, Justice Sanjeev Khanna, mentioning in the morning how much confidence he has now put in training itself for mediators. It will have its own challenges. It will have its own, I would rather say, slow movement, but the process has started. Mediation, which started in 2004, here in 24, we are sitting 20 years down the line with so many mediators, and the law itself coming into force in 20 years. The online mediation is also one which is permanently going to be there, because we all know in 2020, when we had the online hearings, nobody thought that we'll have virtual hearings. When we had the technology already ready with us, it was just that we were not ready to accept it or adapt it into our system. So for this, two of leading American, I would rather say, mediating field professors who are also involved in online mediation made a beautiful statement. If the mediation field does not seriously consider the implications of technology's impact on society and the profession, we may lose the next generation of mediation parties, practitioners, and scholars. So we all know that most of us have moved towards, apart from a laptop, even to iPads, or even, I would rather say, notepads, whatever electronic pads we can do to the maximum possible. If we are unable to do it, we at least have somebody next to us who is slightly upgraded, either as a junior or a staff, or somebody who is aiding us in learning what to do. So we are now in the transition. Our generation is a transitional generation. for this section 30, and I must mention all the three provisions are not yet notified. Whatever we are seeing is only the theoretical side of it. So what is to come is what I'm going to tell you, and not what is already happening. Only Justice Bharat Chakravarti beautifully mentioned which are all the provisions notified. What I'm speaking about, all the three provisions are not yet notified, but what we will face as and when it comes. So in section 30, online mediation including pre-litigation mediation. So they are giving the option that even in online mediation, you could do a pre-litigation mediation, may be conducted at any stage. So one thing is pre-litigation mediation naturally before the suit commences, but an online mediation could commence even after the suit commences or a proceeding commences. So the word at any stage of mediation under this act. So if a mediation is going through, I can switch to online, offline, online, offline. So it's left to the parties. We are doing it in fact in few matters, no doubt in certain commercial matters. If parties are intercity, you can't fly them from Hyderabad, Bombay, everywhere. Online mediation without following these rules is still happening practically. But whether it is happening as per the act, well, we'll have to wait and see because they are bringing out certain norms. Then, with the written consent of the parties, including by use of electronic form or computer networks, but not limited to an encrypted electronic mail service, secure chat rooms, or conferencing by video or audio, both, or the process of online mediation shall be in such manner as may be prescribed. We'll have to wait and see what the rules are. Now, this 3 is a very, very important provision, 30 clause 3. The conduct of online mediation shall be in the circumstances which ensure that the essential elements of integrity of proceedings and confidentiality are maintained at all times. Till this, no problem. The next part is where I would like you to consider. And the mediator may take such appropriate steps in this regard as he deems fit. Normally, in a mediation, I would rather say the provisions in the act or in the procedure or the rules, there is no discretion left to the mediator in a manner how to act. We all know what to say as opening statement, how to have when to have a caucus session or when to have a private mediation session or so. We decide based on the case. But for the purpose of conducting online, 2 seems to prescribe a procedure. 3 seems to provide a kind of a window for the mediator in his discretion or as he deems fit. Whether the rules give a particular one or not, if he wants to fill some gap somewhere, there is a process available there with a paraphrase for the purpose of integrity of the proceedings and confidentiality. Now, when the rules come, you will know how to maintain the records, where you should meet. I mean, it will say more or less like you can't meet the parties in a private place. You should meet only in a mediation center. It should be fully recorded. If we go under the commercial laws, when we have video conferencing facilities, there are rules how you must record those proceedings. Let's take, since I know a little bit of company law, so in company law when you have board meetings, you have audiovisual means. People from around the world sit down in a board meeting, and so therefore how to record and keep that. Applying the same analogy here, if a mediation is done online, are we to record and keep it? If you're supposed to record, is there any confidentiality? If you're not supposed to record, which portion not to record, what to record? So that, as he deems fit, will be the place where we need to wait and see how the success of online mediation is in future. Subject to the other provisions of this Act, the mediation communications in the case of online mediation shall ensure confidentiality of mediation. Now, this 4 reinforces the fact, if it's a confidentiality issue, how much private we can keep the whole process. So the Ministry of Consumer Affairs, Government of India, tried a particular model for consumer disputes, and they chose the National Law School, Bangalore, for this purpose. And 2 professors, Professor Ashok R. Patil and Professor Sri Krishna, they both kind of led this whole project. So if you see the first bullet, the ministry established the Online Consumer Mediation Center, OCMC, in 2016 at the National Law School of India, Bangalore, for unburdening the consumer fora of the massive caseload. Now, more or less online, all of us know all our children on a daily basis buy something. Some box will be arriving at our house, right from a small clip, if it's a daughter, up to a maximum of a cream, which will be the costliest one. If you have a daughter, you'll know. I have one, so I'm saying that. So as a father, I know it. That's why I'm saying. Not that I don't pay for it. The point is that we have to live with it. It's a pleasant experience also, no doubt. So that being the case, suppose, let's say she doesn't like that product. But the point we all say is she has wasted the money. No. Can she have an online dispute forum where I want to bring this company, because without using any names, people say that there are products which are sold which are of spurious or in some other quality which are not of good value. But most of us don't have a forum under which we can kind of pull these people up and get a refund. Now this Online Mediation Center for Consumers, OCMC, has really proven a little bit more, because almost all matters have been settled is what when we see. So they say, I only read the underlined portion, I don't read the remaining. The core value of the center includes easy accessibility. So on the click of a button, we'll ensure that your complaint is registered. And on a click of a button, the other side also gets notice. And then he has to respond. If he doesn't respond, he gets kind of charted or marked. Security, confidentiality, cost-effective, neutrality, and integrity. Now, this, you will see the one. The Bangalore Center is a pioneering initiative in forming a robust online platform for online mediation in consumer cases. Now, nobody for 100 rupees or 200 rupees is going to come to lawyers asking them to issue even a legal notice. Even that will cost more. But whereas if you have an online system which is automated, then it is very easy to file a complaint and get some relief. This is just to show how online mediation could work. So it goes through a process. The online platform covers e-commerce, e-mediation, e-negotiation in a consolidated method, and has created a database for posterity. So they've ensured that they've created such a large database of people who have given these complaints and taken it through. And this online platform also facilitates mediation cases where the disputes are deeper and needs to be contested. This is a Government of India initiative. And these two persons, the professors who had actually modeled this, they gave about 9 points. I'll read only you see, firstly, the consumers can file complaints online in their home or office. Secondly, they can negotiate and try to resolve directly with the companies online. Thirdly, they get the flexibility of getting it resolved by sitting in office, home, restaurants, parks, or any other place they want. So you don't come to a formal place for mediation. You don't have a date fixed, time fixed. Fourthly, they can give out a bid or reply to a bid at any time, meaning if I need the money back, how much is he willing to pay, how much I'm willing to take, so that bid keeps going up and down, and at any time of the day, night, as they want. Fifthly, all communications are confidential. Sixthly, the most important one, very cost effective and also very less time effective. Seventhly, e-mediation process where the e-mediator can be appointed online by their consent, nominated on their behalf, and the whole process is also online. Eighthly, the conversation, again being a record, can test the impartiality of the mediator in check. And last, ninthly, settlement is also online, which is binding and enforceable under the Arbitration and Conciliation Act 1996 or as an e-contract. Lastly, e-mediation always ends in a win for both parties. Because here, they have also found a solution, because otherwise people will be writing, the social media, when they don't like a product, you'll go to all the websites and all social media and write about them. This company is bad, they've done this to me, or this XYZ. You avoid that also. So therefore, the essentials of section 30, which I would like to sum up in one page, is whatever you have heard. I don't want to read it again and explain. I think I've said enough. Yes. Which one are you saying, sir? Subclass 3, yes. I'll just read it for the benefit of everybody, and it will be easier. The conduct of online mediation shall be in the circumstances. I think I'm requested to read section 30, clause 3 again to have a view. I'm just reading 30, clause 3 for the benefit of the audience. The conduct of online mediation shall be in the circumstances which ensure that the essential elements of integrity of proceedings and confidentiality are maintained at all times. So these two are the requirements for 30 clause 3, that is integrity of proceedings and confidentiality. If you use the word essential elements of integrity of the proceedings, it is an all-encompassing word which starts from the data. The question put to me is, for the benefit of everyone, the word integrity of proceedings, does it mean the collecting of data or the data point is what is the question being put up for consideration? My humble view would be the integrity of proceedings would mean right from the start when the mediation commences with the information exchanged between the parties and whatever information collected, either documentary or evidentiary, both oral or so, that to be maintained with the word called the next one and confidentiality. That is what is the context. In my view, again, these two will find its place in section 30 clause 2 because the rules will say so anyway. All proceedings are confidential. All discussions are to be kept confidential. The mediator should be integrity oriented even online. He can't ask anybody else to join. There will be a lot of things. But this seems to add to section 2 where there are going to be rules, a separate section to only re-ensure that the online process has to be both integrity of the proceedings and confidentiality are maintained, which are the two fundamental pillars for a mediation. In a mediation, whatever you have physically, in an online process also you have that. All I am trying to say is what additional steps the mediator has to take in this regard, it leaves open with the words called as he deems fit. Now that is where for our local, I would carefully use the word, our practical situation on the ground. Because we do feel in certain situations there are complaints also about mediators. They are trying to push for a settlement or they are trying to stop one party from speaking or our own personality issues may come up. So my point which I threw up was the interpretation of the word as he deems fit, only from that context. But you are perfectly right. Integrity of proceedings and confidentiality of everything including data. Anything else for me? So essentials of 30, I have tried to kind of summarize what is written there. A little bit of, slightly little bit more technical, the American scenario where they have tried this. I'm not going to read everything, it will be in the notes. Just the subheadings alone. Organizational support app. In fact, they have gone to the stage of even developing apps for this. Can we have online app? So if you want a particular model, private parties have started running apps for mediation, where online, if you have a problem with any company, you go through their app, they'll have a panel of mediators, that mediator will immediately get in, and he'll reach out to the other company side and pull him in. So this kind of organizational support apps for entrepreneurs particularly, forget the consumer side. Even the entrepreneurs want that because they don't want litigation. Litigation costs are very high in the Western world, so easier to finish it at the mediation level. Then decision-making tools. So decision-making tools is you give a drop box like saying, if you go through mediation, this is the provision. If this is the provision, what all can I click and can I get as services? So that kind of self-made decision-making tool itself will be given. You know, when you go in to register somewhere, it will automatically be giving and asking questions yes, no. It is in that format. And the last one, between sessions collaboration, which normally happens only in a multi-session mediation or a multi-party mediation. So how technology can help mediators and clients to move forward. And the last two lines you will see, this is relevant in the case of like you have a Google Drive or a Dropbox or a Google Docs. We know that in Google Docs, you can compare documents, one person can read it from somewhere else and he can correct the document, I can do it. That is just for showing from the lawyer side that we correct it. Same thing can be applicable also for a mediation model where two parties sit from in two places and try putting in their points and I would rather say collaborating these documents and move closer to an agreement. So a single agreement, we don't need to mail, get it back, send it back, but sit it in live, each one trying to put their comments on the document. So the London School of Effective Dispute Resolution, which normally does some kind of recommendation, for the purpose of online, it says, take the technological support, like Google Meet, Zoom, which are the platform you're wanting to use. That is a technological support. Logistics of joining the platform. Do you have enough internet speed? You know, sometimes when you just say you're doing it online, but if you don't have the speed, even your face will be completely frozen. So, do you have the logistics for joining the platform? Recording of proceedings, that will be a very important one. When we call it confidential, is it to be kept confidential means, is it to be recorded or not? How do we keep a track of what was discussed? Is it noting down again? And the last one, working in advance. And as usual, we are supposed to read the case brief and come as a lawyer. So as a mediator also, we are supposed to have an advance of, because in online you don't get to meet the parties physically, whereas when they come to a mediation center, you try to meet each party wise, you ask each one what is the problem. You have some kind of previous knowledge about the actual issue. But online, unless they send a case brief or a short note, you will not know. Otherwise, there must be an interface of an institution who will refer to the mediator a short note on the problem and tell the parties this is what has gone to the mediator. So we have to work out all these mechanisms. Simply not go online from one side, press the button, say that the mediator is available here, and these are the two parties. It's not possible so easily at all. And I would like to bring that WIPO has a checklist for online mediation. All this is available. I don't want to waste your time. I have another 9 minutes for the other one. So effectively, this is one slide which I wanted to share in the context of Honorable Justice Sanjeev Khanna, who mentioned about mediation training in the morning. He had virtually said a 40-hour training process which is to be done. In fact, even now you can join a 40-hour online training by Harvard Negotiation Institute, which is run by Harvard Law School, from here. After COVID, they also started. I'm not advocating for it. The point is they have a particular model in which how the teaching and the training notes have to be done. It's a very short one-page model which they have made. This has to be extrapolated depending upon the course, how long, in which country or which jurisdiction they want to do. So this is just one I wanted to place, but it will be available in the presentation. Now, community mediation. This is absolutely going to be a very, very academic one for the moment. Absolutely academic. With the great respect to Mr. Sriram Panchu and Mr. Kalifullah who are there, what they had done in regard to the Ayodhya dispute itself was a community mediation appointed by the court. Effectively, two groups of people, whether they were litigants, but a community mediation necessarily need not be out of a court process. It could also be through a non-court process, like a pre-litigation. So the Mediation Act 23 envisages this. Section 43, effectively, I'll just read 2 or 3 portions alone of this provision. 43.1. Any dispute likely to affect peace, harmony, and tranquility amongst the residents or families of any area or locality may be settled through community mediation with prior mutual consent of the parties to the dispute. This is nothing but what we see, whichever Tamil or whichever language movie, a gentleman coming and sitting in the center, what we used to call as Ur Panchayat. The same thing now codified, 43.1. No difference, exactly the same thing. The same gentleman who will say this person walk that side, that person walk this side, at least there they will listen to him. Whether here the dispute will get settled or not, we are not absolutely sure at all. For the purpose of this subsection, any of the parties shall make an application before the concerned authority constituted under legal source authority or the district magistrate or subdivisional magistrate in areas where no such authority has been constituted for referring the dispute to mediation. So when we notify it, we'll be able to see. It is possible that when a 144 or a 145 proceedings, is it possible for the purpose of communal harmony attempting this in some form? No doubt a criminal case cannot be referred to is what we heard. I heard Ms. Uma Ramanathan also talking about section 138 matters can it be sent, even though it's got a criminal nature, but it's more out of a contractual event. So in that situation, can we try to have these kind of two villages, two communities or two groups? Is it possible? This will be a very nice area to watch in future for local dynamics. In order to facilitate settlement, I'm reading 3, of a dispute for which an application has been received under subsection 2, the concerned authority constituted under legal services authority or the district magistrate or subdivisional magistrate, as the case may be, shall constitute panel of 3 community mediators. Now this is a very important one. Luckily in our profession alone, a cardiologist can also be a general physician. All of us know what I'm meaning. But whereas it's not possible in medicine or engineering anywhere. A computer engineer is a computer engineer, an electrical engineer is an electrical engineer. Tomorrow morning I can go and do a trial. It's the pain of the judge to listen to whether I know the law or not and pass a judgment. This should not happen in community mediation. It is a very, very, very sensitive one, because community mediation is not simply one gentleman going there and they immediately come and listen to him. That must be a person who is respected both in community, not exactly, both of them should have had prior knowledge about him. We easily mentioned Mr. Justice Kalifullah's name and Mr. Panchu because we know that they are very leading personalities in their respective fields. So when Supreme Court appointed, the point is we all know them already. But if you're appointing somebody who is not known, the person will not have the respect even listen to them first. So the community mediators who are actually empaneled should be not just lawyers or should not just be a person of repute alone. He should be having a different caliber. I'm not able to say how, but the point ultimately is acceptable could be one word which I try putting. Then 4 I'm just skipping. Please see 5 they try to give for that purpose what I was mentioning. The following persons may be included in the panel referred to in subsection 4. Now 4 you saw was who are all the community mediators who can be included. Person of standing and integrity who are respectable in the community. Any local person whose contribution to the society has been recognized. Representative of area or resident welfare association. Persons having experience in the field of mediation and any other person deemed appropriate. So you will find for a moment here, the normally trained mediator is not the person who can effectively be a community mediator. It's a wider concept. The trained mediator comes only as one person in D. Otherwise, he just knows the process, but not effectively community mediation. The features of 43, effectively whatever I've just said, I've tried summarizing this here. Now, community mediation has 2 parallels, which I was able to search and get. One is in the state of US, or the United States of America. It has begun right from 1960s onwards, and in 1977, they brought it for neighborhood, particularly for the colored persons versus non-colored. That's how it started, and from there it kind of developed into the area-wise, and an analysis of all particular models were analyzed before doing so. The evolution is what I'm trying to say. I don't want to trouble you more here. The US experience has been a very, very good experience. There are enough models here. Some methods. I'll straight away take you the next one to the Singapore one. Now, Singapore was even more advanced. In 1996 itself, they brought what is called as a Community Mediation Act, which they brought Community Mediation Center Act in 1997. They ensured that under Section 11, it was a family, social, or community dispute not involving serious penalties. So, this community mediation has been easier in Singapore because such a small group of few lakhs, and the area was also very small, smaller than even Chennai. So it is easier to introduce it there, but not to find fault that we cannot, but it has had its experience earlier also. Now if you see here, the nature of disputes cannot be large contractual or commercial disputes involving legal proposition. So if you feel the moment it touches the word commercial, if people are fighting over land, people are fighting over some kind of property, in our sense it could be relating to a temple right, it could be relating to some kind of a customary right or a traditional right. Those all will lead to community mediation. So these will be not having a commercial or a contractual nature. The applicant and respondent should approach this voluntary process, and then a subsidized fee of about $3 is charged. Here we will not be charging anyway, because when we come to mediation, even contractual we don't charge any fee right now. So this is how it is taken, and the community mediation takes forward the, is it possible to get a solution or some kind of a meeting point there. So, yes. 44.4. Procedure for community mediation. Any settlement I'm just reading the request made, I just have 2 more minutes which I'll be closing. 44.4, any settlement agreement arrived at under this chapter shall be for the purpose of maintaining the peace, harmony and tranquility amongst the residents or families of any area or locality, but shall not be enforceable as a judgment or decree of a civil court. Now, we also know, exactly. So, if you see here, even a settlement agreement, unless it's registered, which we saw in the previous, so the moment it is entered under this chapter, it is just for the purpose of ensuring that there is an understanding between the parties. It will not become like a decree or an award or in any manner a judgment. Thankful to you for having pointed it out. Yes. You're talking about 27? Yes. Subject to the provisions of section 28. I'm reading 27.2. Subject to the provisions of section 28. I've been requested to read section 27.2, if you can follow. 27 talks about, unfortunately I don't have the Act soft copy. If you all have the books, if you can see section 27, the question is subject to the provisions of Section 28, the mediated settlement agreement shall be enforced in accordance with the provisions of the CPC in the same manner as if it were a judgment or decree passed by a court, and may accordingly be relied on by any of the parties or persons claiming through them by way of defense, set off, or otherwise in any legal proceeding. So, subject to Section 28, you know that challenge to the mediation process is there. We are not on that. I fully understand the word settlement agreement there. Will it take into account 44 is... Yes. Yes. It depends on the facts of the case. You're absolutely right, because as everyone said in the morning, the act is yet to be tinkered. When it comes before you all for interpretation, I think these kind of cases are surely going to be there. We just wait for some interpretation in that manner also, because the word settlement agreement itself, whether it takes into account 44 or not, we don't know. And even otherwise, if it's not taken, at least there it had 44.3 to exclude it. But here, the same settlement agreement is not to be taken or to be taken into account in a future proceeding. It's a subject matter. I mean, then there's no value for that settlement at all. Thank you very much for that. And lastly, I'm just giving some closing thoughts for this. Does India have the infrastructure for mainstreaming online mediation? I'm leaving it as a question open. Does our mediation ecosystem have the mind to accept community mediators as a valid and acceptable form of mediators? Yes. I would like to paraphrase it by saying, the corporate law, like the US model, has what is called as class action. For everything we have class action there. We brought the law here. It's from 2016, for 8 years, still there, but not yet effectively being implemented. The same way, community mediators, it's a far-reaching and a very, very long foresight thought. It will have someday, but not today, so we should not wash it away. How is the relationship between the mediation ecosystem and the mediation council going to be? Because there is a mediation council contemplated under the Act. Is the mediation council going to be over and above, if I may boldly use the word, above the Supreme Court Mediation Committee, above the High Court Mediation Committee, and will they frame everything? How it is going to be, we need to see the power dynamics. Can pre-litigation mediation be extended to other types of disputes, including corporate law-related litigation? Because there is no pre-litigation, but the tribunal word seems to bring in. We'll have to see how now while implementing. Can mediators get a chance to study and analyze the mediation frameworks in comparable jurisdiction after the 23 Act? Like how I placed for 2 countries, is it possible to study others? Can there be an industry professional law school connect for this field in future? We saw for online mediation, National Law School, how they had built up for online. Can it become a collaboration between all 3 so that the students at that stage itself are involved to bring this forward? Thank you very much for having given me the opportunity. I've shot up by 5 minutes. Thank you very much.
Sir, please stay on the podium for a moment. Thank you very much for the lecture on 3 kinds of mediation and comparative study of the parallel systems prevailing in US, Canada, UK, Singapore, Turkey and Italy, and also on the planning for the Indian scene. Now we request Honorable Thiru Justice V. Sivanyanam, Judge, Madras High Court, Committee Member, Tamil Nadu Mediation and Conciliation Center, to honor learned resource person with a book and sapling.
Hello, excuse me, sir. Okay.
Thank you, Lordship. Thank you, sir.
Sir, one suggestion. Community mediation, if it is implemented at various places, Katta Panchayats, there is a chance to come down.
That's not a question, that's a nice view.
Yes, thank you very much.
The next session is upon Mediation Council, its functions, powers, and registration of settlement in pre-litigation mediations, for which we have today Mrs. Geeta Ramaseshan, who is known for her work in upholding the rights of women. Madam is a famed commentator on gender issues. Welcome, Madam.
Good afternoon, everybody. It's a very difficult task to follow all the persons before me, and especially Arvind, who has made this very brilliant PowerPoint, taking us all across the globe, looking at various processes and countries, and then to have to talk upon the Council, which is under section 31 to 39, 40 to 42, of course, and 20. So I would first start with the Mediation Council of India, and I'd appreciate if you all take a look at the Act. And at the beginning, I also thank the committee for having selected me to share my views and take you all through this process with reference to the Act. Now, it was also mentioned by Justice Bharat Chakravarti in the morning about the structure of the Mediation Council of India. I mean, he indicated it's like how we have a medical council, we probably have our own bar councils, etc. But of course, this is something completely different the way it has been structured. And at the cost of repeating what the others have said, please bear in mind that what we are discussing today is not court-referred mediation, because all of us are confined to that. We have been trained in that, but we are looking at mediation overall from a much broader view, addressing mediations which are not court-referred, addressing mediations that come at various stages, addressing pre-litigation mediations, etc. This is very important for us to bear in mind when we look at how the Mediation Council of India has been structured. So if you look at section 31 in the Act, it provides for the establishment and incorporation of a mediation council to be based in Delhi. This is called the Mediation Council of India. It is in that sense a structured, centralized body operating from Delhi. The Act does not contemplate different branches of mediation council in other parts of the state, nor does it look at regional councils to be established at different parts of the state. However, in subsection 4, it does provide that the council may, in consultation with the central government, establish offices at other places in India and abroad. Now, whether these would be understood as regional councils, it remains to be seen. The structure of the Mediation Council of India, again, we need to bear in mind, the rules of this have yet to come. So unless the rules come and are notified, we will still not have much of an idea as to how the process is exactly going to work through. Be that as it may, if we look at the Act, at 32 it talks about composition of councils. The council shall consist of the following members, namely, a person of ability, integrity, and standing, having adequate knowledge and professional experience or shown capacity in dealing with the problems relating to law, alternate dispute resolution, preferably mediation, public affairs, or administration, to be appointed by the central government as a chairperson. So it could be an executive person, because it looks at a person who is also having the ability or who is an expert in public affairs or administration. It is not confined completely to a person just having legal knowledge. B, a person having knowledge and experience in law related to mediation or alternate dispute resolution mechanisms, to be appointed by the central government, who is a member. An eminent person having experience in research or teaching in the field of mediation and ADR laws, to be appointed by the central government as a member. Then, of course, a secretary to the Government of India in the Department of Legal Affairs, a secretary to the Government of India in the Department of Expenditure, Finance, etc., chief executive officer who is a member secretary, one representative of a recognized body of commerce. So these are the members. It does not, unfortunately, I think, have any mediators in this composition of a council, nor does it have a judicial officer who, I think, if one were to actually look at litigation and the understanding of litigation that comes to a judge, would actually be far greater and far higher. Be that as it may, this is how the council is composed, and this is how it goes through. Now, if you were to skip section 33, 34, etc., at 36, it does provide for appointment of experts and constitution of committees. So the council can appoint various committees. It does not, and the committees can be appointed maybe not just to be centralized in Delhi alone, but the committees it does have a lot of, in that sense it has a lot of liberty to and power to address committees at different parts of the country. And the council may appoint these experts as it may consider necessary to discharge its functions on such terms and conditions as may be specified, which means we'll still have to wait for the rules. Now, if 38 is where the duties and functions of the council come, literally meaning actually if you look at it, the powers of the council too. If you look at section 38, you come through the first one, endeavor to promote domestic and international mediation in India through appropriate guidelines. Endeavor to develop India to be a robust center for domestic and international mediation. Point C, lay down the guidelines for the continuous education, certification, and assessment of mediators by the recognized mediation institutes. We will look at how mediation institutes are created also under the Act, but it will be this committee which will actually formulate the syllabus in terms of the continuous education, the certification, and also the assessment. Now, how it would, again we'll have to look when the rules come through as to what are the formulations and guidelines that the committee will do in order to assess mediators by the various recognized institutes. It is yet to be seen. Now, D, of course, provide for the manner of conduct of mediation proceedings under subsection 1 of 15. If you look at 15, we'll find that mediation process shall be, the 15.1 just talks about the mediation process to be conducted in the manner as may be specified. 2, of course, talks about the various methodologies of mediation that we follow, and namely how we, confidentiality, voluntariness, self-determination of the parties, and the standards of professional and ethical conduct that are specified, which we follow as court mediators in the guidelines that are issued and in the training that we saw. But we are now, the committee will be having the committee can constitute rules and lay down the guidelines and provide a manner in which mediation proceedings can be conducted. E is where committee can provide for the manner of registration of mediators and renew, withdraw, suspend, or cancel registration on the basis of conditions as may be specified. Once again, at the cost of repetition, please remember we are all court-referred mediators, and what the committee is looking at is a much broader, wider spectrum of mediators that will come through in the near future. And hence, how this, in a way, if you see this, withdraw, suspend, or cancel registration on the basis of conditions as may be specified, it will be the committee that is going to be the authority that will decide the basis in which there can be a suspension or a cancellation of a mediator, or of the registration of a mediator from carrying on his profession. To that extent, this is a very centralized law because, let's take, for example, a mediation is conducted, a complaint is given against the mediator, complaint is sent to Delhi, And we are expecting that the rules will provide for a due process on the basis in which such a complaint will be taken note of and an inquiry will be conducted. I mean, that has to be a part of a law, and I'm sure that will be formulating itself in the rules. Be that as it may, then, the centralized process of mediators from across the country to participate in a inquiry, because we are looking at suspension or cancellation of the registration, makes it very difficult. And unless the committee which in the beginning of the rule has stipulated that the council can, in consultation with the central government, establish offices at other places in India and abroad. So unless these offices are set up in different regional offices at least, the council will have, it will be a very centralized body which the council actually takes down upon. If you look at F, the council lays down the standards for professional and ethical conduct of mediators under subsection 3 of section 15, which is again looking at what is the process of mediation that we have been trained. And we have to again note the fact that our training has gone into all these processes by the module that has been created by the Supreme Court and by the rules that have been formulated by our High Court. But these are very important for mediators who are not part of a court process, who are not lawyers, who are going to be drawn from all over, on all walks of life, as the Act stipulates. And hence, in such situations, this will be the committee, the council that will lay down the standards for professional and ethical conduct of mediators. Now, of course, holding trainings, workshops, and courses in the area of mediation in collaboration with mediation service providers, law firms, and universities. That's the academic research part. That is the work of the council. You take it down to enter into memoranda of understanding or agreements with domestic and international bodies or organizations or institutions. Now, recognize mediation institutes, that is an I, mediation institutes and mediation service providers, and renew, withdraw, suspend, or cancel such recognition. So E and I are almost go together in terms of the powers of the council. So I would word it as the powers of the council more than the duties and the functions of the council. Yeah. Then you go to J, specify the criteria for recognition of mediation institutions and mediation service providers. So it will be the council. I mean, if I were to draw a parallel, just like how our bar council recognizes the institutes for legal education, I mean, grants recognition for law colleges, etc. Here too, it will be the council that will specify the criteria for recognition of mediation institutions and that of mediation service providers. Then lay down standards for professional and ethical conduct on the mediation institutes and mediation service providers. Publish such information that relates to publication. Maintain an electronic depository of the mediated settlement agreements made in India and for such other records related thereto in any manners as may be specified. Morning questions were asked with reference to maintaining the document, and I'll come to section 20 and share with you in terms of registration of agreements, and there are certain conflicting issues that have emerged when some of us were discussing about it, which we would take a look at. If now the last one, of course, is performing any other function. Now if you come to chapter 9 and you look at mediation service providers and mediation institutes. A mediation service provider under section 40 is a body or an organization that provides for the conduct of mediation under this Act and the rules and regulations made thereunder and is recognized by the council. So example was given by Justice Bharat Chakravarti in the morning as to how, when we have so many arbitration centers, you can have mediation centers. There are mediation centers like FCDR, etc., which Umar Ramanathan and other lawyers have started. And therefore, these are, under the Act, they would come as mediation service providers because they are a body or an organization. They are not individual mediators. They are a body or an organization, and this body or an organization provides for the conduct of mediation under the Act. They will now need to seek recognition by the Council. B is any authority constituted under the Legal Services Authorities Act. C, a mediation service provider, a court-annexed mediation center. Okay, here again it's the body, not the individual. The court-annexed mediation center is a mediation service provider. And D, of course, any other body as may be notified by the central government. However, provided that B, C, and D, that is the body under the legal service, the authority under the Legal Services Act, the court-annexed mediation center, and any body created by the central government are deemed to be mediation service providers recognized by the Council. So there is no necessity for these three statutory bodies to actually go and seek any further recognition. But private bodies or organizations would need to be recognized by the Council. Then, the mediation service provider shall be recognized by the Council in the manner as may be specified. We still have to get the rules in this regard. 41 looks at the functions of mediation service providers. What is the role of these service providers? Accredit mediators and maintain panel of mediators. If you take C, that is the court-annexed mediation center, of which all of us are mediators, the center maintains the panel of mediators. It provides the service of mediator for conduct of mediation. It is expected to provide all facilities, secretarial assistance, and infrastructure for the efficient conduct of mediation. It is expected to provide the professional and ethical conduct amongst mediators and facilitate registration of mediated settlements in accordance with the provisions of Section 20 and such other functions as may be specified. Considering the fact that right now all of us are court-referred mediators, if you look at 41, the court-annexed mediation center is a mediation service provider under the Act, and that would be the nature of functions with reference to the court-annexed service provider. Now, I just want to, there is 42, of course, is a mediation institute. The Council shall recognize mediation institutes to perform such duties and exercise such functions as may be specified. And again, we need notification with reference to, the rules have to come to see what is the way in which the Council will look at these rules. I just want you now to look at Section 20, and since a lot of questions were raised in this regard. Section 20 talks about registration of mediated settlement agreement. Morning we saw the difference when the parties agreed to participate in the mediation process, it is called as a mediation agreement, and when they settle their dispute, it is then called as a mediated settlement agreement under the Act. Now, if you look at 20, for the purposes of record, mediated settlement agreement arrived at between the parties, other than those arrived in a court or tribunal referred mediation or award of Lok Adalat or final award of the permanent Lok Adalat under Section 21 or 22E of the Legal Services Act. Now, may at the option of parties be registered with an authority constituted under the said Act or any other body as may be notified by the central government in such a manner as may be specified, and such authority or body shall issue a unique registration number to such settlement agreements. So, mediation agreement entered in two parties, private mediation agreements can be registered at the option of them with the authority constituted under the Act. And once this registration is done, they are entitled to get a unique registration number. Now, provided that the mediated settlement agreement under this section may be registered with such authority or the body situated within the territorial jurisdiction of the court or tribunal or competent jurisdiction to decide the subject matter of dispute, namely where the cause of action arises. Let's look at it that way. Now, here again, explanation. It is clarified that nothing contained in this subsection shall affect the rights of parties to enforce the mediated settlement agreement under section 27 or challenge the same under section 28. We saw 27 and 28, which Jawad had already spoken about. However, you look at two aspects. The registration referred to in subsection 1 may be made by the parties or the mediation service provider within a period of 180 days from the date of receipt of the authenticated copy of mediated settlement agreement, provided that mediated settlement agreement may be allowed to be registered after the expiry of period of 180 days, etc. Now, let's draw an example. There is a mediation agreement. Let's look at a court-referred mediation agreement, because court-referred mediation centers are actually a service provider under the Act. Let's take, for example, parties entered into an agreement. Either parties on their own or the service provider can get it registered. But the question is that at this stage of registration, even though there is a choice left to the parties, how does one maintain the confidentiality with a different body? Currently, the mediation is entered into between two people. The mediator has the mediation agreement is given to one service provider. Now, if it is sent to a body which is created just for registering and taking note of all the, maintaining the records, can the and by providing a unique registration number, etc., how much confidentiality can be kept? What are the rules that would relate to with reference to the way in which this is maintained in the body that is specified or notified by the central government is something that we actually need to consider. And I think that would be, so there are therefore these kind of hiccups in various ways under the Act. But morning when we had a discussion with Mr. Sriram Panchu, there's one suggestion that he has made which I shall share with you. One is that it's only the Act that has come into existence now. The rules have yet to be notified. And I think most of us can at least participate in the process in regards rule making and give our suggestions to the Government of India, because and especially the discussion that we have had today with such a rich body of lawyers, judges, and everyone present here and mediators present here would actually give us an opportunity for us to maybe go back on our own, form certain, groups and look at this Act in a more detailed manner and try to see and address some of the rules that should actually go into it, which we can then recommend to the government so that the various flaws that are actually being seen in the substantive portion of the Act can be rectified in more ways than one, address the silent areas that are, address the areas that are silent in the Act which we can work. So I think I thank the committee once again for having invited me to share my thoughts, and I definitely think that this should be a beginning for us to actually start the process of working along with the rule committee, rules framing of the Act. Thank you.
Thank you, Madam. Madam, kindly stay for a moment on the podium. Thank you, Madam, for a detailed session on explaining the structure of the Mediation Council. Thank you, Madam, for highlighting the various guidelines, methodology in institutional mediation and mediation service providers. Thank you, ma'am. We request Honorable Thiru Justice P. Velumurugan, Judge of Madras High Court, to honor the learned resource person, Mrs. Geeta Ramaseshan, with a book and a sapling. Thank you, my lord. Thank you, ma'am.
We'll now break for tea in the ground floor and reassemble exactly at 3:45 p.m. for the last session and valedictory function.
Tea has been arranged in the ground floor. Huh?
Please come back exactly at 3:45 p.m.
ஸ்லைடிங் இருக்கா ஸ்லைடிங் இருக்கா இல்லை இல்லை
இது என்ன அனௌன்ஸ் பண்ணுறதுக்கு சொல்லணும்ல அவங்களுக்கு கன்ஃபார்மாக சொல்லுங்க கன்ஃபார்ம் பண்ணிட்டு ஏன்னா இன்விடேஷனே கிடையாது அது அவர் ப்ரிப்பேர் பண்ணிக்காரன்னு தெரியலையே அது வேறு இருக்குல்ல இது திருப்பி ஆட்சிகிட்ட கேட்டு கன்ஃபார்ம் பண்ணுங்க கன்ஃபார்ம் பண்ணிட்டு சொல்லி உடனே சொல்லுங்க இல்லைன்னா நம்ம கம்பேரிங்க்கு சொல்லணும் அதெல்லாம் பிரச்சனை பார்க்கக்கூடாது இல்லை நமக்கு ஸ்டேட்மெண்ட்டு போட்டாங்க இன்விடேஷன் நம்ம போடவே இல்லை பிரசிடென்ஷியல் போடல அப்போ இங்கே சொல்லி நீங்கள் கம்பெனிக்கு சொல்லுங்க அட்ரஸா அட்ரஸா இல்லை பிரசிடென்ஷியல் எடுத்து போடுறாங்க முன்னாடி வேலை முன்னாடி வச்சுருக்காங்க அப்போ அதை மாற்றிடுவோம் அதை எடுத்துருவோம் இது என்ன பண்ணுறது அதேதான் இதுதான் பிரசிடென்ஷியல் அட்ரஸ் போட்டாரு நான் ஆடிட்டு கன்ஃபார்ம் பண்ணி சொல்லுவேன் அப்போ இவங்களுக்கு சொன்னாங்கல்ல எக்ஸ்பிரஸ் இந்த அவங்களுக்கு நல்லா ஏன்னா இப்போ இது மாற்றுறாங்க இதையும் மாற்றுறாங்க எங்கோ பார்த்துன்னு சொல்லி சுபாஷினி ஓட்டு இருக்காதா கீழே ஓட்ட மாட்டேங்களா அந்த ஸ்வீப்பர் அந்த பையனை வர சொல்லிச்சு எனக்கு அந்த ஸ்வீப்பர் இருக்காங்க அந்த பையனை வர சொல்லு
ஜட்ஜஸ் லைனில் உட்காருவாங்களே இவங்க தான் வச்சுட்டு போனாரு
ஓகே சார் சார் இப்போ வந்து சார் ஒரு பிரச்சனை என்னென்னா வேலிடிட்டி அட்ரஸ் வந்து பிரசிடென்ஷியல் அட்ரஸ் ஹானர்ஜி கேசஸ் போட்டுருக்கு அது இல்லை தானே இப்போ வந்து ஆர்ஜி சொன்னாரு சொல்லிட்டு இவர் கிளம்பு போட்டுருக்காரு இது அனௌன்ஸ் பண்ணமா என்னன்னு தெரியலையே வேலிடிட்டி அட்ரஸில் வெல்கம் அட்ரஸ் வேலிடிட்டி அட்ரஸ் இப்படி மட்டும் தானே இருக்குது ஓட்டர் டேக்ஸ் மட்டும் தானே இருக்குது திருப்பி பிரசிடென்ஷியல் அட்ரஸ் போய் ஹானரபிள் சீஃப் ஜஸ்டிஸ் போட்டுருக்காங்க ஆமாம் அதை போட்டுருக்காங்க கேட்டால் ஆர்ஜி சொன்னாரு சொல்கிறாரு பிரபு சொல்கிறாரு ஆர்ஜி கிட்ட கேளுங்க இன்விடேஷன் அது இல்லை கேளுங்க கன்ஃபார்ம் பண்ணுங்க எனக்கு அந்த லாஸ்ட் விஷயம் பண்ணுங்க சொல்லியாச்சு அப்புறம் வந்து செகண்டு வெஜ்ஜு சார் ரெக்ரூட் பண்ண சொல்லியிருக்கீங்க வெஜ் சார் ரெக்ரூட் பண்ண சொல்லியிருக்கீங்க திரும்பி மாறிதா இது சொல்லுங்கள் சார் வந்துட்டாரு அவங்களாம் சார் வந்திருக்காங்க சாய் சரவணன் சார் வந்திருக்காரு ஐபன் சார் வந்திருக்காங்க உள்ளாராங்க அப்புறம்
Hello, hello.
இருக்கு வந்துச்சு இருக்கு வந்துச்சு
யார் கொடுத்தாங்க மேடம்? இவங்க கொடுத்தாங்க.
இந்த பிடபிள்யூடியில் கொடுத்தாங்க, குழந்தைங்க சார் கொடுத்தாங்க.
டிவி ஆஃப்
ஆகாமல் இருக்கணும் இல்லையா? சும்மா இப்படி ப்ரெஸ் பண்ண போகிறாரு, வேறு எதுவும் தெரியாது இதில். இதெல்லாம் லைட் எரியுது சார்.
சரி ஓகே. டிவி தான் மெயினாக எதுவும் பிரச்சனை இல்லை மேடம்.
இல்லை செல்லு வேணா கூட எடுத்துடலாம் சார். செல்லு எடுத்துடலாமா?
ஒன்றும் பிரச்சனை இல்லை. ஆஃப் ஆகிடும்.
Last session is followed by valedictory session. So we are expecting Honorable High Court judges anytime after 4 o'clock. So I request, sorry to disturb, I request everyone to keep the first 2 rows vacant. Yes. That was the instruction I received. Sir, அது instruction அப்படிதான்.
போர்டு எடுத்து வச்சிருக்கேன். போர்டு ஜட்ஜஸ் போர்டு அந்த ஒரு சீட் போர்டு சார் போர்டு இங்கே இருக்குல்ல சார், அங்கேயும் ஒன்று வச்சுட்டேன். இங்கே இருக்கு இல்லைங்களா, அதே மாதிரி எங்கே இருக்க அம்மா செக்ஷனில் ஏமா இருக்கேன், செகண்ட் ஃப்ளோர் வாங்க. நமக்கு இப்போ ஆல்ரெடி ஃபங்க்ஷனுக்கு எல்லா செக்ஷனில் உட்காந்து என்ன பண்ணுறீங்க, இது வாங்க. இப்போ இந்த சாந்தி மேடம் விட்டுட்டு நீங்கள் வாங்க, செக்ஷன் யாருக்கு நமக்கு ஃபங்க்ஷன் இருக்குது. இது ஃபர்ஸ்ட் வாப்பா, நான் இங்கே இருக்கிற நானே சொன்னேன் உன்னை இங்கே இருக்க சொல்லி. வா சீக்கிரம் வா.
Your kind attention, please. Kindly be seated. We are going to start the session now. Mediation. Welcome back for the final session on amendments in other laws by the Mediation Act, for which we have Mr. S. Arunachalam, advocate, who has been a part of the High Court Mediation Center from the year 2005. He has written many books on alternative dispute resolution techniques. Now we invite him to take over the session. Welcome, sir.
Good evening to everybody. At the outset, I sincerely convey my thanks to the chairman and the committee of members for having given me this very good opportunity. I may chant now a mantra that may kindly be repeated. We love mediation. We love mediation. We love mediation. Thank you so much. Though after, at this juncture, we want to remind of the quotation by Hudson Burnett. At first, people refuse to believe that a strange new thing can be done. Then they begin to hope that that can be done. Then they see that that is done. Now the whole world wonders why it was not done centuries ago. This is actually the finest quote as far as directly applicable to the mediation concept. After independence, why this Mediation Act has not come at least 50 years ago? That is actually our intention now. Now that it has come, a lot of confusions, a lot of interpretations, expertise, opinions, all these things are there. Apart from that, we, with all wholeheartedness, we welcome the Mediation Act 2023. My session is being shortened by only half an hour. Therefore, the most respectfully, I request the participants to kindly write your questions and hand it over to the center, either by me or by other experts. It will be definitely answered to you. This act has 10 schedules, and the first schedule has already been covered by Madam Uma Ramanathan in a very elaborate way. This, as far as my understanding of these schedules are concerned, this act covers every law of Indian country. You may wonder that the Schedule 2 covers 8 enactments, and other schedules cover 7 enactments. Therefore, totally 16 enactments have been covered one by one in this legislation. Then, this legislation has an overriding effect of all other legislations. Therefore, this law, according to my humble understanding, that covers the entire thing, is considered to be a special law in mediation. As for the second schedule is concerned, say for instance in India, industrial disputes, that's a familiar act. If you are making a settlement under section either by 18.1 or section 12.3 of the industrial dispute, whatever it be. Or even you are trying to do a mediation in the Industrial Disputes Act and arriving at the settlement, that settlement cannot be termed as against the Mediation Act. That exemption is given in the Schedule 2. So such exemption is given not only for Industrial Disputes Act, but also other 7 enactments, totally 8 enactments have been exempted, where whatever be the form it is, the parties are coming to a conclusion by a settlement or something like that, whatever the name you call it as, that will not affect, or that will not compel the, or set aside by saying that, no, you have to only come through the Mediation Act. This is the first aspect of this second schedule. Then as far as the third schedule is concerned, it is about the Indian Contracts Act. Indian Contracts Act section 28 gives some exceptions of void contracts. If a void contract is once and for all void, there cannot be remedied. But however, there are exceptions. If the parties are willing on that, on certain issues, that can be referred to arbitration, is what has been stated in the section 2 of the Contract Act as the exemption clauses. Now, that can also be referred to mediation. That is actually the third schedule. Therefore, I may just read, saving of the contract to refer arbitration or mediation dispute that may arise. This section shall not render illegal a contract by which 2 or more persons agree that any dispute which may arise between them, may arise between them, in respect of any subject or class of subject, shall be referred to resolution through arbitration or mediation. So this mediation is also included. Therefore, even void contracts, if the parties are willing and there are certain issues to be mediated, that can also be mediated. Say for example, time-barred debts. If the parties are willing, no, doesn't matter, we'll go for a mediation, it can be mediated. And once the mediation settlement is arrived at, the agreed amount can be executed and obtained. Then, saving of the contract, rubber questions have already been arisen. So some question has already been arisen, but it's a void contract, that can also be referred to arbitration or mediation. This is third schedule. Then the fourth schedule, the Code of Civil Procedure, you know better. Section 89 CPC has already been inserted, but now that section has been remodified. You know that in the Afghan judgment, Honorable Mr. Justice Ravindra, whenever we take 89 CPC in classes, all the lists will pronounce the Afghan judgment. Because such a great interpretation has been given that section 73 is plucked into and fit in this section 89, the original 89, and that can never be possible. According to the judge, formulate the terms of the settlement and refer to mediation. Therefore, absolutely it is a bad craftsmanship. Therefore, that can never be accepted. That is what Honorable Justice Ravindra has interpreted. And thereafter, in the judges' meeting, all these things, it was decided that, formally we can leave off that facade of that section, then we can continue for other section. That was that. But now, that has also been, sealed away. That has been remodified. And section 89 is completely been, as a new section, it has been inserted in the Civil Procedure Code. Here it is said that one or two areas where it appears to the court that the dispute between the parties may be settled. Here also, you know better than me, that where it appears to the court that the dispute between the parties may be settled. That pre-conclusion is also not necessary for a court. Say for instance, how can the court presume that it may be settled? Then the next sentence, and there exists an element of settlement which may be acceptable to the parties, the court may refer arbitration, mediation, etc. Here also the problem is, where it appears to the court that the dispute between the parties may be settled, but that is not, the humble submission is not necessary. It would have been vouched in such a way that where it appears to the court that there exist an elements of settlement which may be referred to. That may be acceptable. Then the court cannot presume that it will be settled. We may have a hope, that's a different story. But however, as far as the legislation is concerned, whether such an interpretation can be given or not may not be possible. Then section 18(b), refer the parties to mediation to the court-annexed mediation center or any other mediation service provider or any mediator as per the option of the parties. It is a very, very nice drafting. Or the section. As per the option of the parties. If, say, for instance, so far, if you go to the mediation center and saying that, no, I want this mediator, or we, both wish that this particular mediator may be appointed for our case, it may not be possible now. But here it is clear that as for the option of the parties, it is open. No, we want, if agreement is arrived at that, otherwise it is not. But however, if the agreement arrives that so-and-so is maybe a mediator, then that can be done. Then, the D, clause D, this is also a lot of interpretation there. Effect compromise, that is settlement to the judicial settlement. How the judicial settlement, that's it. Effect compromise between the parties and shall follow the procedure as deems fit for the judicial settlement. Effect compromise between the parties. This effect compromise between the parties is alien to this Mediation Act. In the Mediation Act, it can be mediated by a neutral way, by a confidential mediator, and a mediated agreed settlement can only be arrived at. The mediator is acting only as a catalyst. Where it is said that even if it is being done by the honorable judicial officers, what has been done is, or what is to be done is, the mediation only, not other things. Therefore, effecting a compromising question does not arise. Therefore, between the parties and shall follow the procedure. Judicial settlement is our understanding is honorable judge, one judge, referring the matter to the trained other judicial officer. That is actually the word judicial. There also, the honorable judicial officer is only doing the work of mediation. Doing the mediation has no compromise at all. Therefore, when the judicial officer is doing a mediation process, is not going to any compromise effort. So this has some changes. Then, fifth schedule. Fifth schedule is pertaining to Legal Services Authorities Act. There it is categorically mentioned that they encourage the settlement of dispute, including online mediation settlements, that Honorable Senior Counsel Mr. Aravind has taken it, by way of negotiations, arbitrations, and conciliation. We sincerely put it that by way of negotiations, arbitrations, mediations, and conciliation. The word mediations and conciliations are separately need not be worded. For the reason being, under section 3H, the mediation has been defined. Therefore, encourage the settlement of disputes, including online, by way of arbitration or mediation. Negotiation, all are techniques being adapted in the mediation process. But arbitration or conciliation is also included in 3H for the definition of mediation. Therefore, these are some of the small things which I would like to put forth. Then, moreover, 61 to 81 of the Arbitration Act says that it's about conciliation, how the conciliator is appointed, what are the duties and regulations of the conciliator officer, how the whether the conciliation officer is equivalent to mediator or something else. All these things are there. But here, 61 to 81 is completely taken away in the Arbitration Act. In the Arbitration Act, 61 to taken away is completely taken. Therefore, conciliation is no more there. Justice, the opinion of Honorable Justice Ravindra also, though these two words are there, it is amounting to the same. Therefore, maybe on that background, this conciliation and mediation are included in the definition of 3H. Therefore, this, based on that, this 61 to 81 is taken away. All other things, reference to conciliation, any other provisions other than the enactment of time being provided, all these things are all right. Pakka, this sixth schedule is covering so much things. Say, for instance, conciliation as provided under this Act, the Code of Civil Procedure, shall be construed as mediation. Therefore, again it is being rated mediation. H of the therefore, all these things are vouched in a very categorical way. This is actually the sixth schedule. Sixth schedule says about the Arbitration and Conciliation Act, how that is being inserted, and some of the things have been taken away. Then, seventh schedule. Seventh schedule is MSM, the Micro, Small and Medium Enterprises Development Act. Here, Section 17 make a reference to the Micro and Small Enterprises Facilitation Council. So 17 of this Micro Act established a council for that. That council will take care of, as if our mediation center is there, a panel of mediators, that is being done. Likewise, that Micro Council will take care of the mediators, and they will maintain the panel of mediators and do the job. That is actually the good thing. But such provision is not there in the other enactment. That's why I am stressing here. Then, on receipt of the reference under Section 1, the council, that is the Micro Council, shall either conduct the mediation itself. That is a peculiar thing. How can the council conduct the mediation itself? Because the council is maintaining the panel of mediators, and accordingly, this will allot it, and the council is do the mediation. Mediation itself, or refer the matter to any mediation service provider as provided under the Mediation Act. Therefore, Mediation Act as well as his Micro Council, that has been combined together, go jointly. That is actually the thing. The conduct mediation under this section shall be as per the provisions of the Mediation Act. All other things are there in the schedule. Now, because I am speedily covering, but a lot of other things are there. Then, 442 of the Companies Act, section 8th schedule. Companies Act. Companies Act, the provision 2, nothing in this section, 442, nothing in this section shall prevent the central government tribunal or the appellate tribunal before which any proceeding is pending from referring any matter pertaining to such proceedings so moto to mediation to be conducted under the provisions of the Mediation Act. Therefore, so moto reference is there. In the other schedule, may, one place, I will just show that, shall is inserted in this act, that was subsequently immediately amended as may. For say, a judicial officer shall refer the matter to mediation at any stage. That is the wording originally. That was immediately amended as may. Therefore, how can a judicial officer be compelled to refer a matter to mediation? So, question immediately has arisen into the mind of the legislature, and that has been amended as may. But whereas, as far as the Afghan judgment is concerned, may has to be read as shall. Therefore, though a judicial officer cannot be instructed shall, though the may is inserted, the may has to be construed as shall. Because of the Afghans. Because Afghan judgment says that reference is mandatory. In this context, we ought to, now I am reminded of Honorable Mr. Justice A.P. Shah. He said, nothing wrong in referring a case which is being kept in the rack for a long time. 1 day may happen, he said. 1 day may happen. It is really happening in mediation. As Honorable our Guru Panju sir said, even though the settlement is not being arrived at, mediators transform the mind of the parties. That is very important. Mediators transform the mind of the parties. The parties are not the same parties who are going in, and when they came out, definitely not the same parties. They shed all their tears by weeping, but get more things, got more things into them, and they are coming out. You know, in most of the mediations, in my experience, you know, youngsters, even parties, even councils ask, sir, what is the way, sir, to making application to being a mediator? Invariably. So that is actually the transformation is being done by this mediation process. Therefore, even though may is used, no, every matter has to be referred, re-referred. I mean, without swallowing the time of the Honorable Court. So, suo motu mediation be conducted under the provisions of the Mediation Act. The reference can be made suo motu. One more thing is there, that is also important in the Companies Act. The fee of the mediator shall be such as may be prescribed. That is also there. Therefore, when the matter of when the name of the mediator is referred, the last line, the fee of this mediator may be paid such, that may also be mentioned. Then chapter 8, pre-litigation mediation and settlement. That a lot of things have been covered under section 12A. And for there in the pre-litigation mediation settlement, that is 12A is amended accordingly in this schedule, and completely that was taken away, the original was taken away, this has been inserted. Here, the important thing is, for the purpose of, item 2, for the purpose of the pre-litigation mediation, the central government may, by notification, authorize. By notification, authorize the authority constituted under the Legal Service Authorities Act, that is one. The authority, Legal Service Authority is the authority to conduct the mediation as a council, as a authority to conduct, maintaining the panel, etc., that's there. Then, one more thing is, a mediation service provider as defined in clause M of this Act, section 3 of this Act. Therefore, these two are the bodies which are governing the paneling system of this mediation. Now, another thing, very important thing, which actually that would irk, rather to say, the mind of the mediators is this clause. If the parties to the commercial dispute arrive at a settlement, the same shall be reduced into writing and shall be signed by the parties and the mediator. That is the one thing which we are not able to digest at all. For the reason being, யாருப்பா யார் கையெழுத்து போட்டது மீடியேட்டர், அவருக்கு முன்னாலே மீடியேட் செட்டில்மெண்ட் போட்டது, அவர் விட்னஸாக வராரா இல்லையா, வர சொல்லு. அப்போ யாருப்பா உன் பேர் என்னப்பா, யார் பாக்ஸில் யார்? சார், இந்த மீடியேஷன் அக்ரிமெண்ட் நீங்கள் போடும்போது உங்கள் பக்கத்தில் கத்தியை வச்சுட்டு ஒரு ஆள் நின்னாரா இல்லையா? இப்படி ஒரு மீடியேட்டரை ஏற்றி கேள்வி கேட்டால் என்ன பண்ண முடியும்? So, the mediator can never be a party to a settlement. The mediator may transform the mind of the parties. Mediator is not taking any change in him. Mediator is a mediator doing the work of facilitation. Mediator is only a catalyst. He is not making any change, but he is an important part in making that reaction in a chemistry. So that is actually, therefore, in all, whatever be the sense it is, according to our studies, according to our understanding, according to anything of that sort, mediator can never be the party to a settlement. He can never be permitted with the humble request to sign in the agreement. Maybe by authentication, etc., whatever be the form it is, he can never be put to call as a witness in the box. So apart from that, all the things are then. The 10th schedule, the time frame, the 60 days time is given already. Now we are given after the, before the act. Within 60 days, the mediator has to complete, as far as the rules, complete this mediation process. Then, on the request of the parties, another 30 days may be extended, 60 plus 90 days. No, really we are saying, for these 90 days, we can only move to the parties up to 2 private sessions, that's it. Beyond that, it will be very difficult for us to move the parties. Beyond that, we cannot move at all. Therefore, very often, when one mediator does the job of the mediation, it will be, of course, we are happy, it will be settled in the other mediator, in the second reference. For the reason being, these 90 days is not at all possible. Therefore, now it has been extended to the 120 and 60 days extension. There is a welcoming affair as far as this act is concerned. Then, number of re-references are not being specifically stated, but it is not being barred. Therefore, that can also be done. Then, as the Honorable Judge put it, Sriram Panchu sir also said that, no, we speak about docket exploration every day, then why not reference? That is actually a question raised by. Every mediated case need not be settled. But in our experience, we say minimum 30 hours we spend for every mediation, whether it is successful or not successful. Whether the parties are able to arrive at a settlement or not, we spend minimum 30 hours. That is actually a thing. Therefore, of course, apart from the remuneration, all these things, that is a different story. But however, it is our duty, once we take up the matter, it is our social responsibility to do that mediation in such a form and way, which we have been taught of. Then, 10th schedule. 10th schedule is a Consumer Protection Act. As we said in the micro, there is a council established to establish. That is my question is, why I stressed is that in the 10th schedule, a commission is there that has been taken away. You see that. In the 10th schedule, the Consumer Protection Act, section 2, clauses 25 and 26 shall be omitted. Therefore, section 25 and 26 shall be omitted means the mediator, the word mediation and mediator is omitted. Because it is known everybody that it has been included in the Mediation Act. It is all right. Then, another thing comes, chapter 5, big chapter 5 shall be omitted. Chapter 5 says, everyone who is practicing the consumer side will be knowing that chapter 5 says, consumer mediation cell is there. And empanelment is being done by that consumer mediation cell. If now that is taken away, then for the consumer cases, who will make an empanelment? That's a question. Of course, you will be, by reading of this, you may be in a better position to understand me than me. But however, by reading that, I could understand that like the micro council, here the mediation cell in the Consumer Protection Authority is taken away. Then who has to make arrangements for that? That is a vacuum. Then, here I said that this, the reference to mediation, the district commission or the state commission or the national commission, as the case may be, may at any stage of the proceedings refer the disputes for settlement by mediation under this act. Therefore, this is a very important paradigm shift. In the off-cons, it is said that when the pleadings are over, that is the right time for making the reference. But that also vouches that that is not preventing the court to refer the matter at any stage. That is actually the formation. Now it is said that, no, it is not so. At any stage, directly, at any stage, even at the preliminary stage, if you feel that there is an element of settlement, just refer it. May, at any stage of the proceedings, refer the disputes for settlement by mediation under the Mediation Act. In this may only, it was just when this act was formulated, it is mentioned as shall. Therefore, this legislature feel that it may not be appropriate to direct the judge by putting the shall. But however, even though it is changed as may, it has to be construed as shall. Then, 2. The mediator shall prepare a settlement report. The mediator shall prepare the settlement report, and the settlement and the forward the signed agreement along with the report to the concerned commission. Here, lot of word confusions are there. Because, you see, the mediator shall prepare a settlement report of the settlement. The word settlement can be used as settlement agreement. Okay, that has not been mentioned. And forward the signed agreement. Once it is signed, that will become a settled agreement. Settlement agreement. It is not a mere agreement. Therefore, signed the mediated settlement agreement. That must come like that. Agreement along with such report to the concerned commission. Therefore, in this section 2, a lot of word confusion there. Now, all other things are there. It's all right. Then, the mediation removal of difficulties order, the last clause C, the 10th schedule is just amended after the 10th schedule. The 10th schedule relating to amendments to the Consumer Protection Act in section 37 for the words shall, either on an application order of the parties, the word may shall be substituted. Here, only one, the last but not the least, only one thing. Lot of confusions with reference to the references. No, நாங்க மீடியேஷன் கேட்கல சார், அவர் தான் சார் கேட்டார், அவர் கேட்டுட்டு வந்துட்டு இங்கே இப்படி வேண்டான்னு சொல்கிறார் பாருங்களேன். Such type of things will come. So, it is not the case. Who refers to mediation? Two important things are there. Reference is a judicio-administrative matter. It is mandatory. It is not the case that whether the parties have requested or not. It is the discretion of the honorable judges. Therefore, at that stage, the parties has no locus either to refuse the reference or no, I won't go. Nothing of that sort. But the parties may be reiterated once they have come to the mediation center. For the presence, the court's doors are closed. Then once they come to the mediation center, the parties' autonomy is there. They have got every right either to accept or to refuse. All these things are there. Therefore, with all in a humblest way, I thank you all for the finest opportunity given to me. And any questions, kindly, and I am welcome questions, but the time constraint is there. What happened? It's all right? Oh, yes. The sanction has come to do some more things. So, anyway, then we can prompt some questions. Either maybe general questions or maybe questions relating to these schedules. Absolutely no problem. If I am prepared, I am able to answer, I will answer. Otherwise, my seniors will answer. No problem. We can, yes, sir. Please, sir, questions. Sir, please, hand over the mic, sir.
Sir. Inge, right side. Sir.
Yeah, please.
Right side.
Please, to my right. Yeah.
You were talking about the Consumer Protection Act, right? So there are a lot of holes in the act which we are able to see. So now there is no council once the act has come and the rules will come. So what do you think, what do you feel will happen now?
Yeah. I understand the question. Yeah. My thing is that, before the advent of this act, my sincere request is that nobody can mediate except maybe the orthodox view, but still, nobody can mediate or competent to mediate except the one who has taken the 40 hours training by the mediation center. If you are able to complete the mediation center training, then you may do private mediation, etc., etc. But this is actually one of the best quality trainings given to the mediators we have ever had. We have gone for a lot of other trainings in Delhi, this, that, etc., etc. Even our senior members, Mr. Aravind Pandey and all, have gone for abroad for studies. Our Sriram Panchuzar has gone. Mr. Jabad has contributed, years, had got training. But however, it is the best quality training. If, unless and until, more than 3 lakhs rupees is paid, you can never get a training like this. Therefore, our request is that do mediation. More than 1,000 applications selecting for this. I came to know 40 people are selected for this training now, out of 1,000 applications. Therefore, it is a competition. You may request the center, you give, more training may be given to us, more training, more members may be added in the training. But however, this is the only way to channelize it. Private mediations, we are not refusing at all, because all the council is coming, all these things, umbrella type things will come. But however, the respective high courts have to give the 40 hours training. You may do private mediations also. That is actually my view. That may not be, in that case, this consumer, all these things will be solved. Now, second thing is that, in view of, the omission of this council, till the other arrangement is said, as legal is authority, the authority is fixed in this schedule. But whereas in the consumer case, it is not been fixed. Therefore, till the authority is fixed, our High Court may authorize a panel, and from that panel, the consumer court, the head of the consumer forum, may, according to the, make an panel, empanelment, and do the services. That is what I sincerely feel. Sir, please, sir.
Many
Sir, 1 second, sir. Sir, 1 second. Sir, 1 second. Sir, 1 second.
Many enthusiastic judges are mediating during the trial stage.
Many
enthusiastic judges
are doing mediation.
Mediation during the trial stage. Suppose if the mediation fails, can they give judgment?
That's what. No, that's what I made it. The particular honorable judge who is dealing with the matter, sorry to use the word, is not competent to mediate. Sorry to use the word, is not competent to do the mediation. He can very well refer the matter to do other honorable judge who has completed the 40 hours training. He will definitely do the best job. Vice versa, that honorable judge will refer his cases to this honorable judge also. Number one thing. Second thing, another orientation program is also there for the honorable judges. That's what very important. Now, before referring to, இப்போ மணமகளை வீட்டிலிருந்து அனுப்பி விடும்போது, அம்மா அரசே ஒன்றும் வருத்தப்படாடா, கவலைப்படாடா, எல்லாம் நல்லபடியாக நடக்கும், ஏன் அம்மா அழுறா, போயிட்டு வா செல்லம், அப்படிலாம் சொல்கிறோம்ல. அது likewise, orientation is very much there with the same judge. எப்படி? So, no. Mediation, these are all some of the qualities of the mediation. The mediation's quality and mediator's qualities are there. They are completely non-prejudicial. Therefore, it is a matter it's likely to be resolved. Don't worry. Such a type of orientations can be done by the same judge before referring. Sir, please.
The draftsman or the drafting
committee. Sir, 1 second, sir. Sir, Mr. Raghuman sir is on the line. Please. Okay.
That judge shall maintain a register, and that judge shall refer to the trained judge mediators.
I understand.
This is what the procedure.
Okay.
If I am having a case on my board, I cannot suo moto send it to some other judge. I have to refer to the principal district judge or the district coordinator.
Okay.
That judge will maintain a register, and on turn basis the cases will be referred. And our TNMCC has also given a guideline that the judge mediator less than 40 years of age cannot mediate.
Mediate.
That is also one of the
criteria
put
yes,
forth.
yes.
So just like that, I cannot mediate.
I understand. I
This
get
is
corrected.
what,
But it's only the triangular administrative basis. I understand. It's a triangular. The administrative decision cannot be taken. It's a one bench to other bench. Honorable administratively honorable CJ has to take a decision like that. No, it's a triangular basis. I stand corrected. Please, sir. Any other?
Sir, the draftsman or the drafting committee of this act looks like not so wise and professional. So, for framing of rules, can we give suggestions from every district mediation centers? Because it looks like many lacunas and many constitutional questions may arise.
I perfectly understand your question, sir. The thing is that in any event, whatever be the rules it is, the rules cannot override the effect of law. Therefore, unless and until a serious amendments, wherever it is required, it is to be done. The rules also to be framed in such a way. Number one thing. Second thing, your suggestion, Madam Geeta Ramasheshan also said that, a sort of workshop can be done. We must be vibrant enough. A sort of workshop can be done, either the district-wise or, the center-wise, and that output can also be taken. That can also referred either by the center or privately to the law commission, etc., etc. That can do a lot of revolution in that, definitely.
Thank you, sir.
Thank you, sir.
May I please, sir? This is Kavita Balakrishnan.
Yes, ma'am, please, ma'am.
Yes. This is regarding the pre-litigation commercial mediation, sir. The rule says that rupees 1,000 has to be paid along with the application. The parties pay 1,000 rupees. And they also have to pay a mediation fee, which normally the center says it is paid to the mediators, but it is the otherwise. The mediator is not paid as per the schedule. The schedule is given in the rules. That is, Schedule 2 is the rules under Section 11. Can you give us a clarity on this? Where do we need a understanding why it is called mediation fee and it is not being paid to the mediator? When the parties have already paid the money.
Well understood, ma'am. Well understood. For example, in the 2 days back, we was doing a pre-litigation mediation in the Legal Service Authority, where each party, madam said that each party has to pay 20,000 rupees. We humbly paid that, and the mediators are not paid to that extent. Mediators are paid only 7,500 rupees for the mediation were successful, where the matter has from 4,000 for the non-successful mediation, from 4,000 it has been reduced to 2,000. So this is actually a scenario. But no, with all humbleness that as Panju sir put it, that this must be definitely raised, but I am not or we are not the authority. There is to be looked into. As for Madam Kavita Balakrishnan's question, it may be remembered that you see, a lot of things are not being taken to the authorities or the honorable judges who are in the deciding position. That is very important. No, Ma'am Kavita, have we ever represented the matter to the chairman of our committee or the chairman of the Legal Service Authority? We have not done that. That is the whole difficulty. The thing being, now one of my Chittappa has wanted to renew the Bar Council ID. The Bar Council said, no, you must have filed at least 15 wakalats in every last 3 years. Otherwise, your identity will not be renewed. You see, where will the mediators go? We have full-time mediators, we don't have any wakalat at all. We cannot call the adjacent chamber, please.
Sir, the
please
thing
come.
is,
Please come.
the Act says so. That is what the clarification I wanted to say.
Coming.
No, as regards the ID, this issue had come up a few years back when Justice Sanjay Kishan Kaul was the Chief Justice. And what happened was some mediators were refused, saying that you have not filed sufficient number of wakalats. So Mr. Panchu and I met the CJ and explained to him the situation, and he issued directions that mediators, regardless, you just see their mediation record. If they have done sufficient number of mediations, give them the IDs, he said. So that clarification is there. Right. So that's why I'm saying.
That's the thing.
Yeah.
Madam.
Because for documentation there is a provision, but not as mediators, although it's a verbal communication. Probably they lose.
A sort of amendment is also required, at least in the rules. Yeah, that is very important because our trained mediators there, they have more than 1,000 or 2,000 cases in mediation. But when they see the wakalat, they may not have any wakalat. For the reason being, can that be rejected? They are for more than 15 years, they are devoting their life for mediation. So these are some of the paradigms. As Mr. Learned Friend Jawad put it, this has also been represented. As Madam Sudarshana put it, this may also be suitably amended when the rule comes. That's also we'll have to take care of. Ma'am, Kavita's question is very difficult to answer, but however, because for the reason being, the different acts cannot have different payment schedule. That is actually the difficulty. This is to be represented. That is my humble request. We'll do jointly. We'll work together. That's what I simply said. Of course, there is no answer, the correct answer for that. I accept that. Any other questions? I ask a question for answering. Can the mediator ask the party to go for a private session? This is only for mediators. They go for a private session after the opening statement. Now the opening session is over. Now whether the mediator can do a private session immediately after the opening session. Any one of you please, strongly. Yeah, Perumal sound is louder. Therefore, we must do joint session in the beginning, and thereafter only we can go for, we must do joint session in the beginning, thereafter only we can go for a private session. I may give a scenario which has happened like this for me in my mediation. No, in the husband and wife problem, I was explaining how the mediation is going to be done. I am so and so. நான் பெரிய புலி நான் பெரிய இது அப்படிலாம் சொல்லி அந்த விஷயங்கள்லாம் சொல்லிட்டு இருக்கோம் பேரெல்லாம் சொல்லி அப்படிலாம் சொல்லிட்டு இருக்கோம் that we are explaining in the context. The husband was so docile like this. The same position he is for about all the 12 minutes I was explaining, he was all along like this keeping his pose. I said it feel very difficult, what had happened? Then, sir, you understand everything what I say about the process in the mediation. No, even if the process is not being clear to you, you can also stop me in the middle of the process. You can always ask me. And, no, sir, I am not willing for mediation. What is this? Then I said, okay, it is a very difficult task to handle him. Then I said, no, then I requested the other party. Somehow it struck my mind. Sir, the other party I am asking, sir, if you don't mind, can I have a private session? They said, okay, what is wrong in that, sir? You can always do. Then I asked him, because our seniors have taught us, the why is a magical question in mediation. Then I asked him, sir, why you are not willing for mediation? Ada ponga, sir. 10 பஞ்சாயத்து நடத்தியாச்சு 10 பஞ்சாயத்துலையும் சேர்ந்து போ ஏதான் சொல்லிட்டு இருக்காங்க. இங்கே வந்து அதுதானே சார் சொல்ல போறீங்க, அதுக்கு எதுக்கு சார் நாங்கள் உட்காந்து மீடியேஷன் நடத்தணும்? ஓஹோ, this is actually the thing, okay. Then I continued the private session with him, saying, this is in a more elaborate way, opening statement in a very elaborate way, as if he's taking class for 15 to 20 minutes. I explained that, sir, is it so? Divorce can also be tried in this mediation. No. That means the whole question is that, no, had it been known already, I would have come first. That is actually a thing. So, such type of things may happen. So, the mediator has to use his skill according to the situation which warrants. That is very, very important. The mediator, we have studied so many procedural rules, procedure ways, all these things are there. But still, most fortunately, Madam, what is called the US Gita Ramachandran, right? No. Sorry, thank you. Madam Gita Ravindra, then another one from Regalia. All these things, we have fortunate enough to learn from serious experts. They taught all these procedure, this is actually the etc., etc. But still, very often Mr. Jawad would say that, I am in charge of the process. Mediator, I am, is in charge of the process. But at the same time, that does not mean that, private station நடத்தலாம் புரியுதா கொஞ்சம் உட்காருங்க அப்படி இல்லை. So mediation has its own language couched only on neutral terms. எந்த நேரத்தில் எந்த பார்ட்டியை நீங்கள் எப்படி ஹேண்டில் பண்ண நினச்சாலும் that must be couched in a humble, neutral words. அதான் we always take the mediation has a separate language. அந்த லாங்குவேஜை கற்றுக்கிறது வரைக்கும் தான் நமக்கு அதில் நம்ம ஒரு பெரிய ஆளுங்கிறது இல்லை, நம்ம இன்னும் நம்மளை செய்யக்கூடிய அளவுக்கு நம்மளுடைய தகுதியை வளர்த்துக்க முடியும் அப்படின்னா ஒரே ஒரு விஷயம் தானே, உன்னை எப்போதும் தகுதி உடையவன் ஆக்கிக்கொள், அவ்வளோதான், வேறு எல்லாமே வேண்டாம். த ஹம்பிள் வில் பி எக்ஸால்டட். உன்னை முதலில் தகுதி உடையவன் ஆக்கிக்கொள், அதுக்காக முயற்சி பண்ணுவோம். ஆல் த திங்ஸ். ஐ bow, I completely thank you so much for the opportunity.
Kindly stay for a moment on the podium, sir. Thank you, sir, for your lively session by explaining all the amendments and the various schedules classified in the Act. Thank you, sir, for encouraging the advocates to transform themselves as mediators who act as a catalyst. Thank you, sir. Now we request respected Registrar Licensing, Mrs. V. Uma, to honor the learner resource person, Mr. S. Arunachalam, with a book and a sapling.
We request everyone to have seat. Please be seated. Valedictory function will commence in another 5 minutes. We request everyone to stay here. Honorable dignitaries are on the way. Honorable Lordships are on the way. Please be seated. Lordships are in the first floor. They will be here in another 2 minutes. We humbly request the gathering to receive honorable dignitaries. Please be seated. Very We cordially invite our honorable dignitaries to adorn the dais for valedictory function. May we commence the proceedings, my lord?
Good evening, everyone. We have now come to the end of this special day. As we embark on this valedictory function, we extend a heartfelt invitation to Honorable Thiru Justice R. Mahadevan, Judge, High Court of Madras, Executive Chairman of Tamil Nadu State Legal Services Authority, and also Chairman of Tamil Nadu Mediation and Conciliation Center, to deliver the welcome address. Please, my Lord.
Good evening to you all. My Lord, Honorable Thiru Justice Bhushan Ramakrishna Gavai, Judge Supreme Court of India, and the Chairman Supreme Court Legal Services Committee. The Honorable Thiru Justice Sanjay V. Gangapurwala, Chief Justice Madras High Court, Patron-in-Chief TNSL SA and TNMCC, Honorable Mr. Justice D. Krishna Kumar, Executive Chairman, Puducherry Legal Services Authority, Honorable Justice S.S. Sundar, Chairman, High Court Legal Services Committee, all the esteemed committee members, and the Honorable Sister and Brother Judges, distinguished delegates, mediators, trainers, guests, a very warm welcome to you all. It is with utmost respect, privilege, with great honor and humility, I welcome His Lordship Honorable Thiru Justice Bhushan Ramakrishna Gavai as he graces this occasion with his august presence and inaugurating mediation centers at the taluk level, ensuring that justice is truly accessible to all. His Lordship's illustrious judicial career serves as a beacon of light, guiding us along the path of justice and equity. Honorable Justice Gavai has authored enormous number of judgments in education, service, civil, property, and constitution matters. His Lordship's expertise in criminal law is well known. At the same time, during his long tenure, His Lordship had an opportunity to deal with almost every legal subject possible, including commercial law, arbitration, taxation, insolvency, etc. His Lordship has dealt with a variety of subjects, including being part of benches dealing with constitutionality of criminal contempt, validity of unstamped arbitration agreement, challenge to the abrogation of Article 370, demonetization scheme of 2016, the constitutionality of the electoral bond scheme, and the Tamil Nadu government's 10.5% reservation with the MBC quota. His Lordship's mastery over various legal principles can be found through his judgments. His Lordship has also expressed his views with respect to efforts towards lessening of government litigations. In many criminal matters, His Lordship has adopted a very humane approach while dealing with convicts and prison inmates by taking into consideration their satisfactory conduct while in jail. A quote, "A nation should not be judged by how it treats its highest citizens, but by its lowest ones." These are the oft-repeated words of Nelson Mandela that resonate with us at every step we take towards ensuring justice to the last needy person in our society through the national and state legal services authorities. We are grateful with your Lordship's presence with us. I extend a cordial and affectionate welcome to the Chief Justice of Madras High Court, Honorable Thiru Justice Sanjay V. Gangapurwala, who has been instrumental for this program. I also extend my heartfelt welcome to Honorable Mr. Justice D. Krishna Kumar, Executive Chairman, Puducherry Legal Services Authority, Honorable Justice S.S. Sundar, Chairman, High Court Legal Services Committee, all the Honorable Committee members, and the Honorable Brother and Sister Judges for gracing this occasion with their presence. I cordially welcome senior advocates and advocates whose contribution is significant to the march of law. I extend my warm welcome to the registrars of Madras High Court and Madurai Bench who have worked tirelessly day in, day out for this function to turn out as a grand success. I cordially welcome law officers, mediators, senior trainers, and all principal district judges and judicial officers throughout the state of Tamil Nadu and Union Territory of Puducherry, reporters from print and electronic media, and others who have assembled here on this occasion. Once again, a warm welcome to you all, and thank you for your esteemed presence here. Thank you.
Thank you, Lordship.
This is a time for honoring the dignitaries on the dais. As a token of our gratitude, we request Honorable Thiru Justice Sanjay V. Gangapurwala, Chief Justice, Madras High Court, Patron-in-Chief, Tamil Nadu State Legal Services Authority and Tamil Nadu Mediation and Conciliation Center to honor Honorable Thiru Justice Bhushan Ramakrishna Gavai, Judge, Supreme Court of India, with a memento.
We cordially invite Honorable Thiru Justice R. Mahadevan to honor Honorable Mr. Justice Sanjay V. Ganga Purwala, Chief Justice of Madras High Court, with a book and a sapling.
We cordially invite respected Registrar Vigilance Mr. Sai Saravanan to honor Honorable Thiru Justice R. Mahadevan, Judge, Madras High Court, with a book.
We cordially invite respected Registrar of Recruitment, Mr. K. Ayyappan, to honor Honorable Thiru Justice D. Krishna Kumar, Judge, High Court of Madras, with a book.
We cordially invite respected Registrar, District Judiciary, Tirumadi Subha Anbumani, to honor Honorable Thiru Justice S. S. Sundar, Judge, Madras High Court, with a book. With great honor and pride, we humbly invite Honorable Chief Justice to deliver presidential address.
Now it is time to greet Malai Vanakam. Honorable Justice Bhushan Ramakrishna Gavai, Judge, Supreme Court of India, and Chairman, Supreme Court Legal Services Committee, Brother Justice Mahadevan, Executive Chairman, Tamil Nadu Legal Services Authority and Tamil Nadu Mediation and Conciliation Center, Brother Justice Krishna Kumar, Executive Chairman, Union Territory of Puducherry Legal Services Authority, Brother Justice S.S. Sundar, Chairman, High Court Legal Services Authority, my esteemed sister and brother judges, senior advocates, mediators, members of my judicial fraternity, the members of the registry, and distinguished guests. Now this evening I stand before you to celebrate the remarkable success of the conference. This event was truly been a testament to our commitment towards the advancement of legal services and alternate dispute resolution mechanism in our state. First, I would like to express my deepest gratitude to everyone who contributed to the organization and execution of this conference. The seamless coordination between the Tamil Nadu Legal Services Authority, Puducherry State Legal Service Authority, and various district legal service authorities deserves our heartfelt appreciation. This conference aimed to foster a collaborative environment for the exchange of ideas, experience, and the best practices among legal services authorities, legal professionals, and the stakeholders. It brought together esteemed speakers, experts, and participants from across the state, showcasing the importance we place on the development of our legal fraternity. The special training on the Mediation Act of 2023 was an integral part of the conference, highlighting the growing significance of alternate dispute resolution methods. This training equipped the advocates, mediators, and the judges of the district judiciary with necessary skill and knowledge to effectively mediate and resolve disputes through dialogue and consensus. The Act emphasizes on promotion, Promoting mediation as a cost-effective, time-efficient, and less adversarial approach to dispute resolution has been well received by all the attendees. The success of this conference is evident in the active participation of more than 700 delegates. The engaging discussions and the valuable insights shared. The conference also witnessed the launch of several new initiatives aimed at enhancing legal aid services and promoting legal literacy among the masses. The conference provided a platform for us to reflect on our achievements and challenges in the realm of legal services. It allowed us to identify areas of improvement and devise strategies to overcome existing obstacles. The open dialogue and constructive criticism have paved the way for a more efficient and effective legal system in our region. The conference of the District Legal Service Authority of the Tamil Nadu and Puducherry and the Special Training on the Mediation Act 2023 has indeed set a new benchmark in the legal services domain. Let us continue to work together, learn from each other, and strive towards a more accessible, efficient, and just legal system for all. Your Lordship, I would like to apprise you one thing, which I also said in the morning, that the High Court of Madras is the place where the first mediation in the country took place. This mediation center was established in the year 2004, and since then it is going strong. This center was also visited by the erstwhile President Dr. APJ Abdul Kalam, and we have preserved that room as a souvenir forever. I am aware you all must have undergone through a long day. I would not like to trouble you more. You are all eager to hear our chief guest. So thank you very much. Mikai Nandri.
Thank you, my lord.
We extend a warm welcome to Honorable Thiru Justice Bhushan Ramakrishna Gabai, Judge, Supreme Court of India, and also Chairman of Supreme Court Legal Services Committee, for having graced this moment for opening 17 mediation sub-centers at Taluk level across the state. His Lordship will now inaugurate the sub-centers remotely. Please, my Lord. Thank you, Lordship.
We will now watch a brief audio-video presentation on the sub-centers just inaugurated. Now we invite Honorable Thiru Justice Bhushan Ramakrishna Gabai, Judge, Supreme Court of India, to deliver the valedictory address. Please, my Lord.
Honorable Justice Sanjay Gangapurwala, Chief Justice of High Court of Madras, Honorable Justice R. Mahadevan, the Judge Madras High Court and Executive Chairman of Tamil Nadu Legal Services Authorities and Tamil Nadu Mediation and Conciliation Center, Honorable Justice D. Krishna Kumar, Judge Madras High Court and Chairman of Union Territory of Pondicherry Legal Services Authority, Justice S.S. Sundar, Judge Madras High Court and Chairman of High Court Legal Services Committee, and committee members of the Tamil Nadu State Legal Services Authority, Tamil Nadu Mediation and Conciliation Center, Union Territory of Pondicherry Legal Services Authority, and High Court Legal Services Committee. My esteemed brothers and sisters from the Madras High Court, all the learned senior advocates present here, the members of judicial fraternity from the state of Tamil Nadu, the mediators, the registry of the High Court, the Registrar General and the other registrars of the High Court, and friends. At the outset, I express my gratefulness to all of you for having given me an opportunity to be with you on this August evening for the valedictory of the Conference of District Legal Services Authorities of Tamil Nadu and Pondicherry and special training on mediation. I am also pleased to inaugurate the 17 mediation sub-centers established at various taluka levels. I think it now takes the figure to 37, and I am sure that the establishment of large number of the mediation sub-centers will go a long way in promoting the mediation movement so that the disputes between the parties are resolved at the earliest. I also have an added pleasure to be here since the Honorable Chief Justice of Madras High Court happens to be from my High Court. Both of us had an occasion to work together at Aurangabad for a long time, and I also had a pleasure of sitting with him as a bench partner for almost 10 months, and we were assigned with the final hearing matters. Old final hearing, there was a lot of cases that piled up, and we had reached the target of around 1,000 cases that time. So we got an extra week, and he said that taking advantage of that extra week, we should take the figure to 1,100. Fortunately, we could reach that also. He's a keen sportsman, and as a matter of fact, he had also coached me in tennis. I started tennis quite at a late age, but he's a sportsman. He represented the Aurangabad University in the tennis tournaments. He is one of the most affable and lovable judges that the Bombay High Court had, and I am sure that all of you would agree with me on that. Mediation in India traces back to a long history where disputing parties attempted to find a mutually acceptable solution to their conflict, assisted or supervised by a neutral third party. All of us are aware about the panchayats in our villages. As a matter of fact, panchayats would be nothing else but a part of mediation. However, in the legal framework, mediation has been ingrained in the provisions of several statutes, namely the Code of Civil Procedure of 1908, the Arbitration and Conciliation Act 1996, the Companies Act 2013, the Commercial Courts Act 2015, and the Consumer Protection Act of 2019. However, we did not have any specific legislation that dealt with mediation until 2023. Despite there being various provisions, there was no clear structure and practice in mediation, especially private mediation. The lack of coherent framework discouraged the participation of parties from opting for mediation and created doubts about legal recognition of the process. The intervening events of the signing of the United Nations Convention of International Settlement Agreement resulting from Mediation 2019, also called the Singapore Convention on Mediation, on August 7, 2019, gave impetus to standardizing cost and time-effective mediation. India was one of the founding signatory members of the Singapore Convention on Mediation. Even though India has yet to ratify the convention, it enacted the Mediation Act 2023, thereby marking a significant approach to developing the legal framework for mediation in India. The new enactment of 2023 aims to encourage and streamline the process of mediation, mainly promoting institutional mediation for resolving disputes, whether commercial or non-commercial, enforcing mediated settlement agreements, providing a body for the registration of mediators, encouraging community mediation, and making online mediation as an acceptable and cost-effective process. In line with requirement of the state under the Singapore Convention to specify rules of conduct for mediation and standards for mediation, the Act lays down provisions clarifying appointment and qualifications, experience and accreditation of mediators, disclosure requirements to be made by the mediator, principles that guide mediators' behavior to conduct mediation, role of mediator, and essentially time limit for the whole exercise. In a case where there is a misconduct by a mediator or a conflict of interest of parties with the mediator, his mandate may be terminated, similar to its anticipation in the Singapore Convention. Furthermore, to remove doubts regarding the issues relating to subject matters that can be mediated, Section 6, read with the first schedule of the Act, gives an illustrative list of the disputes that are not amenable to mediation. Some of these matters include allegations of serious and specific fraud, fabrication of documents, forgery, impersonation, coercion, prosecution for criminal offences, matters which are prohibited being in conflict with public policy or is opposed to basic notions of morality or justice, or under any law for the time being in force, and more. It is worth discussing certain key features of the Mediation Act that add value, convenience, and meaning to the mediation process. One of the prominent provisions of the Act is the recognition and enforcement of mediated settlement agreements. As a result of the mediation process, some or all the parties agree in writing, settling some or all of the disputes. Thereby, the mediator authenticates the agreement, and in the case of institutional mediation, a copy is also passed on to the mediation service provider. The relevancy of the process is further cemented by the requirement of the registration of the agreement either by the parties or the mediation service provider within 180 days. Notably, once signed by the involved parties and authenticated by the mediator, a mediated settlement agreement will be considered final and binding on all the parties. Parties or persons claiming under them can seek enforcement under the same procedures outlined in the Civil Procedure Code as if the settlement agreement were a court-issued judgment or decree. Therefore, any party or person claiming through them may use the settlement agreement in defense, set-off, or other means in any legal proceedings. The defenses against enforcement of the settlement agreement are dealt with in the Act, similarly in substance to the Singapore Convention, though different in structure. For instance, the ground of contractual obligation is squarely covered in explanation to the provision explaining mediated settlement agreements. That is, a mediated settlement agreement which is void under the Indian Contract Act 1872 shall not be deemed to be a lawful settlement agreement within the meaning of mediated settlement agreement. In addition to the ground of non-mediatable disputes, mediated settlement agreements can be challenged on the other grounds of fraud, corruption, or impersonation. Another vital feature of the Act is facilitating institutional mediation, which means mediation conducted under the aegis of mediation service provider. With the increasing complexity of disputes arising in diverse sectors such as business, labor, and public administration, institutional mediation offers a structured and effective approach to resolving conflicts. The Act validates who can be mediation service provider, including a body or an organization recognized by the Mediation Council of India for the conduct of mediation. An authority constituted under the Legal Services Authority Act of 1987, a court-annexed mediation center, and any other body as may be notified by the central government. The statute lays down the functions of the mediation service providers, including accrediting and maintaining a panel of mediators, providing all facilities, secretarial assistance, and infrastructure for the efficient conduct of mediation, promoting professional and ethical conduct amongst mediators, facilitating registration of mediated settlement agreements, among others. The Act takes conscious lessons from the aftermath of the COVID-19 pandemic, which shed light on the necessity of an affordable, convenient, and prompt dispute resolution mechanism that accentuates the need to use technology in resolving disputes. The Supreme Court is actively insisting on infusing information technology into the modern justice system and is also framing policies and guidelines in this direction. As early as 2003, the Supreme Court in Grid Corporation of Orissa Limited and AS Corporation observed the usage of electronic media, and I quote, when an effective consultation can be achieved by resort to electronic media and remote conferencing, it is not necessary that the two persons required to act as in consultation with each other must necessarily sit together at one place unless it is the requirement of the law or of the ruling contract between the parties. Moreover, the legal jurisprudence on online dispute resolution processes also stems from the decisions of the Supreme Court upholding the validity of online arbitration in Shaktibhog versus Kola Shipping Limited and Tramex International versus Vedanta Aluminium Limited, wherein it was held that the process must conform with the compliances for electronic process, records and evidences under the Information Technology Act 2000 and the Indian Evidence Act 1872. Additionally, there have been efforts from the government to give impetus to online mediation. The Ministry of Consumer Affairs, Government of India, recognized the potential of online mediation in resolving consumer disputes and sanctioned an initiative of the National Law School of India University, Bangalore, to establish the online consumer mediation center. The recent initiative of Niti Aayog to design the online dispute resolution policy plan boosted the adoption of online mediation. In this regard, Section 30 of the Act recognizes and specifies the conduct of online mediation. The use of digital technology and techniques facilitates the mediation process and makes it more convenient for the parties or the mediator situated far off, naturally saving time and money. Herein, the mediator has to play a crucial role in ensuring the integrity of the proceedings and confidentiality of online communication at all times. Besides, within the Mediation Act, territorial jurisdiction to undertake mediation is expanded to encompass online mediation, and similar recognition is given to settlement agreements resulting from online mediation. Let me also deal with the community mediation, which encompasses collaborative dialogal method for resolving conflict amongst individuals, groups, and organizations. The aim is to promote social harmony and devise their own solutions, steering away from the lengthy legal battles. Section 43 of the Mediation Act recognizes community mediation. It explains the adoption of the mediation process in case of disputes likely to affect peace, harmony, and tranquility amongst the residents or families of any area or locality with prior mutual consent of the parties to the dispute. Trained community mediators facilitate challenging discussions to ensure a safe space for parties to voice their needs while maintaining their autonomy in decision making. To initiate the process, the parties must apply, preferably before the appropriate legal service authority, or where none, before the district magistrate or the sub-divisional magistrate. The provision clarifies the strength of the panel of mediators and their eligibility criteria while ensuring adequate representation. Unlike mediation in other matters, a settlement agreement arrived at through community mediation shall not be enforceable as a judgment or decree of a civil court. Its purpose is only limited to maintaining peace, harmony, tranquility among the residents or families of any area or locality. The Act applies to international mediation as well. It makes reservations regarding disputes where the central government or the state government or agencies, public bodies, corporations and local bodies, including entities controlled or owned by such government, is one of the parties. However, in commercial disputes, the government party has the liberty to opt in for mediation. The Act lays down the requirement of premeditated mediation agreement in case of international commercial disputes. But such a settlement agreement can be conclusively made only with the prior written consent of the competent authority of such government or any of its entity or agencies, public bodies, corporations and local bodies as the case may be. In conclusion, it can be said that the new legislation is a commendable step to streamline the mediation process and ensure that the result of the mediation exercise is not futile. The recognition and regulation of mediation service providers in the statute is a significant step in developing the culture of institutional mediation, similar to how we are progressing with the institutional arbitrations in India. Further, the opening of mediation sub-centers in the state ensures the necessary infrastructure and facilities to promote and inculcate the practice of mediation as a primary choice in dispute resolution. I would like to end this speech with the words of Joseph Graberman, a renowned American mediator. He said, and I quote, "An ounce of mediation is worth a pound of arbitration and a ton of litigation," unquote. I firmly believe that many cases ending in the litigation cycle can be resolved with proper dialogue in an amicable and neutral settlement, and the current legislation will effectively pave the way for such resolution. My personal experience also tells me that even as a judges, we can use the tools of mediation. When I was in Bombay, I have resolved many family disputes, matrimonial disputes. There was a dispute between a father and one son on one hand and another son on the other hand in a very big industrial house. But 2 or 3 sittings after court hours resolved the dispute and they walked out of my chamber happily. And therefore, when you use mediation and resolve the disputes without the lengthy wait, the happiness that the judicial officers and the mediators will get is worth millions happinesses that one will get. Thank you very much. I won't stand here long because you have been sitting here from 9 a.m. and thank you very much.
Thank you, Lordship.
In recognition of the excellent comparing of the 2 judicial officers, Mrs. Anita Anand, 17th Metropolitan Magistrate, Saidapet, and Mrs. D. Shobha Devi, Registrar, Court of Small Causes, Chennai, I request Mr. S. Ganapathy Sami, Registrar, IT cum Statistics, to honor them with a sapling. Thank you, sir. We now request Honorable Thiru Justice S.S. Sundar, Judge of Madras High Court and Chairman of High Court Legal Services Committee, to propose the vote of thanks.
The Chief Guest, Honorable Justice Bhushan Ramakrishna Gavai, Judge Supreme Court of India, Honorable Justice Sanjay V. Gangapurwala, Chief Justice Madras High Court, the Patron Chief of Tamil Nadu State Legal Services Authority and Mediation Conciliation Center, Honorable Justice R. Mahadevan, Executive Chairman, Tamil Nadu State Legal Services Authority, Honorable Mr. Justice D. Krishna Kumar, Executive Chairman, Union Territory of Pondicherry Legal Services Authority, Honorable brother and sister judges, members of judicial fraternity, mediators, senior advocates, law officers, ladies and gentlemen. Good evening to every one of you. Thank you is such a prayer that cannot be seen or touched. It must be felt by heart. Today, I have the honor and privilege to propose a vote of thanks on this very important occasion with all my heart and soul. I would like to thank all the honorable delegates who blessed us with their presence and gave their invaluable thoughts to drive the occasion to be a great success. I'm sure that with the culmination of today's events, all of us are energized and our minds are buzzing with opportunities provided by the institution that is mediation. I, on behalf of the organizing committee, convey deep regards and hearty thanks to Honorable Mr. Justice Sanjay V. Khanna and Honorable Mr. Justice B.R. Gawai, Honorable Judges of Supreme Court of India, who allocated their precious time to such an event and provided their great insights in the field of mediation with aplomb. I sincerely thank Honorable Mr. Justice Sanjay Khanna for delivering the inaugural address and not only showed his great affinity towards the institution of mediation, but also gave an intuitive perspective to the field of all younger generations to cherish and follow. His participation in the interacting session with the chairman and the secretary of District Legal Services Authority was so impressive and motivating. I am also extremely grateful to have witnessed the opening of mediation sub-centers in the state of Tamil Nadu by Honorable Mr. Justice B.R. Gawai, to have heard his valedictory address in which his lordship has succinctly analyzed the various aspects surrounding the practice of mediation. I thank our Honorable Chief, our captain, in every sense of the word, the ever valuable and practical inputs and advice offered by our Chief, Honorable Mr. Justice Sanjay V. Kangapurwala, makes all our lives that much simpler, and his patronage towards the institution of mediation and legal services institution has elevated its prestige several notches up. I also thank our Honorable Mr. Justice R. Mahadevan and Honorable Mr. Justice D. Krishna Kumar for being the two huge pillars of support in the present cause and also for the smooth functioning of this August event. I congratulate my brother judges who have contributed much for the successful completion of this remarkable event as members of various committees. I would be remiss if I do not take the opportunity to thank every one of my honorable brothers and sisters who have graced this occasion and whose collective presence has enlivened and elevated the scope and grandeur of the occasion. I am also very much thankful to all those who ideated, arranged, advised, and worked to convene such an erudite gathering for today's event. Words are not enough to thank their hard work to shape the conference. I feel proud and thank you for making this event a successful one. An event of this dimension cannot happen overnight. The wheels start rolling weeks in advance. It requires meticulous planning and a bird's eye for details. We have been fortunate enough to be backed by a team of very motivated and dedicated brother and sister judges and members of Tamil Nadu and Pondicherry Legal Services Authority and Tamil Nadu Mediation and Conciliation Center of Honorable High Court of Judicature at Madras, the members of High Court Legal Services Committee, and everyone else who have put in their hard work to make this occasion a stupendous success. I cannot thank everyone enough for the passion and involvement they have shown and the willingness they have expressed to take on the completion of tasks above and beyond their call of duty. The profound thanks to Registrar, officers of District Judiciary, staff members of High Court and district level for their active participation. I also extend my sincere thanks to the team of PW officials, print and electronic media, each and every one who have contributed making this event a glorious one. I once again thank one and all for patiently listening to this not so brief vote of thanks at its length benefits the sincerity of my gratitude towards all of you. If time is money, then whoever has gathered here today have spent millions, and I sincerely believe that it is not an expense but an investment for a bright future. Thank you all.
Thank you, my lord.
May we all now rise for national anthem.